implemented revolutionary reforms, but these initiatives have mostly been sporadic as islands of excellence. Indian Police Foundation is an informal platform to connect, amplify, and spread these reforms at the national level. Speaking of reforms, every year on 22nd of September, India observes Police Reforms Day to commemorate a landmark judgment by the Supreme Court of India in the case of Prakash Singh and others versus Union of India in 2006. This judgment issued a set of 7 directives aimed at transforming the police force into a more accountable, transparent, and efficient institution. The directives addressed critical areas such as establishment of State Security Commission, security of tenure for police chiefs, setting up of police establishment boards, transparent police transfers and posting, separation of law and order and investigative policing, establishment of a National Security Commission. Police Reforms Day serves as a reminder of the importance of professional and accountable police force in upholding the rule of law and protecting the rights of citizens. It is a day to reflect on the progress made and recommit to the ongoing journey of police reforms in India. The Indian Penal Code, Code of Criminal Procedure, and Indian Evidence Act have been serving as cornerstones of the legal system since 1860. With a commitment to modernizing its legal framework to address contemporary challenges, a significant stride towards a more just and equitable legal system was taken by the government on 21st of December 2023 by ushering in a new era of criminal laws, which have been implemented since 1st of July 2024. These comprehensive reforms promise to enhance the efficiency and effectiveness of criminal justice system, safeguard the rights of victims and the accused, and deter criminal activity, ultimately contributing to a safer and more secure India. However, any change doesn't come without its fair share of challenges, which brings me to the theme of the event, navigating the new criminal laws and implementation challenges. In order to help us navigate the change, the 2 sessions which will be held later in the day are an excellent example of continuous efforts being made in the direction to achieve the stated goal, mission, vision of Indian Police Foundation. The first session will share multiple perspectives ranging from police, legal professions, academia, and civil society on the new criminal laws. The second session will focus more on the practical aspects in respect of these new criminal laws, which includes early learnings and practical implementation challenges, and what needs to be done for preparing police personnel by focusing on training, forensic tools, and upgrading the physical and digital infrastructure. These sessions will help the audience better appreciate the seminal movement in police reforms marked by this introduction of new criminal laws. And I request all of you to once again put your mobile phones on silent mode and while we wait patiently for the arrival of chief guest. Thank you. Sir. I would like to inform you that the first session is, is expected to be conducted between 11:30 hours to 1:30 p.m. in the afternoon. And the first session is, like I said, is on the perspective on the new criminal laws, which will focus on a balanced debate between the positive aspects of the new laws, the criticisms, and the concern related to these new criminal laws. And the panelist in the first session will be Professor G.S. Vajpayee, who is Vice Chancellor in National Law University, Delhi. Shri K. Ramanujam, who is former DGP of Tamil Nadu. Shri K.P. Singh, former DGP of Haryana. Srimati S. Shani, IPS IGP Training, Odisha. Professor Nuzhat Praveen Khan, Professor Jamia Millia Islamia, former Dean, Faculty of Law. Sri Sanjay Vashisht, Senior Lawyer. And the second session will be conducted, will begin at 2:30 p.m. in the afternoon and will carry on till 4:30 p.m., which is again on the early learnings and practical implementation challenges in respect of these new criminal laws, and which I being in CBI, we also face such challenges in implementing these new criminal laws, especially BNSS. But I believe Shri GP Singh, IPS DGP Assam, Shri Biplab Chaudhary, IPS Joint Director CBI, Santosh Rastogi, IPS Joint Director NIA, Chaya Sharma, IPS Special CP, Delhi Police, Anil Kishore Yadav, IPS IG BPRND, and Director CAPT Bhopal. And of course, Shri DC Jain, former Special Director CBI, will be better placed to guide you in this regard. I can see that some of the lawyers have also joined us, and I believe they also must be very curious and getting the insights regarding the new criminal laws and share their experience in the courtroom with the panel. And I hope a healthy discussion will be taking place in these two sessions today.
the minister is starting, then you can take over.
Sure, sir.
Okay.
Sure, sir.
Shall I?
Yes, sir. Sure.
Good morning, ladies and gentlemen. One announcement, please. Dharam, I'll just make an announcement. The minister, Honorable Shri Arjun Ram Meghwalji, is a bit delayed. So during this period, we will make use of this time. So I will request Vice President IPF, Dr. Ish Kumar, to talk to you about one of the projects that the IPF is doing. Now, I must tell you that the Police Foundation has set up a series of centers of research and learning. And these centers, they are on specific subjects connected with policing. It includes things like internal police reforms, women's safety, gender-sensitive policing, prison reforms, digital transformation of policing, safety of, wellness and well-being of police personnel, which includes physical and mental health of police personnel. So like this, the number of areas where we are trying to generate the specialization. So one of the most important centers is on what is called internal police reforms. Reforms for which we don't have to wait for political clearance. Reforms that are well within the reach of the police. The police leadership, as well as every policeman in the street, could be part of this without having to wait for any other resources or instructions. So that is the concept of internal police reforms. And Dr. Ish Kumar, our Vice President, is leading that project. And we have recently got a grant from the Azim Premji Foundation for running this project. So I will request Dr. Ish Kumar, Vice President, to say a few things about this, to brief the audience before we start the project, before we formally begin the program. As soon as the minister leaves from his house, we will stop this. Okay. Thank you. Thank you for your patience.
Good morning, ladies and gentlemen. Our chairman of the Indian Police Foundation, the vice chairman Indian Police Foundation, and the president Indian Police Foundation. Respected audience, I have been just told 2 minutes back to give an extempore on this particular project. You see, the credit goes to Shri Prakash Singh ji that police reforms has become a buzzword in the policing circles and even in a media circle and maybe political circle, not very sure. At least we have started talking about the need for reforms in the police organization. And this thing, I think that he is the man, he is the person who made this word possible with his stupendous effort of filing that PIL and getting a Supreme Court judgment in 2006. Now, the project which I am leading as a part of Indian Police Foundation, it talks about internal police reforms. That judgment is talking about the institutional reforms, maybe establishment of National Security Commission or State Security Commission or Police Complaints Authority. Those are all the things which only government can do. But there are large number of reforms in the police organization which police department can themselves do, as Shri Ramchandra was saying. And these reforms, if done, They will bring lot of relief to the common man who approaches police station for any kind of a complaint, any kind of a grievance or a citizen service. So these are the set of things we call internal police reforms. The examples would be, you go to a police station, your house, maybe a theft has happened, or maybe you had a fight with your neighbor, or maybe there was an accident, your vehicle got damaged or somebody got injured. You want a case to be registered. And this has been the bane of Indian police for last so many years, that most of the citizens find it very difficult to get a case registered at a police station level. I mean, most of us are aware of the reasons. I need not go into the reasons for that. Similarly, doing a fair investigation. We have been talking of custodial torture, doing away with the custodial torture, doing away with the use of excess force in managing a law and order situation. You need a police verification certificate or a passport verification. Now, these are the simpler things for which a common man would approach a police, and for setting these rights, doing it in a given time frame, in a prompt manner, professional manner, and a friendly manner, doesn't need government approval. Rather, government would be very happy in case we are able to bring in all this into the police department culture and subculture. So this project focuses on broadly these kind of areas. What we are planning is, we have chosen the 4 state DGs who gave consent to be the partners in this project. And at present, these states are Punjab, Chhattisgarh, Telangana, and Tamil Nadu. 2 more states which gave concurrence are Delhi and Rajasthan. But at present, the mandate was to do in the 4 states. We are doing in the 4. So what we are basically doing is, in the first research phase, we are holding public consultation meetings in these 4 states. We'll be talking to the complainants, we'll be talking to the victims, we'll be talking to the service seekers, we'll be even talking to the academia, lawyers, the judicial officers, and try to find out which are the main public pain points in their interface with the police. Broadly, we know it, but we want to get into the nuances of each and every smaller thing which pinches. 70 to 80% could be common, 15 to 20% things could vary from state to state. Like Punjab has a border state, lot of drug issues could be there and related things. Tamil Nadu has a coast, there could be coastal issues there. So once we do these consultation meetings, we will list out the focus areas we need to look at. Once these focus areas we need to look at, then we will do an internal exercise. We'll invite all state police forces to make presentations on the best practices in some of these things. Like one clear-cut example is EFIR. Now, EFIR so popular in Delhi since 2013. Most of the other states have not picked it up. Maybe few exceptions here and there, UP, Rajasthan, or West Bengal, but that too in a very minor way. Delhi has taken it in a huge manner. So like this, we will try to find out best practices nationally as well as internationally. Sometimes individual police officers, they undertake some experiments. Experiments give good results but don't sustain because of the predecessor-successor syndrome in the police department. So we will take this. We will also look into the previous commissions and committees' recommendations if there is anything relevant to these issues. And then we have an expert committee consisting of senior police officers, both serving and retired, as well as some academicians and researchers. We will discuss these recommendations with them, and when we will try to come out with what could be the possible solutions to the various issues a common man faces. We will try to pin down those solutions, 1, 2, 3, 4. We'll go to the states and tell the DG, look, this is what we have come out with. Suppose we come out with 4 solutions to a problem, DG may agree with 2 or 3. ये 2 or 3 हम करके देखते हैं. So we are selecting 15 police stations in 2 districts in that particular state, and we will try to implement these revised SOPs or the revised solutions for a particular period around 6 months. We have a then monitoring and feedback mechanism. We are appointing state monitoring units. There is a retired police officer who will be state supervisor. There is a state nodal officer. He would be visiting these police stations every month and seek whether these practices are being implemented or there are any field issues. Based on this feedback, we'll tweak the recommendations and again run a main pilot in which we will increase the number of police stations to around 30 per state. So total 120 police stations, which will be a mix of urban, rural, metro. We'll try to do this particular exercise. At the end of the exercise, those practices which sustain, give good results, state police is happy. We will request DGs to scale it up to all the police stations in that state. Like DGP Punjab, when I met, he said, sir, आप तो 30 में करेंगे, मेरा उससे क्या होगा? मेरे पास तो 500 थाने हैं. The real result would only come if I am able to implement that in all the 500. So we will like to scale it up. We would also request them to revise, if required, police manuals or police standing orders, the respectively where are they are. We'll hold an all India conference with the help of MHA and BPRND and request other states as well. Okay, look, this is what we have done in these 4 states. This has worked. Why don't you take it up in your states also and try to implement? So this is in brief nutshell the internal police reform project which we are planning. It has already started this May and it will be there for 3 years. So I think that's all from my side. In case there are any questions, I don't know what's the time, but I am here to answer. Yeah, yes, ma'am. Yes, ma'am.
Involve BPRND on a big scale.
Ma'am, we'll try. I'm in touch with Mr. Rajiv Sharma. Actually, for that experts meeting also, I had invited him. He had sent his rep there. We'll definitely do that, ma'am. Actually, earlier IPF had a MOU with BPRD for 3 years for standardization of the various police services. But that MOU, that time COVID came, there was not much of a progress, and MOU was not extended. So maybe we'll rework at that, ma'am. Thank you. So thank you very much.
Ladies and gentlemen, I think there is a little bit of a delay in the minister's expected time of arrival. He has promised to reach by 10:45. So we need to keep the conversation going. So the main burden of discussions today, as you all know, is the new criminal laws. And we have a number of experts on the subject here. And during the planned, programs of the panel discussions, there may not be sufficient time for our panelists, esteemed panelists, to do full justice. So I will request a couple of them to speak about the new criminal laws during this intervening time, which will be useful for everyone present here. I would first request Dr. K.P. Singh, former DGP of Haryana, to say a few words to begin with. Thank you, K.P.
Thank you, sir. Good morning, ladies and gentlemen. I'll give you the brief background of the enactment of these laws. As we all know, we were following the IPC, CRPC, and Independence Act, which were primarily designed and enacted by the British to meet the requirement of a nation which they were ruling. The laws which were there were for the state, and this is evident basically from a single fact that the first chapter in the IPC, which we read, is offenses against the state. It shows the priority of the government or priority of that ruling dispensation What was in their mind when they were giving those laws to us? Whereas in a democratic state, people have aspirations, government have their policies. In a welfare state, so many other types of priorities are there for the lawmakers. Although something was done here and there, but a substantial change was required. And with this need, the government constituted a committee consisting of some law professors, retired high court judges, senior police officers, professors of law, and gave them the mandate that you read line by line all the provisions and come out with a draft laws, draft recommendations and laws. The committee worked for 2 years, from 2020 to 2022, and submitted their report. The recommendations were again given to a smaller committee for further detailed consideration and discussions. The committee further discussed about them for about a year and suggested some change and came out with draft 3 legislations, which were introduced in the Parliament on 11th of August 2023. The same day, these bills were referred to the Parliamentary Committee of Ministry of Home Affairs for further discussions. So the committee of the Parliament further discussed and made their recommendations to the chairman Rajya Sabha on 10th of November 2023. After considering those recommendations, those 3 bills which were introduced in the August 2023 were withdrawn from the Parliament. And based on these recommendations by the Parliamentary Committee and other things which have come into the domain of the enactment, fresh 3 draft bill were introduced in the Parliament on 11th of December 2023. On 20th of December and 21st of December, these 3 laws were passed by the respective houses. And the President gave its assent on 25th of November 2023. These laws were notified on 25th December 2025. They came into operation on 25th of December 2025. But they did not come into force, because there was a clause that these laws will come into force on the day to be notified by the central government at a subsequent date. What was the reason? The law came into operation of 25th of December 2023, but did not come into force immediately. Reason was a lot of requirement were there to implement these laws. Some infrastructure was to be created, some training was to be imparted to the policemen, to the judiciary, to other stakeholders. So it takes time. Some rules were to be framed, some delegated legislations were to be in order. So this time gap was given. Ultimately, government notified the date as 1st of June 2024. And this July, sorry. And this law came into force on 1st of July 2024. But there was a saving clause in all these 3 laws, that these laws will come into operation prospectively, not retrospectively. As we all know, penal law can be only prospective, not retrospective. Otherwise, it will be hit by Article 20, subclause 3 of the Constitution of India. Procedural law can be prospective as well as retrospective. But in this case, they said that it will also be retrospective, because procedural law, whether it will be retrospective or prospective, is determined by the rule of fairness. Rule of fairness means if by applying retrospectively the procedural law, you are hitting a person on wrong side, his rights are curtailed, then it cannot be retrospective, it has to be prospective. Therefore, it was declared in the saving clause in all these laws that these laws will come into operation prospectively and not retrospectively. And all pending proceedings before 1st of July 2024, whether it is appeal, investigation, revision, review, whatever, it will be decided as per the old law. And everything which happened after 1st of July 2024, it will be held, it will be done as per the new laws. All the 3 laws were tweaked and were changed, but let me give you gist that the IPC was basically driven by the judge-made law. There were several judgments from the Supreme Court on different issues. So many sections were declared unconstitutional and they were removed from the statute book. So it was to accommodate those laws which were made by the Supreme Court into the statute, into the rule book. Another aspect which was there in IPC was section 48, which criminalized offense. If a person sitting outside India abet an offense in India, and that offense is committed in India, that person can be prosecuted here. Extra-jurisdictional territorial jurisdiction. And it is in the context of national security, let me tell you, those anti-social element and anti-national element which are sitting outside India, in Canada, in US, in UK, we can register an FIR here now. We can conduct their trial in absentia as per section 356 under the new provisions. They can be convicted after following the trial. They will be attached with the tag of conviction. And when they will go to the foreign countries for asylum, the tag of conviction will be attached there. We have a solid point that he is a convict of law. He has been tried by a court of law. He has been convicted. He cannot claim that he is politically persecuted. So he should not be given asylum. This is the biggest advantage for national security. Another aspect which are there in BNS new law which replaced IPC are basically those which are concerning the Supreme Court judgment and which have been incorporated there. People often criticize that you have changed the numbering. You have disturbed the arrangement or sequence of offenses. But that was desirable. That was not by any design, but that was required. And the reason was that we have changed the sequence of the offenses in the IPC to show where our commitment lies. Now, our first chapter in the IPC or in the BNS is crime against women and children. This shows that in a democratic country like India, the first priority which the government put is on crime against women and children. So if you shift a chapter from back position to front position, it was inevitable that the numbering will change. Certainly, there were several other drafting mistakes in the IPC. In one chapter, in one section, you will have definition. In another chapter, in another section, you will have punishment and so many other things. They all have been consolidated. And you all know that there were about 551 sections in the IPC. And now the new law, there are only 358 sections, reduced, consolidated. And policemen have already adopted it. The major challenge was that how policemen will imbibe these new sections. They have already imbibed it and they are using it for the last 2-3 days without any hitch, without any problem. About BNSS, I will again say, people are criticizing that it is pro-police. I will say it is not pro-police. It is anti-heinous offenders. The petty offenders, they will get all the benefits in terms of community service, in terms of no arrest in petty offenses, etc., etc. There are several positions, the panelist will tell you. But the only change which we find, or the gist which we find in the BNSS is that the hardened criminal law has been made tough for them, which was the requirement of the society at this stage, at this juncture. Another aspect which we normally forget, and we policemen, and even in the lawyers, there are certain other areas which we do not even turn the pages to read. For example, commutation of sentence. The executive government were having power even to convert death penalty into fine by way of commutation. Even life imprisonment person can be set free after asking him to pay fine. So certain provisions were there which require certain tweaking, certain remodeling. About jail administration, it is a forgotten entity in our criminal justice system. New system has been devised whereby jail administration has been given a new role. In 4 or 5 sections, The jail superintendent has been made stakeholder, and they have been given certain directions, certain rights to present themselves in criminal justice system. There are several other issues. Disposal of case property. We all have seen the police malkhana, what happens to them. A new concept has been made that as soon as a case property is produced before a judge, he will videograph it, he will get it photographed, he will make an inventory made and place it on the record of the file, and that will be the primary evidence during the course of the trial. And mandate is there that after that, within 30 days, the court have to pass an order for disposal of that case property so that it is not wasted in the police malkhana. Mercy petitions. We all have seen what happens to mercy petitions. One mercy petition after another legal things after another legal things. A streamlined procedure has been embedded in the new CRPC about mercy petitions. How it will be held, how it will be done, what is the time limit, so that the advantage which the criminals are getting, that one mercy petition, one criminal or one convict will file. It takes 2, 3 or 4 or 5 years to decide. After that, another co-convict, he will file. It will take 3, 4, 5 years. After that, the third will file. It will take 10, 15 years. And there is a judicial bar that unless and until petition of a convict is pending, his co-convict cannot be prosecuted, cannot be executed, or cannot be hanged. It results into delay. And there was a judgment of the Supreme Court in 2014, Shatrughan Chauhan versus Union of India, in which the Supreme Court said, if there is delay in execution of the death penalty, it should be converted into life imprisonment. So the convicts, death row convicts, they were getting advantage of these provisions. Now a detailed procedure with time limits have been prescribed. Several other new changes have been incorporated. The panelists will discuss. In the Evidence Act, basically, electronic evidence have been embedded into the scheme. The definition of primary evidence, secondary evidence have been changed. The certification which is required to make an electronic evidence admissible in the court of law, it has been changed. But that is something problematic area in which even the expert, they are not having one opinion. A lot of churning is required so that we could give a correct system of certification, because there is a lot of scope for manipulating those evidences. We all know, and most of the things we don't even know what is happening. What happened in Lebanon and all others, we all know how it can be manipulated and how it can be changed. We have to take care of that. So these are basically those things which I thought I should give as an introduction, because otherwise the panelists will discuss in detail what are those detailed provisions. Thank you very much, sir, for giving me the opportunity.
Thank you, Dr. K.P. Singh. In fact, these discussions are going to be very useful. In fact, in the it may be even more elaborate than the upcoming panel discussions. So I will now request Mr. Dharamchand Jain, former Special Director of CBI, who is also the present Chief Operating Officer of Indian Police Foundation, to speak on the new criminal laws. He will be the moderator for the coming panel discussions, but it will be useful to listen to him about what are the salient features of the new criminal laws, what are the strengths, what are the concerns, and what is it that we can do by codifying or compiling our suggestions, which can be brought to the notice of the authorities that be. Thank you. Over to Dr. Dharamchand Jain.
Thank you so much, sir. Thank you. KP Singh sir has already given a good outline of the new criminal laws, the background, the history, and how long it took, and what all kind of deliberations took place before the new criminal laws were enacted by the parliament. So, as is the theme of the day, that navigating the new criminal laws and implementation challenges. Basically, as we all know, our criminal justice system is run by three kind of criminal laws: penal law, procedural law, and the evidentiary law. We all know what is penal law. Penal law is the one which defines which acts make an offense, and it also prescribes penalties for the same punishments. Earlier it was IPC, and now it has been replaced by Bharatiya Nyaya Sanhita. Then we have this procedural law, and procedural law is the one, from the practitioner's point of view, from the citizen's point of view, I think it is the procedural law which holds the place of primary importance. Because as a citizen, suppose if you are a victim of a crime, then how do you report, where to report, what are the rights of a victim, what are the duties and responsibilities of the police when they receive information about crime, what are the powers of the investigating officers, what it can do, what it can't do, what are the powers or rights of the arrested person in case arrest happens, then what will happen in the courts, appeals, trials. All these things are governed by the provisions given in the procedural law. The earlier procedural law was the Criminal Procedure Code. That has now been replaced by the new procedural code that is known as Bharatiya Nagarik Suraksha Sanhita. So from the practitioner's point of view, as I see, it is this procedural law, I think, which is the most important thing, because even as a common citizen, I must know what are my rights, what I need to do, where I can go, how I can report a crime. All those things are given in the procedural law. Then, of course, we have the third is this evidentiary law. And what is evidentiary law? Basically, it tells you about the admissibility of the evidences, basically what all types of evidences are collected during investigation or inquiries, what will be admissible, what will not be admissible, when these evidences will be presented in the court of law. So it is not easy for any country, as we can appreciate, to change all the three laws. So in a way, we can say that this country has made a history in the month of December 23, when all these three new criminal measure laws were changed. Now, from the citizen's perspective, basically from the common man's perspective, what are the positive things in the new criminal laws? Particularly the BNSS, as I said, these laws are stated to be victim friendly. Now, when we say victim friendly or victim centric, the primary emphasis is that the victim should have an easy access to the justice system. Right, because the first and foremost, as Harish Kumar sir was also mentioning, I think even today it is not so easy. I mean, the common man of the country is not very confident that if he or she will become victim of a crime, whether his report will be entertained in the police station or not, whether the FIR will be registered in the police station or not. So, in order to, I think, address these concerns, then there are certain provisions which have been made in the new criminal laws, I think, which all of us need to know. One is, one of the biggest complaint of a common man is that when he or she approaches a police station, generally they refuse to entertain the information on the ground that this particular crime has not happened in my jurisdiction. So you have to go to the police station where this incident has happened, and many a times the poor person doesn't even know in which police station this particular crime has happened. The problem, I think, is more compounded in cities, because in a particular city, like in a place like Delhi, where there are more than, say, 100 police stations, a common man is not supposed to know which crime in which police station. So this concern has been addressed. Now the new law says that the police station where the victim reports the crime, it is this police station which will have to compulsorily, mandatorily register the crime. They will not be able to they will not be able to refuse on the ground that the crime has not happened in my jurisdiction. So now it is for this police station where the information has been received that they will decide that which police station we have to transfer this FIR for registration and further action. So I think a big worry of the complainant or the victim has been taken away by making this provision what we popularly call as zero FIR, registration of zero FIR. Then one more important change that has been made in the new criminal law is that earlier, as per the scheme of things in section 154 of CRPC, the informant or the victim has to personally visit the police station for lodging the FIR. Now they say those who are familiar with the technology and in this era where when everyone has these smartphones with a lot of data connectivity, you don't have to visit the police station for lodging your FIR. It can be lodged by, the information can be sent by electronic communication also. And we can imagine how good it is going to be, particularly for those who are elderly citizens, those who are women, those who are children. So there is no requirement of now physically visiting the police station for the purpose of getting your information registered. So I think this is also a very important development that has happened. Another thing is, and again, because these are the issues relating to the habits and cultures also, the way our police forces function in this country. If I am the victim or I am the informant, I think I'm interested in knowing what happened to my complaint. What is the progress of investigation? And as we know, police generally, the culture is कि हम पूछते हैं, हम बताते नहीं हैं. Isn't it? You understand? We only seek information, we don't provide information. So I think this particular concern of the complainants has also been addressed. Now it is a legal right of the victim or the informant to know the progress of investigation. Necessary provisions have been made in BNSS. So that is also a very important change that has been made. Then many of you would know there is a provision in the law that the state has the right to withdraw any criminal case from prosecution. What is the meaning of this? That after the charge sheet has been filed, if one fine day the state government or the central government, as the case may be, if they decide that no, will not carry prosecution of this case, we will withdraw. They may withdraw, they have the powers. Imagine from the point of view of the victim. The victim feels cheated because victim doesn't even know that the state decided to withdraw from the prosecution. In the new criminal law, now they say the state application of the prosecution filed on behalf of the state, the court shall not allow such application unless the victim is given an opportunity of being heard. So the victim will first be heard before such an, I may say, one of the salient features of the new criminal laws is there is so much emphasis on the use of technology. They want the courts, the investigators to use technology. For example, suppose if the police wants to record your statement, now the new law says you don't have to call a person physically to the police station for recording his or her statement. They are promoting that by audio video means electronic communication, please record. Same thing applies now to the trials also. So they say, like if I have to go to the court as a witness, I don't have to go physically now to the court. Of course, states will have to set up these designated centers with the state-of-art facilities. Only then these changes will become more effective. But the provision has been made in the new laws that practically now most of the things which happen in the trial courts that can be completed by audio-video conferences, video conferencing as we popularly call. Then timelines have been prescribed. There are 35, like in the BNSS, there are at 35 places they've given timelines for completing a specific task. For example, if I may say, those of you, because I can see many law students over here, when trial happens, you see you may have heard, first the thing is that the police report or the charge sheet or the documents, a copy is supplied to the accused. Then the accused has a right to kind of, accept or deny the documents, and thereafter the accused has a right to file what we call as discharge applications. Now, what is the meaning of this? The meaning is that after having looked at the evidence presented by the police, the victim may say, there is no evidence against me. Why should I face the trial? So I am entitled to be discharged at this stage. So they are entitled to file what we call as discharge applications. Now in practice, what happens in a case where there are multiple accused, maybe say more than 10, so each person will file a discharge application one after the other. And if the application is not decided in favor of the accused, then that person will file a revision petition. The record of the trial court will go to the revisional court. As a result, we have seen cases in CBI where years have taken by the courts in deciding these discharge applications. Means your trial has not even begun and years have passed. Even the charges have not been framed against the accused. So in the new law, for example, they say, once you have been supplied with the documents, you have accepted the same, you have a period of 60 days. So within 60 days, if you want to file discharge application, you can file. But after 60 days, the discharge application will not be entertained. I think if you ask me, this is one timeline which will change the way trials have been happening in this country. Similarly, for each thing, there are different timelines. And one more thing, many of you who you might have seen this film Betab of Sunny Deol, where he makes this famous dialogue that in Indian courts, केवल तारीख पे तारीख मिलती है, justice नहीं होता, केवल तारीख पे तारीख मिलती है, तारीख पे तारीख, तारीख पे तारीख. So I think the new criminal laws have taken care of that. They say now the court shall not be able to give more than 2 adjournments. 2 से ज़्यादा तारीख नहीं मिलेगी on the request of either party. So idea is to expedite the trials. And there is so much emphasis, like the way the evidences of the experts, medical jurists, forensic scientists. If you ask like those who are forensic scientists or medical experts, if you ask them, why do they delay in examining the exhibits and providing us expert reports? One of the primary reasons is most of the time they are in courts attending evidences in the previous, I think, reports which they have provided. So now in the new law, they say, first of all, why should they have to go? Unless the report is disputed, they should not be called for evidence in the court. Secondly, in case there is a necessity, and if the person who was an expert, if he is transferred, is retired, he is not available for any reason, then you should take the evidence from the successor, means the person who has been occupying that seat at that place. And also, again, don't call that person physically, call that person, examine that person by the video conferencing. So if examination of these witnesses start happening by video conferencing, obviously a lot of time of the court will be saved. I think a lot of inconveniences the witnesses are put to. We know in many times the witness travel far distances, they reach the court, and the poor people are told, today your evidence will not happen. We'll let you know when you have to come next. So I think those kind of issues will be tackled. Then these are certain things about the BNSS I wanted to say. Not only here, but even in, the Bharatiya Nyaya Sanhita, which has replaced the penal law, you must have by now come to know, they have added certain new offenses. So, if I may say, organized crime. So in IPC, there was no such crime. And in certain states, of course, they have special laws, like in Maharashtra, a very popular law we know as what is known as Makoka in Maharashtra. Similarly, on the same lines, we have one special law in Gujarat. But in most of these states, we do not have a law to deal with this organized crime. You may have heard of these gangs like Lawrence Vishnoi gangs. They have been playing havoc, and I think they do indulge in a lot of these extortion activities. So in order to tackle these kind of serious crimes, they have for the first time defined what is an organized crime, and if you ask me, it is quite a comprehensive definition. It covers almost all situations, and earlier, whenever we would talk about a serious offense, generally the law would prescribe a condition where unless the person has previous history of convictions, you would not be able to tackle that person in a more serious crime. So instead of this condition of having previous convictions, they have now replaced with the previous charge sheets. So if a person was earlier, say, charge sheeted in a similar crime in more than 2 cases, now that person will be able to be booked under the organized crime, which is, I think, a more serious crime. Then taking, I think, they have taken concern of many other things. Certain crimes, by the way, have been made gender neutral. It could be very interesting to know. For example, if I may say, like, outraising modesty of a woman. When you use criminal assault or force on a woman to disrobe her, in the earlier law, in the IPC, only a male person could be booked as an accused for this particular crime. Now this has been made gender neutral. They say even a woman can subject another woman to this kind of assault. So even the woman can now be booked under the BNS. So this is similarly, there is another crime, what is known as voyeurism. Voyeurism means when you peep into the private life of a person. So again, earlier only a male person could be booked as an accused. Now this has also been made gender neutral. Even a woman, if they do this kind of act, they can be booked for this crime. So similarly, there are many other, I think, changes that have been made. In the evidentiary law, also number of changes have been made, though this is one law which has not been changed much, because in the previous law, that is the Indian Evidence Act, there were 167 sections, against which now in the new law, that is this Bharatiya Sakshi Adhiniyam, they have 170 sections. So not many changes, but what are the important changes they have made? They have expanded the definition of primary evidence. Those who know, the courts always insist that you must produce the primary evidence. I will accept the secondary evidence only when you are able to convince me that the primary is not either not available or you are not in a position to bring the primary before me. For example, sorry, we all know about the electronic evidences, because in electronic evidences, basically the huge storage mediums like servers, loggers, on which like lakhs of other data is stored. You may be interested in one file, and that particular machine has 1,000 other files. So obviously it is difficult to seize original and produce original before the court. Otherwise, many a times, suppose if I read a company and if I take the server out of that company, obviously its operations will be put to a halt. So the law has taken care of that. They say in certain these kind of situations, you don't have to bring the primary. You only obtain the copy of that file in which you are interested, but there are certain riders. That file will be admissible only when you obtain a particular certificate, what we popularly call as Section 65B certificate for the admissibility of electronic and digital evidence. So keeping in view these issues, they say, why don't we expand the definition of primary evidence itself? And now let us try to think of situations where more and more kind of examples would be considered as a primary evidence. If I may give an example, suppose if we are broadcasting this program at number of locations, and the program is being recorded simultaneously. Simultaneously is the key word here, not in a series, but parallelly, simultaneously, together at the same time. The new law says each such recording which is being done simultaneously at multiple locations will now be treated as a primary evidence. So these kind of things. Similarly, in the secondary evidence also, in the definition of secondary evidence, they have expanded the scope of this definition. If I may give an example, there are many endangered manuscripts which are kept in our national archives. Suppose if there is something, some content in one such manuscript or book which is very delicate, we can't even make a photocopy out of it, it can't even be lifted, it can't even be photographed. then if there is some content in that book which I want to like prove in the court of law, how do I bring the primary? I can't bring. So, and there is no photocopy available. So how do I prove? I am not even able to produce the secondary evidence. In the new criminal law, I think this concern has been taken care. When they say, now oral admissions and written admissions will also be accepted as a secondary evidence. Now what is the meaning of oral admission over here? It means if there is an expert, someone who claims that I am an expert, I know what is written in that book. Maybe someone who did a research on that particular theme or subject. Maybe someone who wrote a book in which this particular book or manuscript was referred to. So someone who can be fairly considered as an expert, if that person is presented as a witness in the court, whatever this person states as oral statement, oral admission, that will be accepted by the court as a secondary evidence in order to prove the content of such books. They have also, I would say, changed the definition of the expert, because ultimately, as we know, in the evidentiary law, whose opinion is acceptable in the court? It is only the opinion of the expert, not the opinion of any other person. Someone who qualifies to be called as an expert in the law, it is only this person's opinion which can be accepted as the expert evidence. So many a times, like we all know about these forensic experts, we all know about the experts of the document examination, questioned documents, etc. But there may be many other fields where a person, because that person has worked in that particular field for many years, by virtue of that experience, this person qualifies to be called as an expert. Say, for example, if I may give an example, revenue field, because police does a lot of investigations relating to land disputes, revenue records, etc. There are many matters. Suppose if you want to examine a person who is an expert in the field of these revenue, land records, etc., someone who has worked, say, for 20 years, 15 years, 30 years, now you will be able to present the opinion of such a person as expert's opinion. Because now they say any other field, expert in any other field has now been added into the definition of the expert given in this. But note that everything has been made easy. Certain changes have made things difficult also for the police in the new criminal law, particularly regarding the admissibility of the secondary electronic evidence. Because as I mentioned in the earlier law, in section 65B of the Indian Evidence Act, there was a requirement of seeking only one certificate from the machine handler. Suppose if this is the machine in which, suppose there is a voice logger in which we record the calls. So the one who handles that machine, who is the in charge of this machine, I would obtain a certificate from that person that yes, it is me who handles this machine. I know what are the contents inside it. I can certify the authenticity or the integrity of the recordings. So it is me who has made a copy and I am giving it to you. I certify with this certificate, this will become admissible. In the new criminal law, they say in section 663 of the Bharatiya Sakshya Adhiniyam, now you will require to obtain two certificates. One from this person who has been handling the machine and also a certificate from an expert. Incidentally, who will be an expert for providing this second certificate for making the secondary evidence admissible, secondary electronic evidence admissible? Unfortunately, the law is silent. So how do I know from which person to obtain this second certificate? Now there are multiple interpretations of that. So some people say, okay, look at the definition of the expert given in section 39 of the new law. When we go there and we look at the definition, we find it says that for the purpose of electronic or digital evidence, an expert is a person who has been defined as an expert in the Information Technology Act, section 79A. So when we go there, we find that the expert for the purpose of this act or this section would be an agency which is certified to be so by the Ministry of Electronics and Information Technology. When we go and look at their list, we find so far they have only given certificate of examining these electronic exhibits to about some 20 odd agencies, not persons. Laboratories, mostly the central government laboratories, not even the state laboratories. So obviously they would not be able to fulfill the objective of the requirement of section 63. It is very simple, because now, for example, you know, the the most common thing that we do during investigations these days is we collect call records, because everyone is using a mobile phone. I want to know to whom this person talked to. I want to know whether this person was actually present at this place when the incident happened. Then obviously I want to know, I want to find out his location as per the tower details in the call records. So I am seeking what we call as CDRs, call detail records. Earlier, the nodal officer of that service provider will give me the section 65B certificate. Now, police, like if you ask the officers from Delhi police, they would tell you they have been seeking CDRs every day in thousands. So who would give the other certificate, which is now required as per section 63? From where will you bring so many experts? I don't think this expert as defined in section 39B would be of use to us. So these are the areas of concern also. Then there is perhaps some other section, what is known as section 329 of BNSS. There also they define the expert. But if you ask me, it would not be easy for the police to obtain this second certificate. Then, you know, there are many other areas also. Achha, one more thing, you know, which is, I think, relating to the use of technology. One of the most important work of the police in a police station, if you go and see, is servicing of summons issued by the courts, isn't it? If you go to a typical police station, you will find that more than half of the police personnel are busy, or they have gone out of the police station to service the summons which were received from the courts. So the new law says, why to engage so much manpower for the purpose of servicing summons? So they say that, okay, court shall issue the summons in electronic form, digital form, with digital signature, or with the image of the court seal, and police would also be able to, I think, serve these summons electronically. I have got a signal that I think the chief guest is about to reach, so I think more discussions we'll have during the panel discussions. I think the panelists will throw more light on this. Not that everything is good. I think there are areas of concerns also in the new criminal laws. I think we need to educate ourselves about that also, particularly those who have the responsibility of implementing the new criminal laws, particularly the state governments, particularly the police leadership, the DGPs of the states, as we would try to bring out during today's these two panel discussions. There is so much for the state and the DGPs in particular. The way they will implement, the way they will issue the guidelines, the way they will issue circulars, I think a lot will depend whether wherever there are discretions given to the police station authorities in the new criminal laws, how they will be used, whether they will ensure that they are not abused or misused and they are not used for harassing innocent people. I think a lot will depend on the police leadership. So with this, thank you so much, sir, for giving me this opportunity. I think we will have more on this. Thank you.
मंच ऊपर उपस्थित माननीय केंद्रीय कानून एवं न्याय मंत्री श्री अर्जुन राम मेघवाल, श्री आरएस मोशहारी, चेयरमैन इंडियन पुलिस फाउंडेशन, श्री प्रकाश सिंह, पेट्रन ऑफ इंडियन पुलिस फाउंडेशन, श्री एन रामचंद्रन, प्रेसिडेंट ऑफ इंडियन पुलिस फाउंडेशन, श्री डीसी जैन, चीफ ऑपरेटिंग ऑफिसर इंडियन पुलिस फाउंडेशन, श्री जेके पिलाई, फॉर्मर यूनियन होम सेक्रेटरी श्री एमएल कुमावत, फॉर्मर स्पेशल सेक्रेटरी एमएचए श्री के रामानुजम, फॉर्मर डीजीपी तमिलनाडु, श्री राजीव जैन, फॉर्मर डायरेक्टर आईबी, श्रीमती मीरन बोरवनकर, फॉर्मर डीजी बीपीआरएनडी, श्री श्याम मेहरा, फॉर्मर डीजी आसाम, श्री सुनील कुमार, फॉर्मर चीफ सेक्रेटरी छत्तीसगढ़, श्रीमती विमला मेहरा, फॉर्मर स्पेशल सीपी दिल्ली पुलिस, श्री केपी सिंह, फॉर्मर डीजीपी हरियाणा, श्री मनोज यादव, डीजी आरपीएफ, श्री पंकज कुमार सिंह, डिप्टी एनएसए, श्री आशीष गुप्ता एंड तिलोत्तमा वर्मा, डीजी यूपी, श्री सदानंद दाते, डीजी एनआईए, श्री जीपी सिंह, डीजीपी असम, श्री अभिषेक त्रिवेदी, डीजी हिमाचल प्रदेश, श्रीमती सतवंत अतवाल, डीजी हिमाचल प्रदेश, डॉक्टर एम श्रीनिवास, डायरेक्टर एम्स न्यू दिल्ली, एवं सभी सम्मानित अतिथियों का 10वें इंडियन पुलिस फाउंडेशन डे और पुलिस रिफॉर्म्स डे के उपलक्ष्य पर आप सभी का स्वागत करना मेरे लिए सौभाग्य की बात है। माननीय मंत्री श्री अर्जुन राम मेघवाल एक लोकप्रिय राजनेता हैं। इनका जन्म बीकानेर राजस्थान में हुआ। अपनी शिक्षा में उत्कृष्ट प्रदर्शन करने के पश्चात इन्होंने प्रशासनिक सेवाओं में अपना उल्लेखनीय योगदान दिया। वर्ष 2009 में बीकानेर लोकसभा क्षेत्र से निर्वाचित होकर यह संसद का हिस्सा बने। वर्ष 2013 में इन्हें बेस्ट पार्लियामेंटेरियन अवार्ड से भी सम्मानित किया गया। यह वास्तव में हम सबके लिए बड़े गर्व और खुशी की बात है कि इतने सम्मानित व्यक्तित्व आज हमारे बीच उपस्थित हैं। माननीय मंत्री बहुमुखी प्रतिभा के धनी हैं, जिन्होंने प्रशासनिक सेवा एवं राजनीति के साथ साथ एक लेखक होने का भी उत्तम उदाहरण प्रस्तुत किया है। इन्होंने सफल दाम्पत्य जीवन पर 2 किताबें भी लिखी हैं। पहली एक सफ़र हम सफ़र के साथ और दूसरी दिव्य पथ दाम्पत्य का, जिससे काफ़ी लोग प्रेरणा ले रहे हैं। माननीय मंत्री महोदय ने इस समारोह के लिए अपना बहुमूल्य समय दिया, इसके लिए हम उनका आभार व्यक्त करते हैं। कार्यक्रम को आगे बढ़ाते हुए मैं श्री एन रामचंद्रन सर से स्वागत संबोधन करने का अनुरोध करता हूँ।
Good morning, everyone. The chief guest of the day, Honorable Law Minister, Minister of Law and Justice, Shri Arjun Ram Meghwal ji, our respected patron and our leading light, Shri Prakash Singh ji, our esteemed chairman, Shri Ranjit Shekhar Moshari ji, my colleague Shri Dharamchand Jain ji, all other distinguished panel of experts, distinguished dignitaries in the audience, ladies and gentlemen. In fact, there is an array of people watching us online. There are a number of police chiefs, senior police officers, officers from the CAPFs, and field police officers who are logged on and who are virtually participating in this program. I welcome every one of them. It is my great honor and privilege to welcome every one of you here to the 10th annual Foundation Day of the Indian Police Foundation. In fact, the Police Foundation was inaugurated on the 21st of October 2015 in this very hall, when the then Union Minister Honorable Shri Rajnath Singh ji had inaugurated the event, inaugurated the organization. So we have completed 9 years. This is the 10th annual day. So at the outset, I wish to express our deep gratitude to our chief guest, Honorable Law Minister Shri Arjun Ram Meghwal ji, for graciously accepting our invitation. Sir, we are deeply honored by your presence today as the chief guest. Your ready acceptance of our invitation to grace this occasion, your leadership and dedication to the cause of reforming the criminal justice system, as well as your keen interest in the smooth implementation of the new criminal laws, are truly inspiring. In fact, when we suggested to him, he very readily agreed. It was very gracious gesture on his part. May I now request our chairman, Shri Ranjit Shekhar Mushari, to kindly welcome the Honorable Minister by presenting him a bouquet of flowers. We are also privileged to have with us the legendary police officer, Shri Prakash Singh ji, who has been the first chairman of the Indian Police Foundation and our patron. He continues to guide the Indian Police Foundation to this date, almost on a daily basis. We take guidance from him. It is a matter of privilege and honor to welcome him today formally to this occasion. And during the course of this program, we will be honoring Shri Prakash Singh with the Lifetime Achievement Award. In fact, we will be honoring ourselves by giving him the Lifetime Achievement Award for the outstanding contributions that he has made to the cause of policing, to the cause of police reform in this country. May I request our Vice Chairman, Shri Mahendralal Kumawat ji, to present a bouquet to Shri Prakash Singh and welcome him to this program. The IPF has been conceived as a multidisciplinary independent think tank, a think tank on law enforcement. Of course, we have a think tank in the government, that is the Bureau of Police Research and Development, which is the primary think tank on policing. But in the independent sector, the Police Foundation plays that role. And our vision is to nurture and develop the IPF as a professional voice of the Indian police, committed to upholding the rule of law, professionalism, and citizen centricity. So that is our vision. And it is also our vision to foster, to promote evidence-based policing and professional excellence within the police system. Since its inception, IPF has traveled a long way, and we have set up a number of centers of excellence, centers of research and learning. In fact, they are all work in progress. We, as I had mentioned earlier, we have, most importantly, we have the Center for Police Reforms, internal police reforms. We do have a center for women safety and gender-sensitive policing, child-sensitive policing, etc. Then we have a center on forensic sciences, on prison reforms, which is being headed by Dr. K.P. Singh, who sits here. We have one on digital transformation of policing, which is an aspirational activity. Mr. Ramphal Pawar is heading that project. And most importantly, we have a center on the wellness and well-being of police personnel, which includes both physical health and mental health of police personnel. In fact, during the COVID season, the police went through, I don't have to explain everything here, but we need to learn quite a bit on the health of police personnel. In fact, the number of police persons who fell to COVID was far in excess of the national average. And during our informal, we are yet to carry out a research on this, but it was found that the largest number of casualties happened because a very large number of police persons suffered from fundamental underlying diseases like diabetes, high blood pressure, etc., which are very common. Dr. Srinivas, our director of All India Institute of Medical Sciences, is sitting here. I'm sure he will help us in conducting this research project and taking it forward. About the other projects we have already mentioned here before the Honorable Minister came. And policy advocacy for reforms remains the key focus area of the Police Foundation. Talking of new criminal laws, in the early days of the legislation of the new criminal laws, the Police Foundation did a massive exercise in carrying out consultations and brainstorming sessions, and we prepared and submitted a comprehensive set of proposals and suggestions for the consideration of the parliamentary committee which was considering this legislation. Coming to today's seminar, that is navigating the new criminal laws and implementation challenges, we have the right chief guest here who can guide us about this. And we have an array of very distinguished panelists who will be guiding us through. I extend a very hearty welcome to each one of them, and also thank them for sparing their valuable time, because all of them are very busy people who have come here, holding very high positions in their own right. So thank you very much for sparing your time and coming here. And the purpose of today's seminar is not merely to critique, but to collaboratively develop solutions and identify suggestions that will help smoothen the edges and towards a smooth transition to the new criminal laws. So at the end of today's session, which we have two panel discussions, and we will be documenting whatever discussions that take place, and we plan that at the end of the sessions we will consolidate the key learnings and insights from the seminar for the guidance of the police persons across the country. And we also intend to prepare a comprehensive set of suggestions to be presented to the authorities for their consideration. And of course, I need not say this, our outcome document will reflect the combined expertise and experience of all those who are sitting in this hall and all those who are watching the proceedings and participating in the proceedings online. So once again, I welcome each one of you and thank you for all your active participation. I'm confident that today's program will be highly enriching, productive, and useful to the police fraternity and also to the country as a, police fraternity especially. So thank you very much. Jai Hind, Namaskar.
अब मैं श्री आरएस मोशाहारी जी को अपने विचार व्यक्त करने के लिए आमंत्रित करता हूँ।
Honorable Union Law Minister, Sri Arun Ram Meghwal, Sri Ramachandran, Sri D.C. Jain, and most importantly, the person today is sitting in the midst of us is one of our very senior colleagues, Mr. Prakash Singh, whom we are going to honor in recognition of his contribution to the Indian police. And very distinguished audience of this hall, students and their friends. Well, the government of India has really done something remarkable by bringing out the 3 new legislation, the 3 major acts in the criminal justice administration. And this is a huge compendium of sections. The 3 laws, which is the procedural, evidentiary, and penal laws, consist of over 1,000 sections. It is not easy to really familiarize with all these sections. It is an attempt, very sincere attempt, to make justice available as soon as it is possible to the people of this country. Well, it is done now. It has become an act. But law, if you really look at it, it is a value neutral thing. Law does not punish or absolve you of anything. A law is absolutely a piece of paper. What makes it important, what makes it effective, is the enforcement of law, the application of law, the administration of law that makes it effective. So all the penal provisions in the new penal code, we have a section 4 of Bharatiya Nyaya Samhita, which defines the punishments for criminal actions. These punishments begins with death. That is number 1. After that, life imprisonment, 7 years imprisonment, and likewise it comes to less punishment, and ultimately it ends. This new law introduces one new subsection in the punishment. It is something known as community service. This was not in existence in earlier Indian Penal Code. So I do not know what it will be like, the community service in the new act. Now all this death, life imprisonment. Now what is the punishment for murder? Punishment for murder is death. But murder is happening. Punishment for kidnapping with ransom is death. People are being kidnapped for ransom even now. Punishment for rape, gang rape, is death. If it is associated with the killing of the victim, but now rape is happening, and happening very rapidly, almost every day it is happening. Why it is so that we have these acts, the penal provisions? Where have we failed? In the justice administration has three components: the investigating agency, the prosecution, and the judiciary. Somewhere in this line of the justice administration, we seem to have failed, or all the three of us have failed. So as a result, all this legislation have become ineffective. You know, the effectiveness of law is that the criminal must know that he will be punished. And the punishment will be as severe as the offense. And the punishment will be quick. If these three ingredients are there, then law is effective and it becomes deterrent. Law is essentially, the penal provision is retributory. But retribution is not only the intention, it is a deterrence. It is somewhat reformative also. We imprison people so that they have chance to reform, become good citizens. All these objectives of punishments and the objective of legislation has not been successful in our country. We feel ashamed that every day, why it is that rape is happening. There is something really that we need to do something. What is it that we should do? I have been thinking about this. So I was thinking that punishment of death alone possibly, or life imprisonment alone is possibly is not the real deterrence. Deterrence for the punishment of rape is possibly somewhere else. You know, the punishment must be commensurate not only with the crime, but also with the perception of the people of that crime. Now, that actually is not a punishment to the person. If he is hung, he is gone. He doesn't suffer. His family suffers, but the person, the man, the criminal, he doesn't know. After death, who knows where he has gone? You know, one of the punishments that I learned when I was seeing Mahabharata, you know, the most heinous crime in Mahabharata was committed by whom? Most heinous crime in Mahabharata was committed by Ashwatthama. It was the most heinous crime. He wanted to kill the entire children, but lucky he wanted to kill the entire 5 brothers, but by mistake he killed the entire children. I mean, what more heinous crime? They are minor children. They killed. When Sri Krishna came to know about this, he could have killed him instantly, but he did not kill him. He said, no, killing is not enough for you. I will incapacitate you because you have the power to survive. No one can kill you because you have got that gem on your forehead. That forehead gem I will remove from your forehead and then make you live in the world for 5,000 years. You suffer. No one will meet you in the world. Your body pus will come out. You will suffer aches and pains. So this is known as incapacitation. So for the rape case, should we not think of something like incapacitation? Incapacitation. After death, incapacitation, life imprisonment, then various terms of 10 years of imprisonment should be there. So I request the Honorable Minister to consider this punishment nation. What is incapacitation? Even in case of not only rape, in case of murder, we can have the incapacitation. We can cut off one of the hands. People will see, yes, this man is there, whole life he will suffer. That's a great deterrence. And for the serial rape convict, possibly the castration is a part of incapacitation. I think this one will bring shame to him throughout his life and to his family, and this will be a great deterrence. This is one way. Many countries have got this incapacitation, particularly in the world, in the Islamic countries. So we have to really think of this. Now, the Act has brought a lot of new things. The plea bargaining for quick resolution of the dispute. This is the alternative dispute resolution. Plea bargaining. And one of the very, very welcome section that I found was section dealing with the release of the under trial prisoners. And it is really something very forward looking that way. Of course, these are new acts. There will be trials and errors. We will have to find out, and where necessary, possibly not now, slowly, amendments can be inserted. No law is perfect. Nothing is perfect in the world, as a matter of fact. So this law which has come, there will be some flaws that will be experienced. So on the basis of the experience, amendments can be introduced. But this is a very, very welcome step. One thing, of course, it will take quite some time for the investigating officers to familiarize with 1,000, I think 1,100 sections, 1,011 or 1,007, I'm not very sure, but it exceeds 1,000. All these sections, it really is very confusing. And for people like us who have learned the versions of CRPC and IPC and Evidence Act, this is absolutely new for me. So it's not important whether I know it or I do not know it. But it is important for the young people to know it. For them, it may not be difficult, because if you learn IPC or Criminal Procedure Code Evidence Act, you will have to learn from the beginning. So this also you will learn from the beginning. So this is no new burden for you. But those who have learned earlier something new, he has got to correlate. Because I was seeing the list of offenses in the Criminal Procedure Code. It would have been easy if the old sections of the penal code was also given for easy reference, but it is not done in the new Samhita. This has not been given. And the sections in new code, procedural code, has gone above 500. It is actually about 100 sections or more. What is reduced is what someone was telling in the IPC. IPC has been, sections have been drastically reduced, but overall, the total sections more or less remain the same. So respected Law Minister, I congratulate the Government of India for this piece of legislation, and your government can be really proud of it, of this achievement. Thank you very much.
थैंक यू सर। आपने महाकाव्य महाभारत से उदाहरण लेके आपराधिक न्याय प्रणाली में दंड और निवारण के महत्व को बहुत ही खूबसूरती से उजागर किया। श्री प्रकाश सिंह एक सेवानिवृत्त आईपीएस अधिकारी हैं जो भारत में आर्किटेक्ट ऑफ पुलिस रिफॉर्म्स के रूप में अपनी भूमिका के लिए प्रसिद्ध हैं। उन्होंने उत्तर प्रदेश राज्य, असम राज्य और सीमा सुरक्षा बल के पुलिस महानिदेशक के रूप में कार्य किया है। हालांकि राष्ट्र और पुलिस बल के प्रति उनकी सेवानिवृत्ति के बाद भी जारी रही, जब उन्होंने वर्ष 2006 में पुलिस सुधारों के लिए सर्वोच्च न्यायालय द्वारा ऐतिहासिक निर्देश दिए जाने हेतु एक जनहित याचिका दायर की। उनके प्रयास भारत में पुलिस की जवाबदेही, स्वतंत्रता और दक्षता के लिए अपने आप में एक दौर के बराबर साबित हुए। आज इंडियन पुलिस फाउंडेशन के लिए हर्ष और गौरव का विषय है कि ऐसे सक्षम और सफल अधिकारी को जीवन पर्यंत योगदान के लिए सम्मानित करने का अवसर प्राप्त हुआ है। अब मैं बिना किसी और देरी के उन्हीं के सम्मान में श्री एमएल कुमावत जी को अब उन्हीं के सम्मान में मैं श्री हरीश कुमार जी को ईश कुमार जी को साइटेशन पढ़ने के लिए आमंत्रित करता हूँ।
Good morning to all of you once again. Shri Arjun Ram Meghwal ji, Chief Guest and Honorable Minister for Law and Justice, Chairman Police Foundation, Shri Mushahri ji, President Ramchandran sir, of course my colleague Jain Saab. It's an honor to be given the opportunity to read the citation whom we are going to honor today by the Indian Police Foundation, one of the legends of the Indian Police, Shri Prakash Singh ji. Sir, I welcome you here today. So Shri Prakash Singh ji joined Indian Police Service, if I correctly recollect, sir, 1958, sir? 59, sir. I remember, so he has been renowned for his exemplary service, significant contribution to national security, law enforcement, and public administration. As somebody mentioned, he was DGP in the two states of Assam and Uttar Pradesh, and he was also heading the border security force. Shri Prakash Singh ji served in some of the country's most turbulent regions, including Nagaland, Assam, Punjab, Jammu and Kashmir, UP, and played a stellar role in the counter-insurgency operations against the rebel militants in Northeast and anti-terror operations against the Sikh militants in Punjab and Tarai area of UP. He also played an important role in curbing cross-border terrorism in Jammu and Kashmir. For his contributions and services, he was awarded Padma Shri by Government of India for his contributions in the field of civil services. Which year was that, sir? Padma Shri, sir?
91.
So in the year 1991, which is long back. So great thing is, I think that inspired him and he has continued to serve post his retirement also, and sir is very active even today. He was also recipient of a Paul Appleby Award in 2019 for his services in the sphere of public administration. As someone rightly said, he is recognized as the architect of police reforms in India. Everyone talks of that PIL, which sir filed in 1996 along with Common Cause in the Supreme Court for implementation of the key recommendations of National Police Commission. So National Police Commission reports came from 79 to 81. There are 8 volumes. And sir picked up the important points out of that. Basic intent being that police must be isolated from the political pressure of the government in the day and giving its functional autonomy. Shri Prakash Singh ji has also contributed significantly to the academics, public discourse through his writings. I was just talking to sir before this, and he said that he has written more than 10 books. There is also a book on the Naxal violence. His last 2 books, which I am aware, one is a book on the struggle for police reforms in India. I think it came around a year or 2 years back. And recently, this year, I think sir has written his memoirs, The Unforgettable Chapters. So, sir, one book is on my table. I am trying to go through it. I haven't been able to complete the book as yet. He has been contributing extensively to the newspapers, the journals, the TV shows. And I remember him going to the KBC as well, which is hosted by Shri Amitabh Bachchan. And he won it there. And whatever money he got, he contributed to Indian Police Foundation there. Now, beyond policing, Shri Prakash Singh ji has been actively involved in various social and cultural activities with the organizations like Paramarth Niketan, it is in Rishikesh, and Vivekanand Kendra, I think it's in Kanyakumari. He is an influential voice on the national security. He served as a member of the National Security Advisory Board and is an associate fellow of the Joint Special Operations University, United States. As Ramchandran sir mentioned, he was the first chairman of the Indian Police Foundation from 2015 onwards and continued for there almost 7 to 8 years during its formative years. I remember, sir, you also gave a report on the Jats agitation in Haryana. That's what I recollect. And now he is a patron of the Indian Police Foundation. His remarkable career, continued activism reflect his dedication to strengthening the rule of law and governance in India. In recognition of his outstanding professional career, lifelong dedication to public service, the Indian Police Foundation has decided to honor Shri Prakash Singh Ji for his exceptional contribution to India law enforcement and police reforms on the occasion of 10th IPF Annual Foundation Day and Police Reforms Day today, 2024.
थैंक यू हरीश सर। अब मैं मुख्य अतिथि माननीय मंत्री श्री अर्जुन राम मेघवाल को श्री प्रकाश सिंह को साइटेशन देने के लिए आमंत्रित करता हूं। अब मैं श्री आरएस मोशहारी जी को श्री प्रकाश सिंह जी को प्लेक ऑफ साइटेशन देने के लिए आमंत्रित करता हूं। अब मैं श्री प्रकाश सिंह से अनुरोध करता हूं कि वे अपने आशीर्वचन से हमारा मार्गदर्शन करें।
माननीय मंत्री महोदय, चेयरमैन इंडियन पुलिस फाउंडेशन श्री मोशाहारी, प्रेसिडेंट श्री रामचंद्रन और चीफ ऑपरेशंस ऑफिसर श्री डीसी जैन, सभागार में उपस्थित मेरे पुराने जाने पहचाने चेहरे और साथियों, पुलिस विभाग के अन्य विभागों के भी, गृह विभाग के, यूनिवर्सिटी प्रोफेसर्स, लॉ स्टूडेंट्स, मीडिया के प्रतिनिधि, प्यारे बच्चों और बाकी सब देवियों सज्जनों, सबसे पहले तो मैं इंडियन पुलिस फाउंडेशन के प्रति अपना आभार और कृतज्ञता व्यक्त करना चाहूँगा कि उन्होंने मुझे ये लाइफ टाइम अचीवमेंट अवार्ड दिया है। और जब इस अवार्ड की बात आई करीब 15-20 दिन पहले मुझे फ़ोन किया मुशाहारी साहब ने, तो मैंने थोड़ा अनिच्छा जाहिर की। मैंने कहा देखिए, अभी तो मैं इंडियन पुलिस फाउंडेशन का हिस्सा हूँ, पुलिस फाउंडेशन मुझे अवार्ड दे, मुझे कुछ बात जच नहीं रही है। जब मैं पुलिस फाउंडेशन से चला जाऊँ, यहाँ से भी रिटायर हो जाऊँ, उसके बाद दीजिएगा तो ज़्यादा अच्छा लगेगा। पर मुशाहारी साहब आग्रह करते रहे और फिर रामचंद्रन ने भी मुझसे कहा कि नहीं सर, हम लोग रिवेरो साहब को दे चुके और उसके बाद आपको देना चाहते हैं। तो फिर मैंने कहा चलिए, अब आप लोग अगर आपका आग्रह है तो मैं उसे बड़ी विनम्रता से स्वीकार करता हूँ। और जीवन में पुलिस विभाग को मैंने शुरू में जब मैंने पुलिस विभाग में आया तो मुझे लगा कि मैं कहाँ फंस गया हूँ। और मैंने अपनी पत्नी से कई बार कहा कि अब इस्तीफ़ा दिया जाए, वापस एकेडमिक फील्ड में जाए, पर मेरी पत्नी ने मुझ पर कहा नहीं, इतनी जल्दीबाजी में इतना बड़ा फ़ैसला मत लीजिए, थोड़े दिन और देखिए। और जैसे जैसे मैं तरक्की करता गया, मुझे पुलिस के बारे में, मैं गवर्नमेंट ऑफ इंडिया में रहा तो, और भारत और प्रदेश में रहा तो एक नई फीलिंग आई अंदर से जो पहले नहीं थी। जब जितने दिन मैं राज्यों में रहा, स्टेट गवर्नमेंट्स में, मुझे ये लगा कि पुलिस जो सेवा है ये एक सोशल सर्विस का एक बहुत सशक्त माध्यम है। आप सोचेंगे पुलिस का सोशल सर्विस से क्या मतलब है, पर मुझे लगा कि नहीं, ये वास्तव में ये समाज सेवा करने का एक बहुत सशक्त माध्यम है। आपके पास जो भी आदमी आता है वो कुछ दुखी है, पीड़ित है, कोई परेशानी है उसको, उस परेशानी को अगर आप दूर कर देते हैं, उसका खोया बच्चा वापस ला देते हैं, उसके खोया सामान बरामद कर देते हैं, या जिससे वो प्रताड़ित है, जिसने उसका घर आपका दबा लिया, उसको वहाँ से निकाल देते हैं, माफिया के खिलाफ कार्रवाई करते हैं जो समाज विरोधी तत्व हैं, राष्ट्र विरोधी तत्व हैं, बड़ा आत्मसंतोष मिलता है। तो इसी बात ने मुझको फिर मोटिवेट किया कि नहीं, पुलिस विभाग में काम करते रहना चाहिए। और जो मेरा लक्ष्य था कि दूसरों के कुछ समाज के मैं काम आऊँ, और जो इस माध्यम से मैंने उसको पाने की कोशिश की। और जब भारत सरकार में रहा तो मैंने देखा सीमाओं की सुरक्षा, वो भी एक बहुत बड़ा काम है। नागालैंड में शुरू में ही मैं भेज दिया गया, बड़ा मुश्किल क्षेत्र था, उसके बारे में ज़्यादा जानकारी भी नहीं थी, पर थोड़े दिन बाद मुझे लगने लगा कि मैं एक ऐसे क्षेत्र में जहाँ देश की अखंडता, एकता को चुनौती दी जा रही है और इसको देश से अलग करने की बात हो रही है कि नागालैंड, वहाँ के लोगों का ये कहना था, विद्रोहियों का, कि साहब नागालैंड तो किसी के आपके अधीन कभी रहा ही नहीं है, ब्रिटिश सरकार के ने हमको जीता तो हम उनके अधीन हो गए, अब वो सरकार चली गई तो हम फिर से स्वतंत्र हो गए। बड़ा सिंपलिस्टिक आर्गूमेंट था उनका। तो देश की अखंडता और एकता बनाए रखने के लिए मैं वहाँ उस क्षेत्र में काम कर रहा हूँ। ठीक है, मेरा योगदान 1% ही हो या 0.1% हो, पर कुछ योगदान तो है। और इसी प्रेरणा से फिर मैं पुलिस विभाग में काम करता रहा। और रिटायरमेंट के बाद फिर ये हुआ कि अब तलवार तो चली गई, अब क्या किया जाए। एक दूसरा ही अनुभव हुआ कि अब तो आपके पास, आपकी सारी फौज तो आपसे ले ली गई। तो फिर मुझे याद आया कि पेन इज़ माइटर देन द स्वॉर्ड। तो मैंने कहा फिर ठीक है, अब अपनी कलम का इस्तेमाल किया जाए। फिर मैंने लिखना शुरू किया और पत्रिकाओं में 350, 400 लेख अब तक निकल चुके हैं। किताबें भी मैंने लिखा जो भी खाली समय मिला, और ऐसे विषयों पे जो मैं समझता हूँ समाज के लिए एक बड़ी भारी समस्या थी। ऐसे तो मैंने कई किताबें लिखी हैं, पर जो 2-3 किताबों जिस पर मुझे ख़ास तौर से गर्व है, एक तो नक्सल मूवमेंट पर जो मैंने किताब लिखी, उस पर मुझे गर्व है। गर्व इस बात का भी है कि वो किताब फिर 3 देशों में अलग अलग प्रकाशित हुई। अमेरिका में अलग प्रकाशित हुई, फ्रांस में उसका ट्रांसलेशन हुआ। और मुझे ताज्जुब हुआ, मुझे जब मेरे मित्र ने, बालाचंद्रन ने मुझे बताया, वो पेरिस में उस समय एम्बेसी में पोस्टेड थे, उन्होंने मुझे बताया कि प्रकाश, योर बुक हैज़ बिकम ए बेस्ट सेलर इन फ्रांस। तो और फिर हिंदुस्तान में तो खैर छपी ही थी। एक तो वो किताब के लिए मुझे गर्व है। दूसरा पुलिस रिफॉर्म्स पे जो मैंने किताब लिखी, वो किताब लिखने का मेरा उद्देश्य ये था कि इतनी लंबी लड़ाई मैंने लड़ी, 10 साल तक कोर्ट दौड़ते रहे और उसके बाद भी अदालत दौड़ते रहे, और जनता में मतलब जगह जगह हिंदुस्तान में जहाँ भी जाने का मौका मिलता था मैं पुलिस रिफॉर्म की बात उठाता था। मैंने कहा जितनी लंबी लड़ाई मैंने लड़ी है, इसका कहीं एक कंसोलिडेटेड अकाउंट होना चाहिए, क्योंकि ये मशाल मेरे बाद कोई ना कोई आगे नई पीढ़ी का अधिकारी ज़रूर लेकर चलेगा, तो उसको इसमें सामग्री मिल जाएगी क्या काम हुआ है। और आखिरी किताब है अनफॉरगेटेबल चैप्टर्स। उसमें वो मैं ऑटोबायोग्राफी तो नहीं कहूँगा, पर मैंने ये, कई लोगों ने मुझसे कहा कि ऑटोबायोग्राफी लिखे, पर मुझे लगा कि मैं कोई इतना बड़ा आदमी नहीं हूँ कि ऑटोबायोग्राफी लिखूँ। और ऐसे भी आजकल ऑटोबायोग्राफी पढ़ने का फैशन शायद कम हो गया है, शौक़ कम हो गया लोगों का। तो मैंने सोचा कि मेरे जीवन की बहुत महत्वपूर्ण संस्मरण जो है, जो एक मेजर इंसिडेंट्स जो हमारे लाइफ में हुई हैं, और ऐसी घटना जिसमें मैंने कुछ योगदान किया, कहीं सफलता मिली, कहीं नहीं सफलता मिली, फिर भी वो ऐसी घटनाएं हैं जो आज के पुलिस अधिकारियों के लिए उसमें एक सबक हो सकता है। और जनसाधारण को उसकी पढ़ के ये जानकारी होगी कि एक पुलिस अधिकारी का जीवन कितना मुश्किल होता है, एक कांटों की राह पे चलने के समान होता है, और उस पे चलते हुए आपको खून भी बहता है, सब कुछ होता है, फिर भी अगर आदमी चलता रहे तो उसको एक बड़ा सर्विस ख़त्म होने के बाद एक बड़ा संतोष भी मिलता है। तो इस तरह से आपने लाइफ टाइम अचीवमेंट भी दे, अवार्ड भी दे दिया। अवार्ड देने पे ऐसा लगता है जैसे अब सर अब आपका काम ख़त्म हो गया, आप जाइए। तो दैट्स अ वेरी सीरियस थॉट कि भाई अब आप अवार्ड भी हो गया, लाइफ टाइम आपकी ख़त्म हो गई। तो ख़त्म हुई या नहीं मुझे नहीं मालूम। कल ही मैं अपने डेंटिस्ट के पास गया तो मैंने कहा डॉक्टर साहब आप दांत का इलाज कराएं कि ना कराएं, कोई मुझसे बता दे कि 1-2 साल ज़िंदगी है तो मैं नहीं कराऊंगा, पर कुछ ठिकाना नहीं है कितने दिन जिंदा रहना है, इसलिए मैं सोचता हूँ कर ही दीजिए। तो लाइफ तो अभी कितने दिन चलना है मुझे नहीं मालूम, ऐसे उम्र तो काफ़ी हो गई है, पर इलाज बिल्कुल बिल्कुल कराया। तो ठीक है, जीवन तो चलता रहता है और आदमी काम करता रहता है, और ये थॉट की, ये विचार की ठीक है लाइफ टाइम भी पूरा हो गया, ये भी एक बड़ा समबर, बड़ा गंभीर विचार है। मुझे यूनिवर्सिटी में मैंने शेक्सपियर की कुछ लाइनें पढ़ी थी, याद आ रहा है। जीवन के बारे में भी उन्होंने कहा कि tomorrow and tomorrow and tomorrow creeps on this petty pace to the last syllable of recorded time, the way to dusty death. Out, out, brief candle. Life is but a walking shadow. अब इसका आगे वाला महत्वपूर्ण है। A poor player that struts and frets his hour up on the stage and then is heard no more. Life is a tale told by an idiot, full of sound and fury, signifying nothing. तो खैर इसके दर्शन से मैं सहमत तो नहीं हूँ शेक्सपियर का कि लाइफ इज़ ए टेल टोल्ड बाय एन इडियट, और फुल ऑफ साउंड एंड फ्यूरी तो खैर ज़रूर है। वेदर इट सिग्निफाई समथिंग और नॉट डिपेंड्स ऑन द इंडिविजुअल। आप जीवन को कैसे लेते हैं, आपका जीवन का दर्शन क्या है। मैं समझता हूँ जीवन को एक आदमी अपनी कर्मभूमि के रूप में ले कि हमें ईश्वर ने जब भेजा है, और हमारा दर्शन तो हिंदू धर्म का ये है कि मनुष्य का जीवन बहुत आपने पुण्य किया होता है तभी मिलता है, और आप अच्छे घर में पैदा हों, आपके अच्छी परवरिश हो सके, वो भी एक बड़े भाग्य की बात होती है। तो ये एक कर्म भूमि है, और यहाँ पे आदमी जितने दिन रहता है, मेरा दर्शन यही रहा है कि अच्छा से अच्छा काम करे। और हमेशा मैं तो अधिकारियों से, पुलिस अधिकारियों से जब बात करता हूँ तो कहता हूँ कि हमेशा तुम अपने आप से 3 सवाल पूछो कि तुमने अपने परिवार के लिए क्या किया, अपने समाज के लिए क्या किया, और अपने राष्ट्र के लिए क्या किया। अगर तीनों का जवाब में तुम्हें कुछ मिलता है तो ठीक है, और अगर तीनों के जवाब में नकारात्मक जवाब हैं तो फिर तो तुम्हारा जीवन बेकार गया। कुछ ना कुछ यू शुड बी एबल टू से समथिंग पॉजिटिव अंडर ऑल दीज 3 हेडिंग्स। तो धन्यवाद फिर से आपको मुझे लाइफ टाइम अचीवमेंट अवार्ड देने के लिए। आज का विषय पे बहुत संक्षेप में कहूँगा, बस 2-3 मिनट में बात ख़त्म करूँगा। विषय है नए क्रिमिनल लॉज के बारे में, और नए क्रिमिनल लॉज के बारे में हमें ये कहा गया कि वी वांट टू डीकॉलोनाइज आवर लॉज ऑल्सो। बड़ी अच्छी बात है, डीकॉलोनाइजेशन की प्रोसेस, ये सोच ही अच्छी है, और इस दिशा में जितने भी कदम उठाए जाएँ वो महत्वपूर्ण है। और जैसा कि चेयरमैन साहब ने कहा, इस भारत सरकार बधाई की पात्र है कि इतना बड़ा क्रांतिकारी कदम उन्होंने उठाया। शायद थोड़ा जल्दी में उठाया, थोड़ा सा और स्टेक होल्डर्स को और कंसल्टेशन का टाइम मिलता तो अपोजिशन पार्टीज़ का जो शिकायत है कि साहब इसको भी बुलडोज़ किया गया है बड़ी जल्दी, और ऐसे समय में जब बहुत सारे मेंबर्स ऑफ पार्लियामेंट में थे ही नहीं, तब इसको पास किया गया। खैर जैसे भी है, पास हो गया और अब लागू हो गया। अब वो सब बातें तो पुरानी हो गई, ऐतिहासिक हो गई हैं। अब हमारा कर्तव्य यही बनता है कि इन लॉज को अच्छी तरह से लागू करें। मुझे भी बड़ा संशय था कि भाई इतना बड़ा परिवर्तन हो रहा है, ज़रूर परेशानी होगी, पर 3 महीने तो निकल गए। हमें लगता है कि वी हैव ए जीनियस फॉर अडेप्टिंग न्यू थिंग्स। हमने वेट्स एंड मेजर्स बदल दिए, अपना किलोग्राम में चले आए, फासला मील का किलोमीटर में हो गया। मैं यूएसए अक्सर जाने का मौका मिला, मैंने कहा ये लोग किलोमीटर में क्यों नहीं आते? वो कहते बहुत मुश्किल है, बहुत मुश्किल है। मतलब अमेरिकन को बड़ा मुश्किल लगता है कि हम मील से किलोमीटर में कैसे जाएं, और कहते हैं इसमें इतने हजार करोड़ रुपए डॉलर खर्च हो जाएंगे वगैरह वगैरह, भगवान जाने इतनी सारी समस्याएं बताते हैं। उनके लिए माइंड बॉगलिंग है कि वो किलोमीटर में जा ही नहीं सकते। बट हमने तो किलोमीटर भी अपना लिया और मन शेर भी छोड़ दिया और किलोग्राम पे आ गए, और अब नए लॉस को भी हमने अडॉप्ट कर लिया। 3 महीना तो हो गया, कोई ऐसी ख़ास परेशानी नहीं हुई, और मुझे लगता है कि पुलिस विभाग ने इसको लाइक फिश टेकिंग टू वाटर, हम लोग इसको भी अपना लिया है, और ये अच्छी तरह से चलेगा। बस मेरा सवाल ये है कि सर, हम जब डिकोलोनाइजेशन की बात करते हैं और नए लॉस को लाते हैं, तो ये 1861 का एक्ट जो कॉलोनियलिज्म का सबसे बड़ा प्रतीक है पुलिस विभाग में, इसको हम कब छोड़ेंगे? ये मेरा एक सवाल है आपसे। दूसरी बात, इसी संदर्भ में मैं ये भी कहूँगा कि जब 2006 में सुप्रीम कोर्ट ने जजमेंट दिया, दूसरी बात मैं ये कहूँगा 2006 में ही सुप्रीम कोर्ट ने जजमेंट दिया, 2006 में ही, सर कृपया ध्यान दें, 2006 में ही सोली सोराबजी के नेतृत्व में एक कमेटी बैठी थी, पुलिस एक्ट ड्राफ्टिंग कमेटी, होम मिनिस्ट्री के अधीन, और उन्होंने अपना मॉडल पुलिस एक्ट बना दिया। मॉडल पुलिस एक्ट भी 2006 में आया, सुप्रीम कोर्ट का जजमेंट भी 2006 में आया। तो हम लोग बराबर सरकार से ये अपेक्षा कर रहे थे कि मॉडल पुलिस एक्ट आप पास कर दीजिए, और जिन, उस समय आपकी सरकार भले नहीं थी, और जिन राज्यों में, मतलब जो भी केंद्र सरकार हो, उसको ये करना चाहिए था कि मॉडल पुलिस एक्ट पास करें, और जिन राज्यों में उन्हीं की पार्टी की सरकार है उनसे ये कहे कि आप भी इसी को अपनाइए, और बाकी स्टेट्स भी बचते हैं उनको आप एक शायद संविधान के 254 कोई धारा है उसके अंतर्गत वहाँ लागू किया जा सकता था। या दूसरा तरीका है, आप कुछ इंसेंटिव देते कि भाई जो नया पुलिस एक्ट लागू करते हैं उनको थोड़ा हम ये इंसेंटिव दे रहे हैं, तो बाकी स्टेट भी उसी लाइन में आ जाते, और कुल मिला के मतलब कम से कम 3/4, अगर पूरा नहीं तो ज़्यादातर स्टेट्स इसको लागू कर दिए होते मॉडल पुलिस एक्ट, और हमारे पास पूरे हिंदुस्तान के लिए एक पुलिस एक्ट हो जाता। अब देखिए, ब्रिटिशर्स ने 1857 के गदर के बाद पुलिस एक्ट बनाया, और क्यों एक्ट बनाया? उन्होंने कहा कि हमको एक ऐसी फोर्स की ज़रूरत है जो हमारी सत्ता को देश में सुदृढ़ कर सके, और अगर कोई चुनौती इस तरह एक देशव्यापी चुनौती आती है तो उसका दमन करने में ये फोर्स हमारे काम आएगी। और उस समय के आप मिनट्स पढ़ें तो उस मिनट्स में साफ साफ लिखा है कि हमें एक ऐसी फोर्स चाहिए जो पॉलिटिकली यूज़फुल, राजनीतिक दृष्टि से हमें लाभप्रद हो। इस उद्देश्य उन्होंने बनाया था। इसीलिए मैं कहता हूँ कि 1861 का एक्ट तो सबसे बड़ा कॉलोनियल राज्य का पुलिस विभाग में एक गले की चक्की है, एक उसका कॉलोनियलिज्म का प्रतीक है। उसको हम तो छुड़ाने, उसको तो हम फेंक नहीं रहे हैं, उसको तो कूड़ेदान में डाल देना चाहिए। और पर मतलब अब आपने जो इतना समय जो गंवा दिया उसका नतीजा क्या हुआ? बाकी राज्यों ने इस आधार पे कि सुप्रीम कोर्ट ने निर्देश दिया है कि एक एक्ट बनाइए, नहीं, सुप्रीम कोर्ट का निर्देश ये था कि या तो आप हमारे निर्देशों के अनुसार एक नया एक्ट बनाइए और या तो हमारे निर्देशों का पालन करिए। अब राज्य सरकारें तो इतनी चालाक हैं, क्या कहा जाए, मतलब ज़रूर से ज़्यादा चालाक हैं। उन्होंने सोचा कि अगर हम एक्ट बना देंगे तो हम सुप्रीम कोर्ट के सुपरविजन से, पर्यवेक्षण से बाहर हो जाएंगे। तो उन्होंने एक्ट बनाए, और एक्ट बनाने के पीछे नियत ये थी कि जो वर्तमान व्यवस्था है उसको कानूनी जामा पहना दो। ऐसा नहीं कि सुप्रीम कोर्ट के आदेशों का पालन करना था। जो वर्तमान व्यवस्था है, जो हमें सूट करती है, जो कॉलोनियल व्यवस्था चल रही है, इसको कानूनी जामा पहना दो, और वही वो काम कर रहे हैं। तो नतीजा अब ये हुआ कि देखिए, ब्रिटिश सरकार में इतनी दूरदर्शिता थी, वो पूरे भारत देश में जहाँ भी उनकी सत्ता थी वहाँ पे वो चाहते थे एक एक्ट लागू हो, और एक एक्ट उन्होंने बनाया। अब कहने में बड़ी शर्म आती है, बड़ा दर्द होता है, पर उन्होंने 150 साल पहले ज़्यादा दूरदर्शिता दिखाई बजाय हमारे आज जो हम आज कर रहे हैं। अब मेरा अंतिम निवेदन, भारत सरकार बात कर रही है और बहुत सही बात कर रही है। क्या? 1 नेशन 1 इलेक्शन, बहुत सही बात कर रही है। इससे कितनी बचत होगी। आप राज्यों में जाइए राज्य के पुलिस अधिकारियों से बात करी, कहे सर मुसीबत है, साल भर इलेक्शन होता रहता है, कोई ना कोई इलेक्शन होता रहता है, साल भर होता रहता है, एक इलेक्शन से छूटो दूसरा, कहीं पंचायत, कहीं जिला कहीं मेट्रोपॉलिटन काउंसिल का, कहीं किसी का, कहीं असेंबली का, बाई इलेक्शन। आप एक इलेक्शन, वन नेशन वन इलेक्शन करके बहुत अच्छा काम कर रहे हैं। हम आपको इसके लिए बधाई देंगे और हम चाहेंगे कि इसको जितनी जल्दी, मतलब कितना भी विरोध हो, इसको आप जरूर लागू करिए। परंतु इसके साथ साथ हम ये भी कहेंगे, वन नेशन वन पुलिस क्यों नहीं? ब्रिटिशर्स ने तो वन नेशन वन पुलिस रखा था और हमने वन नेशन मिनी पुलिस कर दिया। मतलब ये कितना विरोधाभास है। देखिए, हम लोग जब पुलिस सुधार की बात करते हैं तो ऐसा नहीं कि हम देश को कमज़ोर करना चाहते हैं, हम देश को और सशक्त बनाना चाहते हैं। और ये जो विरोधाभास हमारे अकर्मण्यता से कहिए या उसको नेग्लेक्ट करने से हुआ है, इसको अभी भी अगर आप दूर करने की कोशिश करें तो शायद समय है। इन सवालों के साथ और इन निवेदन के साथ मैं अपनी बात समाप्त करूंगा। धन्यवाद।
धन्यवाद सर। आपकी विनम्रता और सेवा भाव युवा पुलिस अधिकारियों के लिए उल्लेखनीय है। हम आशा करते हैं कि सभा में उपस्थित अतिथियों को आपके शब्दों से प्रेरणा मिले। अब मैं माननीय मंत्री श्री से अपने आशीर्वचनों से सभा को संबोधित करने का आग्रह करता हूं।
इंडियन पुलिस फाउंडेशन द्वारा आयोजित ये कार्यक्रम, इसका नाम है 10th IPS फाउंडेशन डे, और साथ में एक नाम और रखा है, पुलिस रिफॉर्म्स डे। तो पुलिस रिफॉर्म की बात तो अच्छी तरह से हुई है अभी ना, हाँ काफ़ी अच्छी हुई है। और प्रकाश सिंह जी ने तो पूरा इसी पे जोर दिया है। मैं आपका आज फंक्शन का मतलब ही ये था, 10th IPS फाउंडेशन डे एंड पुलिस रिफॉर्म्स डे 2024। इस अवसर पर सजा हुआ मंच और मंच पर उपस्थित हमारे श्री प्रकाश सिंह जी, जो BSF के भी DG रहे, DGP असम और DGP उत्तर प्रदेश भी रहे, और इस पदों के अलावा इनका जो बड़ा योगदान है, जो हमारे ध्यान में आता है कि हमारे यहाँ पुलिस रिफॉर्म को लेकर के नेशनल पुलिस कमीशन भी बना 77 में, पद्मनाभैया कमेटी भी बनी 2000 में, और रिव्यू कमेटी सेटअप हुई MHA की 2004 में। फिर कुछ चैप्टर कुछ हुआ NN वोहरा कमेटी ने भी 1993 और 4 में। लेकिन जो प्रकाश सिंह जी की PIL थी, प्रकाश सिंह वर्सेस यूनियन ऑफ इंडिया, जिसने जो पुलिस रिफॉर्म में प्रभाव डाला, ऐसा किसी ने नहीं डाला। इसलिए आपकी हम बड़ाई भी करते हैं और आपको बधाई भी देते हैं। अवार्ड सही दिया, जोरदार ताली बजा दीजिए आप। अवार्ड तो सही दिया आपने, अवार्ड सही था ना, इनको देने वाला अवार्ड तो अच्छा था ना। लेकिन मुझे लगता है कि एक अवार्ड इनकी पत्नी को भी देना चाहिए, जिनका जिक्र इन्होंने किया। आप भूल गए शायद, आप भूल गए क्या? याद है ना? हाँ, याद रखना पड़ेगा ओम जी आपको। हाँ, तो पत्नी को भी अवार्ड कब देंगे आप, अगली बार ध्यान रखना। और वैसे तो आज दिन भर का कार्यक्रम है, आप शाम का समापन के समय भी दे सकते हैं, ताकि दोनों काम पूरे हो जाएंगे। अगर ये नहीं, ये तो छोड़ ही रहे थे ना सर्विस, इतने बड़े आदमी थोड़ी बनते, सर्विस छोड़ के बन के लेखक बनते, क्या बनते कुछ पता नहीं है। लेकिन आज तो जब आपका नाम आता है तो पुलिस रिफॉर्म के साथ जुड़ता है कि नहीं जुड़ता है। इनका आर्टिकल भी बहुत पढ़े हमने। तो इसके लिए मैं तो कहूँगा आपको कि अगर श्री प्रकाश सिंह जी की पत्नी अगर यहाँ दिल्ली में हैं और आ सकती हैं तो मुझे तो लगता है कि श्याम का अवार्ड दे देना चाहिए। मैं एक डिलॉयट कंपनी में श्याम को जाऊंगा कोई कार्यक्रम में, मैं दोबारा कर सकता हूं इसको अवार्ड को देने के लिए, नहीं तो पूरा ही नहीं होगा ये अवार्ड, पूरा ही नहीं होगा ये अवार्ड। यहाँ है, कहाँ है? दिल्ली में है तो श्याम को कंक्लूडिंग सेशन में बुलाइए, इन दोनों को एक साथ दीजिए ना, और दोनों से एक दूसरे से माला भी पहना दीजिए, क्या फर्क पड़ता है। कितना शानदार इन्होंने इसको एक्सेप्ट किया। ये भी कह सकते थे कि मेरी दृढ़ इच्छा थी मैं पुलिस में रहा, नहीं, इन्होंने कहा मेरी इच्छा तो इधर उधर हो रही थी, मेरी पत्नी की दृढ़ इच्छा थी कि आप अभी जल्दी में निर्णय मत लो। तो पत्नी के लिए जोरदार ताली बजाओ भाई। नहीं, बड़ा काम किया। वो नाम क्या पत्नी क्या है? सावित्री जी के लिए दोबारा सावित्री जी के लिए भी बजाइए जोरदार। और मैं तो चाहूंगा कि अवार्ड दे दें आप, ठीक रहेगा। कहाँ? ओ अच्छा, ठीक, समझ गया। अरे नहीं, खड़े नहीं रहना, अब इनको कहो आप तो लेके आओ जी शाम को। नहीं, कितना बड़ा काम है। नहीं, एक्सेप्ट नहीं करते हैं जी। मैं भुक्तभोगी हूँ जी, मैं भुक्तभोगी हूँ कि जनरली लोग जब सफल होते हैं तो ये कहते हैं कि मेरी मेहनत, कई बार लक को कह देते हैं मैं लकी था या भाग्य ने साथ दिया, कई बार और किसी को कह देते हैं, कई बार माँ बाप को भी कह देते हैं, कई बार गुरुजनों को भी कह देते हैं, लेकिन पत्नी का नाम तो कोई लेता भाई। जबकि पत्नी का भी योगदान बड़ा होता है, और मेरी लाइफ में तो बहुत बड़ा है। मैं तो यहाँ आज अगर मंच पे खड़ा हूं तो मेरी पत्नी के कारण ही खड़ा हूं, लो ये और कह देता हूं। इसलिए किताब लिखी है मैंने पत्नी पे। मैंने जो जिक्र आया ना कि लेखक है, मैं लेखक नहीं हूं, मैंने पत्नी पे किताब लिखी है, एक सफर हम सफर के साथ। ये हमारा सफर है जीवन का। कहाँ कहाँ प्रॉब्लम आई, कैसे हमारे पार्टनर ने हमारी मदद की। तो ये एक तो बहुत अच्छा चैप्टर आपने छेड़ा है। अगर हो सके तो श्याम का ही करे तो ठीक रहेगा, मेरे कैसा लगता है। हमारे चेयरमैन साहब RS मूसहरी साहब और हमारे प्रेसिडेंट रामचंद्रन जी, ये तो घर पे आए थे शायद, और हमारे DC जैन साहब राजस्थान से ही हैं, आप भी घर पे आए थे, और भी घर पे थे, यहाँ इस कुमार जी भी थे, आप भी थे, गर्ग साहब भी थे, हमारे कुमार साहब भी बैठे हैं राजस्थान। सुधीर प्रताप सिंह जी कहीं नजर आ रहे थे, किधर हैं सब? हैं? नमस्कार सर बैठिए, आगे आ जाओ ना सर। हैं? नहीं, आगे आना ठीक रहेगा ना सर। ये सुधीर प्रताप सिंह जी एक जिले में SP थे। आइए सर, आइए। राजीव प्रताप रूडी है ना, मंत्री भी हैं हमारे साथ, MP भी हैं, उनके भाई हैं, आपको जानते तो होंगे ही ना। और मैं एक जिले में काम करता था, वहाँ ये SP भी थे, इसलिए मैंने आगे बुलाया है। प्रणाम आपको। आपकी जोड़ी जोरदार थी, गलुंडिया साहब की और आपकी, शानदार जोड़ी भी रही। अब थोड़े आप स्पिरिचुअल भी हो गए हो, कई दिनों से देखा है, अच्छी बात है, होना भी चाहिए। सबको जो इस सभागार में आए हैं, सबको मैं, जितने भी वरिष्ठ हमारे इंडियन पुलिस सर्विस के साथी हैं, डायरेक्टर्स जनरल्स आए हैं, सब स्टूडेंट भी हैं बहुत बड़ी मात्रा में, सबको नमस्कार प्रणाम, और पत्रकार साथी भी हैं। देखिए, मैं लिख के तो कुछ और लाया था, लेकिन मुझे सब्जेक्ट और दे दिया, तो एक सब्जेक्ट तो मैंने टच कर लिया, पत्नी वाला। दूसरा सब्जेक्ट एक और टच कर रहा हूं मैं, शेक्सपियर वाला। मैं कोई बहुत विद्वान आदमी नहीं हूँ अंग्रेजी का। मैं तो बहुत ग्रामीण परिवेश से आया हूँ। मैंने 6th क्लास में ABCD सीखी है। तो मैं बहुत शेक्सपियर बहुत बड़ा विद्वान रहा होगा, लेकिन एक चीज़ शेक्सपियर की मेरे को बहुत अच्छी लगी जो मैं यहाँ जिक्र करना चाहूँगा। शेक्सपियर ने कहा कि जो जीवन है मनुष्य का, ये हारमोनियम की तरह है। हारमोनियम जिसने देखा होगा, उसके कई स्वर होते हैं। ये जीवन हारमोनियम की तरह है, इसमें अलग अलग स्वर हैं। अगर बजाने वाला शानदार है तो स्वर अच्छा निकलेगा, और बजाने वाला ठीक नहीं है तो स्वर बेसुरे निकलेंगे। हमारे प्रकाश सिंह जी शानदार हारमोनियम बजाने वाले थे, इसलिए पुलिस के स्वर भी शानदार निकले, सुहावने निकले। इसलिए जीवन के बारे में इन्होंने दर्शन दिया। ये जीवन का दर्शन है। भारतीय दर्शन में भी बहुत से महापुरुष हुए जिन्होंने जीवन का बताया, जीवन है क्या। लेकिन हारमोनियम में अलग अलग स्वर हैं। जीवन में भी आपको अलग अलग तरह के लोग मिलेंगे, और पुलिस ऑफिसर से तो अलग अलग तरह के लोग टकराएंगे। अपराधी भी टकराएगा, राजनेता भी टकराएगा, अच्छा आदमी भी टकराएगा, साधु भी टकराएगा। लेकिन आप सबसे समन्वय स्थापित करके स्वर कैसे अच्छे निकालते हो, वही ऑफिसर अच्छा कहलाता है। कब रहे होंगे सुधीर प्रताप सिंह जी गंगानगर में? आज भी जाइए, सुधीर प्रताप सिंह जी का एसपी के नाते आज भी श्री गंगानगर में लोग नाम लेते हैं जी। आज भी नाम लेते हैं। कितने शानदार एक ऑफिसर थे एसपी। मैं जब कभी जाता हूं तो मुझे पूछते भी हैं कि वो रूडी जी के भाई कहां हैं आजकल। तो ये क्या कहलाता है जी? ये कहलाता है कि खुशबू आप छोड़ रहे हो। आपने जहां काम किया उसकी खुशबू आप छोड़ रहे हो। ये खुशबू ही महत्वपूर्ण है, यही जीवन है। लेकिन आपने मुझे टॉपिक दिया न्यू क्रिमिनल लॉज का, और पुलिस के साथ क्या इसका संबंध, कैसे संबंध, ये विषय तो है ही। आपका संबंध तो रहेगा ही, क्योंकि आपने कहा इन्वेस्टिगेशन, प्रोसिक्यूशन एंड जुडिशरी, 3 ऐसे स्तंभ है जिसके कारण ये विषय चला। हमारे बहुत से यहाँ विषय आए कि लॉ डेटरेंट होना चाहिए, रिफॉर्मेटिव होना चाहिए। ये तो कैपिटल पनिशमेंट को लेकर के तो पता नहीं, जब से सभ्यताएं विकसित हुई है तब से विवाद है कि कैपिटल पनिशमेंट से अपराध रुकते हैं या नहीं रुकते। इट्स ए डिबेटेबल टॉपिक, आज भी है। किसी जमाने में ज्यादा था कैपिटल पनिशमेंट, लेकिन अब कुछ लोग आ गए एक रिफॉर्मेटिव कि हम आदमी को सुधार भी सकते हैं। अब कब सुधारोगे आदमी को? कुछ लोग कहते हैं सुधर सकता है, कुछ कहते हैं नहीं सुधर सकता। ये डिबेटेबल है। क्यों डिबेटेबल है? कि हम मनुष्यों से डील करते हैं। जैसे कोई ह्यूमन बॉडी है, उसके मोटे मोटे 4 पार्ट हैं। जैसे हमारा शरीर ये दिखता है, इसको हम फिजिकल बॉडी बोलते हैं। इसके अंदर एक और शरीर है जिसको हम एस्ट्रल बॉडी बोलते हैं। जो संसार दिखता है ये फिजिकल वर्ल्ड है, लेकिन एक और संसार है जिसको हम एस्ट्रल वर्ल्ड बोलते हैं। तो हम जो बॉडी लिए यहाँ इस संसार में, जिसका जिक्र हमारे प्रकाश सिंह जी कर रहे थे कि हमें मानव शरीर मिला, इसमें 5 ज्ञानेंद्रियां हैं और 5 कर्मेंद्रियां हैं। ज्ञानेंद्रियों से हमें ज्ञान मिलता है कि ये पीपल का पेड़ है, ये नीम का पेड़ है, इस घर में हलवा अच्छा बन रहा है। ये ज्ञानेंद्रियां बताती हमें, सुगंध आने से, स्वर अच्छा निकल रहा है, सुनने से। कर्मेंद्रियां भी 5 है हमारे पास, जिससे हम कर्म करते हैं। लेकिन इसके अंदर हम झांकते कम हैं। जैसे अंदर झांकेंगे तो इसके अंदर एक मन है, जिसको बहुत से विद्वानों ने फिजिकल माइंड कहा है, जो ज्ञानेंद्रियों और कर्मेंद्रियों के साथ भी है, और इंटरनल पार्ट हमारा ऑर्गन जिसको हम इंटेलेक्ट बोलते हैं और सोल बोलते हैं, उसके साथ भी उसका संबंध है। तो मन की ओर हम पहुंचते ही नहीं है, कम पहुंचते हैं। लेकिन हम शरीर की खुराक के लिए खाना खाते हैं, कपड़ा पहनते हैं, एसी चलाते हैं, कपड़े ओढ़ते हैं, ये शरीर की खुराक है। मन की खुराक के लिए भी हम काम करते हैं। आज जो ये फाउंडेशन का काम है, इसमें शरीर की खुराक कम है, हो सकता है खाना रखा होगा, आपने रखा है क्या खाना, तो वो शरीर की खुराक है। लेकिन यहाँ बैठे हैं, यहाँ खाना नहीं मिल रहा है, यहाँ आपको मन की खुराक मिल रही है। आप मित्रता भी आपके मिल रही है, मन की खुराक मिल रही है, मन को अच्छा लग रहा है, भाई होना चाहिए आईपीएस रिफॉर्म डे और ऐसे आईपीएस एसोसिएशन फाउंडेशन बनाए तो अच्छा है, ये मन की खुराक है। लेकिन जैसे ही हम मन के आगे चलते हैं तो एक इंटेलेक्ट करके हमारे पास एक ऑर्गन आता है। इंटेलेक्ट क्या करता है कि वो विजडम देता है हमें कि हम जो काम कर रहे हैं वो सही कर रहे हैं, गलत कर रहे हैं। डिसीजन मेकिंग प्रोसेस में इंटेलेक्ट का बहुत बड़ा रोल है। लेकिन इंटेलेक्ट जब विवेक से संचालित होता है तब हम अच्छा निर्णय लेते हैं, और जब वो विवेक से संचालित नहीं होता और हमारी आत्मा पे कोई राख आ जाती है, और आत्मा जब रिफ्लेक्ट नहीं करती है, इंटेलेक्ट को प्रकाश नहीं देती है, इनका नाम भी प्रकाश ही है ना, हाँ, प्रकाश नहीं देती है, तो निर्णय सही नहीं होते। अब इनकी आत्मा ने भी प्रकाश दिया और इनकी पत्नी ने भी प्रकाश दिया, तो इनका निर्णय सही हुआ, पुलिस में ही रहो। ये सिस्टम है हमारा डिसीजन मेकिंग प्रोसेस का। यहां अगर वो चारों स्तर पे आदमी जीता नहीं है तो कुछ भी निर्णय सही नहीं हो सकता जी। मैं एक उदाहरण देता हूं, दो उदाहरण देता हूं। डीसी जैन साहब बैठे हैं, एक जैन समाज के धर्म गुरु हैं आचार्य मासरमण जी। वो मेरे घर रुके, ये 5A कामराज मार्ग। उनको राष्ट्रपति जी से मिलना था, तो राष्ट्रपति जी से मिलने के लिए उन्होंने कहा मैं आपके घर रुकूंगा तो ठीक रहेगा, नजदीक है राष्ट्रपति भवन, पैदल चलते हैं। वो जैन साधु हैं, पट्टी लगाते हैं, सफेद कपड़े पहनते हैं, आपने भी कई सड़कों पे चलते हुए देखे होंगे। अब उनके साथ 100-150 आदमी जैन समाज के महत्वपूर्ण लोग, जो बड़े बड़े इंडस्ट्रियलिस्ट भी, वो भी पैदल चल रहे थे। मेरी भी इच्छा हुई मैं भी साथ चलूं, मैं मंत्री। तो हम हमारे घर से निकले और ये कृष्णा मेनन मार्ग वाला चौराहा, क्या नाम था चौराहे का, चौराहे, वहां एक सब इंस्पेक्टर आता है साहब हमारे पास, दिल्ली पुलिस का। ये थोड़ा बैड इवेंट है, एग्जाम्पल है, अच्छा भी दूंगा एक। तो वो आता है, वो कहता है जी कहां जा रहे हो। तो मेरी ये पगड़ी करीब करीब लोग जानते हैं कि यार ये तो मंत्री हैं। उसने कहा आइडेंटिटी कार्ड कहां है। तो मैंने कहा आइडेंटिटी कार्ड तो घर भूल ही है यार, लेकिन मुझे देख लो यार मैं मंत्री हूं। बोला ऐसे नहीं मानता मैं मंत्री। तो मैंने देखा यार इनके तो कोई और ही झगड़ा है, कोई क्या करें अब इसका। अब उसके मन में ये आया होगा कि पुलिस ऑफिसर और बड़ा होता होगा, मंत्री क्या कर। मैंने कहा ये महाराज हैं, ये सबसे बड़े हैं मेरे यहाँ, तो अभी आए हुए हैं, ये निकल रहे हैं राष्ट्रपति भवन जा रहे हैं और इनका यही रूट है। बोला नो। मैंने कहा यार अभी तो 9-9:30 बजे तो किसी से बात हुई है, कोई लेडी ऑफिसर थे डीसीपी, उससे उसने कहा रूट तय है। उन्होंने कहा 10 बजे तक किसी और की ड्यूटी थी, 10 बजे किसी और की ड्यूटी होगी, मेरी ड्यूटी है, मेरे पास कोई ऑर्डर नहीं है। तो हमने उनको पूछा, जो जैन समाज के लोग साथ चलते थे, अरे यार किसी के पास कागज है क्या, ये मेरा पीएस है या आरपीएफ का। ये भी, मैंने कहा यार तू भी बात कर, ये डीआईजी रैंक का आदमी है, अब आईजी बनने वाला। मैंने कहा तुम भी बात कर भाई, राजीव को कहा, इसने भी बात करी। उसने कहा ऐसे कई डीआईजी देखे मैंने, मैं डीआईजी देखता रहता हूं। बोला यहाँ डीआईजी आईजी सब देखता हूं मैं, आप कागज लाइए। अब बड़ा समस्या हो गई, मैंने कहा कागज कहां लाए। तो हमने कहा राष्ट्रपति भवन बात करो भाई। तो हमने राष्ट्रपति भवन बात की। उन्होंने कहा इनका तो रूट तय है, कागज दिया हुआ है। तो मैंने कहा भाई उसकी कॉपी भेजो। ये आदमी है कि नहीं मान रहा भाई, क्या करें। तो आपको पता है मैं केंद्र का मंत्री, वो एक धर्म संघ है जिसको हम 13 पंथ धर्म संघ बोलते हैं, उसके आचार्य, उनके साथ एक हमारे मोमा सर, एक हमारा बीकानेर पार्लियामेंट्री कॉन्स्टिट्यूंसी का गांव है, उसके बहुत बड़े सेठ जिसको केएलजे बोलते हैं, यहाँ दिल्ली वाले भी जानते हैं, केमिकल में बहुत बड़ी फैक्ट्री है। केएलजे स्पॉन्सर है क्या? हाँ ये रे केएलजे ग्रुप। इन्होंने भी खूब कहा कि मैं बहुत बड़ा आदमी हूं भाई, मेरे ऐसे कई काम करते हैं आपके जैसे सिक्योरिटी में। उन्होंने कहा कुछ नहीं जाने दूंगा। अब मैंने कहा फंस गए भाई, अब क्या करें इसको। मैंने कहा यार तुम पुलिस जैसा ही लग रहा है, आरपीएफ तो पुलिस का ही होता है आधा आदमी। डीजी साहब बैठे हैं, बुरा मत मानना। मैंने कहा यार तू तेरी ड्रेस में आ जाता या तो उसने कहा मैं, इसके पास आइडेंटिटी कार्ड था, आइडेंटिटी कार्ड भी दिखाया, नहीं माना जी। अब मैंने कहा क्या करें भी, अब तो बड़ा मुश्किल हो गया। रोक के लिया जी उसने तो, और आते जाते लोग देखे कि मंत्री जी कैसे खड़े हो। मैंने कहा ऐसे ही खड़ा हूं यार, अब बेइज्जती भी हो भाई, पुलिस ने रोक दिया, हमारी सरकार भी है। तो मैंने कहा क्या करेंगे, तो फंस गए, उल्टा फंस गए हैं उल्टा फंस गए। तो हमने कहा नहीं महाराज रुक गए, कोई काम है, क्या करें, फिर कवर अप करना पड़ता है। इतने में वहां से कोई मैसेज आया किसी बड़े अधिकारी को कि भाई ये कौन आदमी है जिसने रोका है। तब जाके हलचल हुई, और फिर हमने देखा क्या कुछ हो रही है। इसने कहा सब कुछ हो तो रही है, और मुझे किसी दूसरी मीटिंग में जाना था। तब जैसे हलचल शुरू हुई भी रवाना हो गए, तो मैं निकला। फिर भाई मेरे को तो गुस्सा आना ही था स्वाभाविक रूप से। मैंने इधर उधर फोन किए, फिर तो वो लेडी आपके डीएसपी कौन थी वो भी आई, फिर तो सीपी का फोन भी आया, फिर राष्ट्रपति भवन से जो पुलिस देखते हैं उनका भी आया। लेकिन साहब वो ऐसा आदमी था कि वो नहीं आया जी मेरे पास, सारे आगे, और उसकी सिफारिश करने वाला और आगे कि इसकी गलती नहीं है साहब, इसके पास ऑर्डर नहीं था। अरे यार मैं कह रहा हूं मैं मंत्री हूं, रूट तय है, इतना बिहेवियर मतलब चेंज नहीं कर सकते, इतनी ट्रेनिंग तो होनी चाहिए भाई, फर्स्ट कांटेक्ट होता है ना पुलिस का। अब दूसरा उदाहरण भी देता हूं आपको, एक दूसरा उदाहरण। मैं एक ट्रस्ट चलाता हूं, ये वंदना बेटी इसको पता होगा, भावना मेघवाल मेमोरियल ट्रस्ट, ये भी हमारे राजस्थान कैडर की है ना। तो एक ट्रस्ट चलाता हूं, उसमें हमने एक पुलिस कांस्टेबल को सम्मानित किया। तो मैंने ट्रस्ट के लोगों को कहा भी इसको सम्मानित क्यों करो, क्या ऐसा काम किया। मैं तो दिल्ली था, और जब उन्होंने सम्मानित लोगों की लिस्ट देखी तो मैंने कहा भी पुलिस कांस्टेबल कोई है भी यहाँ का नहीं, यूपी का है, इसको आप यहाँ क्यों सम्मानित कर रहे हो। क्या है कि एक हमारे गांव की कोई महिला हरिद्वार गई थी। हमारे यहाँ क्या सिस्टम होगा कहीं और जगह भी, परिवार में अगर डेथ होती है तो उनके फूल वगैरह लेकर के और हरिद्वार जाने का एक रिवाज है। तो ऐसा ही कोई ग्रामीण महिला थी, और वो अपने हस्बैंड के साथ थी। वो अपने पेरेंट्स की कोई डेथ हुई थी किसी की, तो फूल चुगने के लिए यहाँ और स्नान करने के लिए हरिद्वार आ गए। उसी समय कोई साधु आया, अब वो तो गांव के आदमी थे, पता नहीं थे कहीं स्नान करे, तो वो कह रहे हमारा घाट है। उनके साथ कोई सिक्योरिटी वाले थे, तो फटाफट इधर उधर किया मामला। तो वो पति अलग हो गया और पत्नी अलग हो गई, और वो महाराज को वहां स्नान करना था, टाइम था कोई। अब वो पत्नी ने देखा भी पति कहाँ, इधर उधर देखा, इतने में तो पुलिस और वो काफी लंबा चौड़ा मुलाजमा था, समझ में नहीं आया। वो पति अलग होकर के, और उसने देखा भी पत्नी कहाँ है। तो एक कोई महिला कोई गंगा नदी में कोई नहाई थी, तो डूब गई, तो उसको लगा कि भाई कहाँ है, एक लाश तो चल रही है। तो उसने देखा भी पत्नी चली गई होगी। तो वो बेचारा, उसका 2-3 घंटे के बाद टाइम था ट्रेन का, तो वो तो ट्रेन पे आ गया और रोते रोते वापस अपने गांव आ गया, बीकानेर आ गया। और उसके बाद उसने जाके यही कहा भी पत्नी तो वो गंगा नदी में चली गई, जबकि पत्नी गंगा नदी में नहीं गई जी, बच गई। बचने के बाद उसके पास कुछ नहीं, और वो ना हिंदी जानती ना अंग्रेजी जानती, मारवाड़ी जानती। अब मारवाड़ी भाषा में कोई जानकार नहीं। तो एक पुलिस का कांस्टेबल, यूपी पुलिस का, उसने देखा ये महिला बिछुड़ गई किसी से। अब यहाँ भी बिहेवियर देखना, बिहेवियर देखिए किसी पुलिस का कैसा बिहेवियर है, समाज सेवा का कैसा, कितना बड़ा संतोष का काम कर सकता है कोई पुलिस कांस्टेबल भी। उसने कहा ये तो बिछड़ गई ऐसा लगता है। उसने जाके बात की, तो उसके भी समझ में नहीं आई, बहुत लोकल डायलेक्ट गांव का, हमारे बीकानेर साइड का, जनरली हर किसी के समझ में नहीं है ऐसा डायलेक्ट बोले वो। बीकानेर उसके समझ में आ गया पुलिस कांस्टेबल को। उसको लगा तेरे पास कुछ पैसे वैसे हैं, तो उसने पैसे भी मना किया, कुछ नहीं है। तो उसने इशारा किया, वो समझ में आया। उसने कहा मेरे पास ये गहना है पहनने का, ये बोरला जिसको बोलते हैं ना, इसको बेच के और मुझे तो बीकानेर पहुंचा दो कैसी करके। उसने कहा भी ऐसा नहीं मैं काम करता। तो अब उसने क्या किया, उसने देखा कि पुलिस में रिपोर्ट दर्ज कराएंगे, क्या करेंगे, उसने अपना निर्णय लिया। यहाँ इंटेलेक्ट काम करता है। उस आदमी ने सोचा मुझे क्या करना चाहिए, तो सात्विक प्रवृत्ति का आदमी था, समाज सेवा पुलिस में रह करके भी वो कर सकता है, जैसे प्रकाश सिंह जी ने कहा। उसने कुछ नहीं किया जी, उसने कहा मेरे साथ चलो, तुम हमारी बहन हो आज से। तो उसको विश्वास नहीं हुआ थोड़ी, उसने देखा कोई गड़बड़ तो नहीं हो जाए, पुलिस का आदमी है। पर इतना तो पता था खाकी वर्दी है इतना, लेकिन ज़्यादा वो पढ़ी लिखी नहीं थी, बिल्कुल इलिटरेट थी, अंगूठा छाप जिसको बोलते हैं ना वो। लेकिन वो विश्वास करके, और क्या करती वो, विश्वास करके उसके साथ हो लिया। होली तो उसने रेलवे स्टेशन आई, तो उसको लगा रेलवे स्टेशन आया ये तो ले जा कहाँ रहा है, समझ नहीं आया। उसने कहा मैं बीकानेर ही ले जाऊँगा आपको, और मेरी ड्यूटी है, मैंने छुट्टी ले ली है। तो अभी उसका विश्वास नहीं हुआ कि भी इतना बड़ा काम ये क्यों कर रहा है। लेकिन उसने 2 टिकट ली, क्योंकि उसके पास तो पैसा नहीं था महिला के पास। उसने 2 टिकट ली बीकानेर की, बीकानेर आया। रेलवे स्टेशन पे उतरने के बाद टैक्सी वालों से पूछा कि इसका गांव इधर है, ये कोई बता रही है। तो टैक्सी जा नहीं सकती, उसमें कुछ टीबे, हमारा सैंड ड्यून्स का एरिया है, कुछ टीबे। तो उसने एक गाड़ी करी, गाड़ी करके उस महिला को गांव ले गया। तब तो गांव में तो वो माहौल था ना, भी पत्नी तो रही नहीं, और कोई पुलिस का कांस्टेबल लेकर के जावे पत्नी को, तो गांव में एक हर्षोल्लास का माहौल हो गया, भाई ये आ गई। तो ये कहां थी? तो उन गांव वालों ने कहा कि साहब आप ट्रस्ट में शादियां करते हो, हमारे परिवार में शादी है, नहीं तो हम शादी नहीं कर रहे थे, हम शादी को रिजेक्ट कर रहे थे, क्योंकि हमारे परिवार में तो डेथ हो रही थी। लेकिन जैसे ही पत्नी वापस आ गई तो हमने उस शादी को आपके ट्रस्ट में करने का मौका हम ले रहे हैं। लेकिन हम शादी तभी अच्छी कर पाएंगे कि वो पुलिस का कांस्टेबल जिसको हमारी पत्नी ने भाई बना लिया है, उसको लेके आओ। तब मैंने फ़ोन किया उसको और उसको बुलाया हमारे ट्रस्ट वालों ने। मैंने भी फ़ोन किया, धन्यवाद, वो आने से मना कर रहा था। मैंने कहा नहीं तुम आइए। हमने पूरे ट्रस्ट में, जहाँ हम 25-30 हज़ार लोग होते हैं, इतना बड़ा फंक्शन हमारा ट्रस्ट का होता है, उस पूरे मंच से यादव नाम का, राकेश यादव ऐसा कोई नाम का कांस्टेबल था, उसको हमने पूरे मंच से सम्मानित किया। वो भी तो उदाहरण है, अभी उसके लिए भी ताली बजा दीजिए। तो हम क्यों नहीं कर सकते जी समाज सेवा? यही जिक्र इन्होंने आज किया है। अब देखिए, एक विषय आपने छेड़ा कि शायद हम जल्दबाजी में या बिना कंसल्टेशन करके ये न्यू लॉज लिया है। ऐसा नहीं है प्रकाश सिंह जी। अगर मैं जिक्र करूं आपको, तो आप तो बहुत इन चीज़ों को जानकार हैं। बेज बरवा कमेटी बनी, उसने भी हमारे न्यूज़ लॉज में बात करी कि ये क्रिमिनल लॉ कॉलोनीज, ये उपनिवेशिक टाइम का है, कॉलोनियल लॉ है, इसको चेंज होना चाहिए। विश्वनाथन कमेटी बनी, उसने भी ऐसा कहा। मलीमत कमेटी बनी, उसने भी ऐसा कहा। माधव मेनन कमेटी बनी, उसने भी ऐसा कहा। वर्मा कमेटी बनी, उन्होंने भी ऐसा कहा। लेकिन कोई निर्णय नहीं ले रहा था जी, हाथ ही नहीं लगा रहे थे। और उसके बाद स्टैंडिंग कमेटी ऑन होम अफेयर्स ने 2005 में अपनी 111वीं रिपोर्ट दी, 2006 में 128वीं रिपोर्ट दी, और 2010 में 146वीं रिपोर्ट दी कि अंग्रेजों के जमाने बनाए हुए कानून है, इसमें चेंजेज आना चाहिए, टेक्नोलॉजी में भी बहुत बदलाव हो गया, चेंज करिए। नहीं कर पाए। 2019 में मोदी जी ने सोचा भी इतनी कमेटियां हो गई कि अब तब क्या कर रहे हो, तो 2019 से हम लगे हुए हैं। 2019 में जब गृह मंत्री हमारे अमित शाह जी बन गए, उन्होंने सभी राज्यों के मुख्यमंत्रियों को पत्र लिखा, सभी मेंबर ऑफ पार्लियामेंट्स को पत्र लिखा, सभी चीफ जस्टिस ऑफ द हाई कोर्ट्स को पत्र लिखा कि हम चेंज करेंगे भाई, आईपीसी, सीआरपीसी, एविडेंस एक्ट, आप सुझाव है तो दीजिए। जितने भी आपकी पुलिस एकेडमी है उनको पत्र लिखा, नेशनल लॉ यूनिवर्सिटीज है उनको पत्र लिखा। सबको पत्र लिखने के बाद जजेज को पत्र लिखे, चीफ जस्टिस ऑफ इंडिया को पत्र लिखा, आपका बीपीआरडी है उनको पत्र लिखा, कोई जगह आईपीएस ऑफिसर ने भी सुझाव दिए हैं, उनको भी पत्र लिखा। कोई हमने आपके सीमा सुरक्षा बल और जो हमारे आर्म्ड फोर्सेज हैं उनको भी पत्र लिखा। कोई जगह छोड़ी नहीं जहां पत्र नहीं लिखा, लेकिन सुझाव भी आए। इस समिति का मैं भी हिस्सा हूं, जिसमें गृह मंत्री जी इसकी समीक्षा कर रहे थे, मैं भी हिस्सा हूं एज ए लॉ मिनिस्टर। तो उसमें 18 राज्यों ने कहा परिवर्तन होना चाहिए, 6 यूटी ने कहा चेंजेज होने चाहिए, चीफ जस्टिस ऑफ इंडिया ने कहा यस नाउ इट इज द राइट टाइम टू चेंज द लॉज। उसके बाद 16 हाई कोर्ट्स के चीफ जस्टिस ने कहा, बाकियों ने जवाब नहीं दिया। 5 लॉ अकेडमी ने कहा चेंजेस होने चाहिए, 22 लॉ यूनिवर्सिटीज ने कहा, 22 लॉ यूनिवर्सिटीज ने चेंजेस होने चाहिए, 142 सांसदों ने कहा, लिखा तो सबको था, करीब 800 के आसपास सांसद हैं लोकसभा राज्यसभा मिला के, लेकिन 142 ने राइटिंग में कहा चेंजेस होने चाहिए। 270 एमएलएज, सारे एमएलएज जितने भी देश में हैं सबको लिखा, लेकिन 270 एमएलएज का पत्र है हमारे पास कि चेंजेस होने चाहिए, इट्स ए गुड मूव। और उसके बाद पब्लिक ने भी सुझाव दिए, जिसकी तो संख्या भी बहुत है। बीपीआरडी ने भी कहा चेंजेस होने चाहिए। और उसके बाद जब हम बिल लेके आए तो इसको इंट्रोड्यूस किया जब लोकसभा में, तो अपोजिशन की तरफ से क्या था कि साहब इसको कमेटी में भेज दीजिए, बुलडोज मत करिए। जो शब्द अब इन्होंने यूज किया ना, वही शब्द उन्होंने यूज किया, बुलडोज मत करिए, यू सेंड इट टू द कमिटी। तो हमारे राज्यसभा में होम अफेयर्स की जो कमेटी है, उनको एक्स आईपीएस ऑफिसर है ब्रजलाल जी, जो आजकल राज्यसभा के एमपी हैं, वो उसके चेयरपर्सन थे। आप ब्रजलाल जी को पूछना, हमने ब्रजलाल जी की कमेटी को उसको रेफर किया और ब्रजलाल जी ने सबको सुना जी। कोई ऐसा स्टेक होल्डर नहीं है जिसको नहीं सुना, सबको बुला के सुना, उनको अलग से टाइम दिया और सुनो। सुनने के बाद सुझाव आए, यूनिनिमस कमेटी में तो सारे एमपी होते हैं, तो हमने जब लाए तब एक दूसरा विषय आया हुआ था। ये नहीं था न्यू क्रिमिनल लॉ, मतलब ये विषय नहीं था। लोकसभा में राज्यसभा में एक दूसरा विषय आया था, संजय सिंह को सस्पेंड क्यों किया, वापिस लो। और थोड़ा ये एक विषय ये भी था कि उसको सस्पेंड कर दिया, हमें भी सस्पेंड कर दो, ऐसे कुछ विषय आए हुए थे। तो उसमें कुछ एमपी सस्पेंड उस पीरियड में ज्यादा हुए। तो जब ये आ रहा था, किसी ने ये नहीं कहा कि सरकार हरी में ला रही है, क्योंकि सबको पता था कि 40-50 साल से इसमें काम चल रहा है, सबको पता था। लॉ कमीशन ऑफ इंडिया ने तो कम से कम 50 साल पहले रिकमेंडेशन दी। ये जो कम्युनिटी सर्विस का विषय है ना, आज कम्युनिटी सर्विस न्यू लॉज में है, ये एल के अडवाणी जब गृह मंत्री होते थे, तब समिति ने, मलिमत कमेटी ने रिपोर्ट दी कि हमारे देश में कम्युनिटी सर्विस का कंसेप्ट है कि छोटा किसी ने अपराध किया, उसको क्यों सजा देते हो, तालाब साफ करा लो, तो कम्युनिटी सर्विस भी हो जाएगी और उसकी सजा भी निकल जाएगी, वो जेल नहीं जाएगा। दूसरे देशों में लागू है, लेकिन हमारे यहां लागू इसलिए नहीं कर रहे थे कि भाई ये तो कम्युनिटी सर्विस हो सकता है, इंडियन इथोस, भारतीय दर्शन, भारतीय सनातन, उसमें जोड़ दिया उन्होंने। मोदी जी ने कहा नहीं, ऐसा नहीं चलेगा भाई, ये रिपोर्ट इतनी पुरानी है, क्यों नहीं कर सकते। और उन्होंने सब जगह का, हर धर्म में भी है, हर जगह भी है। जैसे सिख धर्म में कार सेवा का बड़ा महत्वपूर्ण विषय है, वो क्या है, वो यही है कि छोटा अपराध किया, कार सेवा करो और माफ आपको, लेकिन कम्युनिटी सर्विस है, काम भी होता है। तो ये कंसेप्ट आया कम्युनिटी सर्विस का, तो बहुत लंबे समय से चल रहा था। उस समय एमपी जब सस्पेंड थे लोकसभा में तो कम थे, राज्यसभा से ज्यादा थे, क्यों, संजय सिंह राज्यसभा में था। अब क्या हुआ, इन्होंने देखा यार ये तो बहुत बड़ा चेंज है, मोदी जी इससे अमर हो जाएंगे, इतना बड़ा चेंज लाए, क्योंकि जो चेंज आया है ना, ये चेंज ये है बड़ा, उससे उनको डर लग रहा है। क्या, ई प्रिजन प्लेटफॉर्म, ई फॉरेंसिक प्लेटफॉर्म, ई प्रोसिक्यूशन प्लेटफॉर्म, ई कोर्ट, और इसको टोटल जोड़ते हैं तो CCTNS बोलते हैं इसको, क्राइम एंड क्रिमिनल ट्रैकिंग नेटवर्क सिस्टम। इस सिस्टम से उनको लगा कि मोदी जी अमर हो जाएंगे, बोला विरोध करो। तो हमें गृह मंत्रालय जी ने कहा, गृह मंत्री जी ने, और गृह मंत्रालय से हमें भी टास्क मिली लॉ एंड जस्टिस को, आप वर्कशॉप करो। तो हम वर्कशॉप करेंगे, सब जगह वर्कशॉप की हमने, 8-10 जगह की, साउथ में भी की। वहां से फिर हमारे 1-2 वकील हैं जो हर मोदी जी के एक्शन को विरोध करते ही हैं। आप 2-3 नाम जानते, मैं नाम नहीं लेना चाहता, मेरे पास एप्लीकेशन लेके भी आए कि इसको आप डेफर करो, टाइम दो। हमने कहा क्यों भाई, इतना टाइम दे दिया, आप क्यों दें। कहने आपका साउथ में विरोध होगा, तो हम तो चेन्नई में वर्कशॉप करके आए। मैंने कहा आप कई दिन BNS बोल लो भाई, भारतीय न्याय संहिता नहीं बोलना है तो BNS बोल लो। लेकिन अब उनके यहां से डिमांड क्या आई है, एक ही डिमांड आई है कि इसका तमिल में भी अनुवाद कर दो। तो मैं आपको बताना चाह रहा हूं कि ये जो IPC की जगह भारतीय न्याय संहिता, CRPC की जगह भारतीय नागरिक सुरक्षा संहिता और इंडियन एविडेंस एक्ट की जगह भारतीय साक्ष्य अधिनियम, इनका जो लीगल भाषाएं हैं जहां अनुवाद होता है, या जिनको हम, जैसे तमिल में भी, तमिल में कोई बहस कर सकता है कोर्ट में, ऐसे तेलुगु भी है, ऐसे बंगाली भी है, ऐसे पंजाबी भी है। तो अब ऐसे हम सारे भारतीय भाषाओं में ये जितनी भी किताबें हैं हमारी, भारतीय न्याय संहिता, भारतीय नागरिक सुरक्षा संहिता, भारतीय साक्ष्य अधिनियम, इन तीनों का भारतीय भाषाओं में अनुवाद कर रहे हैं। और जैसे हमने कहा हम तमिल में भी कर रहे हैं, वो राजी है, दे आर हैप्पी नाउ। एक्सेप्ट भी कर लिया और हैप्पी। अब जीरो एफआईआर, जीरो एफआईआर क्या है? डीजी साहब बैठे हैं, आरपीएफ, आपसे संबंधित एक उदाहरण है, इसलिए आप थोड़ा बुरा मत मानना। ये हमारे कमेटी के सामने है। एक महिला, वो ट्रेन में फर्स्ट एसी में यात्रा कर रही थी, उसका पर्स चोरी हो गया। वो एक स्टेशन पे जागी, स्टेशन भी बड़ा था, तो उसको लगा मेरा पर्स और सामान भी कीमती था। जैसे वो कहती है कि 50 लाख से 60 लाख के बीच में सामान था उसका, गहने वगैरह थे, किसी शादी में जाना था। अब वो चोरी हो गया। वो नीचे उतरी स्टेशन, उसने कहा मेरा तो पर्स चोरी हो गया, मैं यात्रा कैसे करूं? तो उन्होंने कहा आप जीआरपी में वो एफआईआर दर्ज कराइए। वो जीआरपी में गई थाने। जीआरपी ने कहा कि आपका पर्स चोरी कहाँ हुआ था? तो उसने कहा ये तो मुझे पता नहीं है। तो पता कब चला? कि पता तो इसी स्टेशन के आसपास पता चला, कोई आवाज़ आ रही थी, कुछ कोहरे थे, तो मुझे लगा, तो मैंने देखा कि नहीं, आपको ये अगर पता नहीं है कि आपका चोरी पर्स कब हुआ, तो हम एफआईआर दर्ज नहीं करेंगे, क्योंकि हमारा जुरिस्डिक्शन नहीं है। हमारा जुरिस्डिक्शन तो बोला आप नींद में थे क्या? तो आप पता करिए आरपीएफ से कि आपका पर्स चोरी कब हुआ। तो उसने कहा आरपीएफ इसमें क्या करेगा? तो उसने कहा हम तो नहीं करेंगे, तो नहीं करा। वो संभ्रांत घर की महिला थी, वो लड़ने की मूड में थी, वो हमारे तक आई ना, तो वो गई आरपीएफ में। आरपीएफ ने कहा नहीं, आपके अगर सुरक्षा का मामला होता ना तो हम कुछ आपकी मदद करते हैं, ये तो आपका पर्स चोरी हो गया, अब इसमें हम कुछ नहीं कर सकते, इसमें जीआरपी करेगा। तो वो फिर जीआरपी गई, उसने कहा हम नहीं करेंगे, आप ये बताइए कहाँ हुआ था आप पर? वो कब नींद में थी। बोला नींद में बताना पड़ेगा कहाँ हुआ, नहीं तो नहीं करेंगे। उसका नहीं हुआ साहब एफआईआर दर्ज। और फिर वो कोर्ट में गई, तो कोर्ट ने भी कहा भाई ये तो प्रोसीजर है, उसको फॉलो करो। उसने कहा फंस गए, अब तो क्या करें। इस पीरियड में ये हमारी कमेटी चल रही थी, वो आ गई हमारे पास कि मैं एक शानदार आपको मेरा वाक्य सुनाना चाहती हूँ। सुनाया। ये जीरो एफआईआर में इसलिए लाए। अब किसी महिला के साथ कोई हादसा नहीं हो, खैर ना पर्स चोरी होना चाहिए, नहीं होना चाहिए, लेकिन अगर हो गया तो किसी स्टेशन पे जाने की जरूरत नहीं है, सीधे अपने घर जाएगी और ऑनलाइन जीरो एफआईआर दर्ज करा देगी। सुविधा हुई कि नहीं हुई बताइए मुझे। यही चेंजेस हमने किए हैं, यही चेंजेस हमने किए। मैं एक डिस्ट्रिक्ट में कलेक्टर था, अब आप ही ऑफिसर रहे वो हो, अभी तो जाते होंगे कोर्ट में, कोई कोर्ट के मजिस्ट्रेट साहब बैठे हैं तो वो बुरा मत मानना। मैं कई बार गया हूं कोर्ट में, एज ए एमपी बनने के बाद भी गया हूं, मंत्री बनने के बाद भी गया हूं, और कोर्ट में पूछते क्या ये पटवारी था आपके यहाँ कोर्ट में? मैंने कहा नहीं, हमारे कलेक्ट्रेट में था। आपने इसको सस्पेंड किया? मैंने कहा किया था साहब। ये दस्तखत आपके ही हैं? मैंने कहा मेरे ही हैं। वो सवाल में किए? वो सवाल, इतना ही पूछना और पूरा दिन मेरा लगना। कोई छोटे कोर्ट में, कोई और छोटे इंटीरियर कोर्ट में, और एक दो जगह तो ऐसा हुआ जब मैं पहुंच गया तो पता चला मजिस्ट्रेट साहब छुट्टी पे। मेरा तो पूरा दिन खराब हो गया। अब क्या होगा इसमें? इसमें क्या होगा कि अगर आपकी कोई पेशी है तो आप घर बैठे अपना कंप्यूटर खोलेंगे, ई प्लेटफॉर्म पे जाएंगे, अपना बयान देखेंगे। कोर्ट का भी ई प्लेटफॉर्म होगा, ई कोर्ट प्लेटफॉर्म। वो पूछेगा आपसे कि डीजी साहब जब आप डीजी थे तो इस कांस्टेबल को आपने सस्पेंड किया था, ये दस्तखत आपके ही हैं? तो घर बैठे ही डीजी साहब कहेंगे हाँ मेरे ही दस्तखत है। हो सवास में किए, ठीक है, तो उसको कोर्ट नहीं जाना पड़ेगा। आराम हुआ कि नहीं हुआ ये तो बता दो। यही चेंजेस हमने किए हैं। ये क्या है? ई प्रिजन। आपने इक्विटल कर दिया किसी को, अपराधी को, लेकिन आपको ऑर्डर नहीं मिला, और जैसे जैसे आप जेल के, हमारी कमेटी के सामने विषय आया, एक विषय ऐसा आया कि साहब 2 दिन बाद हमें ऑर्डर मिला सर्टिफाइड कॉपी कोर्ट की, कोई छोटा कोर्ट था। उसके बाद हम जेल सुप्रिटेंडेंट के वहां गए तो उसने कहा 6 बज गई, जेल बंद हो गई, अब आप दूसरे दिन आइए। उसने कहा मेरे पास इक्विटल है, मेरा आदमी क्यों जेल में रहे? उसने कुछ नहीं कर सकते, अब जेल बंद हो गई, आपको दूसरे दिन ही आना पड़ेगा। इसमें क्या होगा? जैसे ही मजिस्ट्रेट, कोई डिस्ट्रिक्ट जज, कोई हाई कोर्ट का जज, कोई सुप्रीम कोर्ट का जज ऑर्डर करेगा और अपना ई प्रिजन प्लेटफॉर्म पे डाल देगा। जैसे इधर वो ऑर्डर करेगा उसके ई प्रिजन प्लेटफॉर्म पे चला जाएगा। कोई कॉपी की जरूरत नहीं है। उस अपराधी को जिसको इक्विटल हुई है वो छोड़ देगा बोला आराम हुआ कि नहीं हुआ, बताइए तो सही। तो यही चेंजेस है जी। इस चेंजेस के लिए कोई कुछ कहे तो वो एक अलग विषय है। मैं इस अवसर पर मुझे आपने बुलाया और एक समाज सेवा का भी माध्यम पुलिस है, इसका प्रकाश सिंह जी ने एक दर्शन दिया, मैंने भी इसको नोट किया है। और आपकी ये जो पुस्तक है स्ट्रगल ऑफ पुलिस रिफॉर्म, ये हमने थोड़ी पढ़ी भी है और आगे हम इस पर कुछ कार्रवाई कर रहे हैं। इस कुमार जी, आपको मैंने बताया था उस दिन जब आप आए थे ना कि हम इसमें कुछ काम कर रहे हैं। लेकिन एक चीज़ जो आपने कहा कि 1861 का पुलिस एक्ट, देखिए हमने 1562 संख्या काफ़ी अच्छी है, नहीं 1562 कानून जो काम के नहीं थे वो हमने रिपील कर दिए। तो ये भी नंबर आ जाएगा, अब आ जाएगा। अब आपने आज बताया है तो हम नंबर लेंगे इसका भी, पर ये क्यों नहीं हुआ इसका थोड़ा हम पता करते हैं, नंबर लेंगे इसका। दूसरा आपने कहा कि एक मॉडल पुलिस एक्ट बनना था क्या 2006 में। अब ये क्या है कि लॉ एंड ऑर्डर ये सब राज्यों का विषय भी आ गया, लेकिन एक विषय आपका जो सुझाव था जिसमें एक पुलिस कंप्लेंट अथॉरिटी बननी थी शायद, वो अभी बनी नहीं है ना, वो भी आप हैं कई राज्यों में बन गई ना। हाँ, कई राज्यों में बन गई, कई राज्यों में बन, ये भी एक विषय आपका था। और कुछ अच्छे सुझाव आपके थे। ये पुलिस रिफॉर्म का अब स्ट्रगल करने वाला पार्ट पूरा हो गया, अब आपको ज़्यादा स्ट्रगल नहीं करना पड़ेगा। आपको अब अवार्ड भी दे दिया है लाइफ टाइम अचीवमेंट का। तो अब हम आपसे सुझाव लेंगे और हम कोशिश करेंगे मेरा ऐसा मानना है कि हम कोशिश करेंगे और हम पक्का ही करेंगे, एक दिन आपके यहाँ मैं मेरे कुछ अधिकारियों के साथ आपके यहाँ चाय पीने आऊँगा, वहीं पे सुझाव लूँगा, आपको आने की ज़रूरत नहीं होगी। नहीं, मैं आऊँगा आपके घर। मैं इसलिए घर आऊँगा कि मैं आपकी पत्नी का सम्मान करना चाहता हूँ घर चल करके। आप तो मुझे लगता है यहाँ नहीं करोगे आज। हाँ, मैं आपकी पत्नी का, सावित्री जी का नाम है ना, सावित्री जी का घर आकर के सम्मान करना चाहता हूँ। ये मुझे सब्जेक्ट, मुझे जो आपने पत्नी का जिक्र करके यहाँ तक मेरे को आपने छू लिया है, यहाँ तक छू लिया है। और मेरी पुस्तक भी आपको हम दे देंगे, अगर है तो। लाए हो क्या है? हाँ, अगर है तो वो भी दे देना। और बहुत अच्छा कार्यक्रम आज हुआ, कई अच्छे सुझाव आए। और मैं समझता हूँ कि आपने जो 1861 पुलिस एक्ट की बात की है, और दूसरा आपने जो बात की थी कि 1857 में जब अंग्रेज़ों ने सोचा, वो एक अलग विषय था। अब तो क्योंकि राज्यों ने कहा है ये तो लॉ एंड ऑर्डर हमारा स्टेट का सब्जेक्ट है, उसको काफ़ी, लेकिन फिर भी मैं सारी चीज़ें जो कंसर्निंग हमारे ऑफिसर हैं जो इस चीज़ विषय को देखते हैं, उसके साथ मैं सोचता हूँ हमारे लॉ सेक्रेटरी भी और आपके घर चाय पीने ही आएंगे। चाय तो पिला दोगे ना, कोई दिक्कत नहीं है।
हमारे छोटे फ्लैट में आप कहाँ आइएगा?
नहीं, छोटे का विषय ही नहीं है। मैं छोटे और बड़े का विषय नहीं रखता हूँ। पुलिस में मैं जो आईपीएस के रूप में देखता हूँ ना, इनके जब आर्टिकल आते हैं तो मैं तो कहता हूँ पढ़ो भाई। मैं तो कई बार आपसे, मेरी इच्छा थी कि मैं आपसे बात करूं, आज मौका मिल गया। ये आईपीएस फाउंडेशन ने अच्छा मौका दे दिया। मैं तो वाकई आपसे इनको कई बार कहा, मैंने कहा मुझे प्रकाश सिंह जी से बात करनी है भाई। तो आज कोई भगवान ने मिला दिया, कोई विषय होगा, इसलिए मैं ही आऊँगा आपके यहाँ और उसके बाद ही आपको बुलाएंगे अगर बुलाना है तो। पहले मैं आऊँगा। एग्री हो ना आप तो एनएसए साहब हैं? तो कब चलने का तारीख तय कर लो भैया। आप 2-3 दिन यहीं हो तो वैसे ये विद इन ए वीक मैं आपसे टाइम लेकर के, और हम सुबह सुबह आपके घर सुबह आएंगे 10-11 बजे के हैं? सुबह ठीक नहीं रहेगा, हमारे सेक्रेटरी सुबह नहीं आते। मैं तो तैयार हूँ हैं? ब्रेकफास्ट में गर्ग साहब सुबह, हाँ आप बुला लेंगे यार उनको भी सुबह ब्रेकफास्ट पे ठीक है, ये अच्छा है क्यों सुबह माइंड फ्रेश होता है। तो ये जो इतनी चीज़ें पेंडिंग रह गई है ये नहीं रहनी चाहिए। इन्होंने इतना काम किया है भाई पुलिस रिफॉर्म में। मैं तो चाहूँगा एक बार और जोरदार ताली बजा के इनका स्वागत करें। बहुत बहुत धन्यवाद, बहुत बहुत आभार।
धन्यवाद सर। पर्दे के पीछे के हम सफ़र का हर सफल व्यक्ति के सफ़र में योगदान को आपने सराहा। आपने अपने पुलिस के साथ अनुभव पर प्रकाश डाल इंटेलेक्ट और निर्णय के समन्वय को समझाया। इतना ऊंचा पद प्राप्त करने के बावजूद आपका स्पष्ट स्वभाव एक दुर्लभ रत्न है। सर, अब कार्यक्रम को आगे बढ़ाते हुए मैं श्री आर.एस. मुशाहरी सर से आग्रह करूंगा कि माननीय मंत्री श्री को स्मृति चिन्ह भेंट करें। अब मैं श्री डीसी जैन को मंच पर वोट ऑफ थैंक्स देने के लिए आमंत्रित करता हूं।
सबसे पहले मैं आज के इस कार्यक्रम के मुख्य अतिथि माननीय श्री अर्जुन राम मेघवाल साहब, केंद्रीय कानून एवं न्याय मंत्री का हृदय से आईपीएफ फाउंडेशन की तरफ से आभार और धन्यवाद व्यक्त करना चाहूँगा कि आपने हमारे इस निमंत्रण को स्वीकार किया और आज आप हमारे बीच में यहाँ पधारे और आपने अपने बहुत ही अभी जो आपका बहुत ही ओजस्वी और अच्छा उद्बोधन रहा, बहुत प्रैक्टिकल एग्जांपल्स दे करके आपने इनफैक्ट अपना मैसेज भी डिलीवर किया सभी तरह का कि हम सफ़र का क्या इम्पोर्टेंस है हम सब की लाइफ में, चाहे स्पाउस की क्या इम्पोर्टेंस होती है, जो भी हम लोगों ने लाइफ में थोड़ा बहुत कुछ अचीव किया है उसके पीछे, और प्लस पुलिस को भी आम आदमी के प्रति पुलिस का क्या व्यवहार होना चाहिए, क्या नज़रिया होना चाहिए, क्या दृष्टिकोण होना चाहिए, उसको आपने बहुत ही सरल शब्दों में बहुत ही अच्छे उदाहरण दे करके पुलिस रिफॉर्म के प्रति जो मैसेज है उसको भी कन्वे किया। और जैसा प्रकाश सिंह सर ने जो बात कही पुलिस रिफॉर्म्स को लेकर के, जो अधूरी बात चल रही है पर्टिकुलरली पुलिस एक्ट 1861 को ख़त्म करने की, उस पर भी बहुत ही आपका बड़ा पॉजिटिव रिस्पॉन्स रहा और आपने आपने खुद ही कहा है कि आप उनसे मिल कर के अपने डिपार्टमेंट के अधिकारियों के साथ इस विषय पर और अधिक चर्चा करेंगे और ये कार्यक्रम आगे बढ़ेगा। तो मैं पर्टिकुलरली इंडियन पुलिस फाउंडेशन की तरफ से तहे दिल से मंत्री महोदय का बहुत बहुत आभारी हूँ। मंत्री जी राजस्थान के हैं, मैं भी राजस्थान का हूँ और हम सब मंत्री जी को अच्छे से जानते हैं कि बहुत ही सरल स्वभाव के हैं, बहुत ही मतलब इनफैक्ट इनका अपना ही बहुत प्रतिभाशाली इतिहास रहा है, पढ़ाते भी रहे हैं, अधिकारी भी बहुत पॉपुलर रहे हैं, पार्लियामेंटेरियन भी बहुत पॉपुलर रहे हैं, इसीलिए आउटस्टैंडिंग पार्लियामेंटेरियन का आपको अवार्ड भी मिला है। और पहले रेवेन्यू डिपार्टमेंट में थे, वहाँ भी बहुत पॉपुलर थे, अभी कानून न्याय मंत्री हैं तो बहुत पॉपुलर हैं, क्योंकि इनका स्वभाव जो है वो इतना सरल है कि कोई भी व्यक्ति, इनकी एक्सेसिबिलिटी बहुत हाई है। उस दिन जब हम मंत्री जी को निमंत्रित करने गए थे तो आधा पौन घंटे में ही हमने देखा कि ऐसे ऐसे लोगों के फ़ोन आ रहे थे जनरली जिनसे शायद अधिकारी लोग भी बात नहीं करते, और हर व्यक्ति जिसका भी फ़ोन आ रहा था उससे मंत्री जी खुद बात कर रहे थे, उसकी जो भी बातचीत थी उसको सुन रहे थे। तो ये बहुत ही हमारे लिए सौभाग्य की बात रही कि ऐसे सरल, सुलभ और सहज व्यक्तित्व आज हमारे इस कार्यक्रम में पधारे और हम सबका मार्गदर्शन दिया। प्रकाश सिंह सर के बारे में ज़्यादा कुछ कहने की आवश्यकता नहीं है, लीजेंडरी व्यक्तित्व है और पुलिस रिफॉर्म्स के लिए सर ने जो कुछ किया है सबको पता है, उनका दिल हमेशा पुलिस के लिए धड़कता है। जैसा आपने खुद ही कहा कि हम सब, बाकी किताब सर की लिखी हुई हम लोगों ने कितनों ने पढ़ी या नहीं पढ़ी, लेकिन जो आर्टिकल सर के नियमित रूप से अखबारों में आते रहते हैं, मैंने भी करीब करीब मैं कोशिश करता हूँ कि सर का लिखा हुआ कोई आर्टिकल मिस नहीं करूँ, और उससे जो हम लोगों को मार्गदर्शन मिलता है एक बिल्कुल प्रैक्टिकल, जो आपका अपना अनुभव है वो तो है ही है, लेकिन आज भी आपकी जो सोच है वो इतनी सकारात्मक है, इतनी पॉजिटिव है, और कोशिश हमेशा ये रहती है तो युवा पुलिस कर्मियों का मार्गदर्शन, अधिकारियों का मार्गदर्शन, तो ऐसे व्यक्तित्व को आज इंडियन पुलिस फाउंडेशन को सम्मानित करने का अवसर मिला। उसके लिए सर ने जो स्वीकृति दी उसके लिए भी मैं सर का तहे दिल से बहुत बहुत आभारी हूँ, और सर को ये विश्वास दिलाता हूँ कि हम सर को आसानी से छोड़ने वाले नहीं है इंडियन पुलिस फाउंडेशन, और ये नहीं है कि कोई आपको हम आईपीएफ से रिटायर कर रहे हैं, सर्टेनली नॉट। आपके नेतृत्व में, आपके मार्गदर्शन की बहुत आवश्यकता है। आप ही मतलब जो हैं इसके सूत्रधार हैं आईपीएफ के, और आगे भी आपका मार्गदर्शन हमें मिलता रहेगा, ये बहुत ज़रूरी है। मैं आईपीएफ के चेयरपर्सन श्री आर.एस. मुसारी साहब का भी बहुत बहुत धन्यवाद करूंगा कि उन्होंने इस कार्यक्रम को आयोजित करने के लिए महत्वपूर्ण मार्गदर्शन किया। लेकिन जो व्यक्ति इस कार्यक्रम के सूत्रधार हैं, जिन्होंने इस पूरे कार्यक्रम को कंसीव किया और मतलब इसको बहुत ही हर चीज़ को बारीकी से देखा, कंसेप्चुलाइज किया, एग्जीक्यूट किया, वो इज़ नन अदर देन मिस्टर एन रामचंद्रन, आवर प्रेसिडेंट. So definitely, matlab, I can see the way he has worked for organizing this function. I am seeing him for last 15 days, 1 month. एक एक छोटी छोटी चीज़ हमारे सभी आईपीएफ के जो भी हमारे पदाधिकारी हैं, हमारे स्टाफ हैं और यहाँ आईआईसी का स्टाफ है, उन सब के साथ एक एक छोटी छोटी चीज़ आपने खुद तय की है। और हम लोग क्या बोलेंगे, क्या नहीं बोलेंगे, पैनल डिस्कशंस में कौन शामिल होगा, किसको कैसा क्या रहेगा, बहुत ही महत्वपूर्ण विषय पे आपने ही इसका थीम चयन किया है, नेविगेटिंग द न्यू क्रिमिनल लॉज एंड इम्प्लीमेंटेशन चैलेंजेस, जो कि बहुत ही मतलब आज की तारीख में इम्पोर्टेंट थीम है। तो मैं सर का भी बहुत बहुत आभार व्यक्त करता हूँ। हमारे जो आईपीएफ के पदाधिकारी हैं, ईश कुमार सर हैं, सुनील हमारे सहयोगी हैं, और ऑफ कोर्स सुधीर प्रताप सिंह सर हमेशा पीछे जाके बैठ जाते हैं, उनसे कितने भी रिक्वेस्ट करें कि थोड़ा आगे बैठ जाइए। तो और हमारे जो भी स्टाफ, हमारे अधिकारी, सब ने इस कार्यक्रम को आयोजित करने में बहुत महत्वपूर्ण योगदान दिया है। और चूंकि समय कम है इसलिए मैं सब लोगों के नाम नहीं ले पाऊंगा, लेकिन जो डिस्टिंग्विश्ड ऑडियंस में हमारे आए हुए हैं, पिलई सर हैं हमारे साथ, जैन सर हैं हमारे साथ, फॉर्मर डायरेक्टर आईबी, मीरा मैम मुंबई से आई है, कुमावत साहब हमारे राजस्थान से आए हैं, और कंठ साहब बैठे हैं, डीजी आरपीएफ हैं, सिंह सर हैं, तिलोत्मा मैम, आशीष सर चले गए मैडम, हैं, हाँ, तो सभी हैं। उधर ओपी सिंह साहब बैठे हैं ऑडियंस में, पंकज सर आए हैं डिप्टी एनएस से, इतना अपना समय निकाल करके सबने सर ने हमारा आग्रह स्वीकार किया। सर भी हमारे कैडर के हैं और हमेशा ही मतलब हमारे बहुत ही लोकप्रिय अधिकारी रहे हैं। तो और प्लस सबसे बड़ी बात है कि डायरेक्टर एम्स हमारे साथ हैं। तो इतने सारे लोग, मैं सबका नाम नहीं ले पा रहा हूँ, एनआईए के अधिकारी यहाँ पर हैं, पैरामिलिट्री फोर्सेस के अधिकारी यहाँ पर हैं, सीबीआई के अधिकारी यहाँ पर हैं, बीपीआरएनडी के अधिकारी यहाँ पर हैं, अलग अलग और कई प्रदेशों के अधिकारी भी यहाँ पर आए हैं। लाइव स्ट्रीम से सब लोग जुड़े हुए हैं। सबसे बड़ी बात है कि लॉ स्टूडेंट्स हमारी सेमिनार में आए हैं, दिल्ली पुलिस के अधिकारी हमारी सेमिनार में आए हैं। तो आप सब लोग जो भी आए हैं, जिन सब का नाम तो मैं नहीं ले पाऊँगा, आप सबको भी इंडियन पुलिस फाउंडेशन की तरफ से मैं बहुत बहुत आपका धन्यवाद ज्ञापित करता हूँ, अपनी कृतज्ञता व्यक्त करता हूँ कि आप लोगों ने हमारे इस आग्रह को स्वीकार किया। पर्टिकुलरली जो ऑडियंस में हमारे दिल्ली पुलिस के अधिकारी, लॉ स्टूडेंट्स आए हैं, मैं पूरा विश्वास दिलाता हूँ कि अब जो पैनल डिस्कशंस होंगे उसमें निश्चित ही जो चर्चाएं होंगी और जो भी क्वेश्चन आंसर्स होंगे वो हम सब के लिए लाभान्वित होंगे। और ये जो न्यू क्रिमिनल लॉ जो भारत सरकार ने ऐतिहासिक काम किया है, इसको आगे जो बढ़ाना है, इसको जो सफलतापूर्वक इम्प्लीमेंट करना है, उसमें इसकी अच्छी बातें क्या है, क्या एरियाज़ ऑफ कंसर्न है, उनको कैसे हैंडल करना है, कैसे प्रभावी तरीके से इन कानूनों को लागू करना है, इस पर भी बहुत सारगर्भित चर्चा हम करेंगे। और आप सब लोगों के जो सुझाव और क्वेश्चंस आएंगे उनसे लाभान्वित होंगे, इसका मुझे पूरा विश्वास है। इस कार्यक्रम को आयोजित करने में इंडिया इंटरनेशनल सेंटर के लोगों ने जो हमारी मदद की है, बीएसएफ ने जो हमारी मदद की है, सीआईएसएफ के अधिकारियों ने जो हमारी मदद की है, सीबीआई के अधिकारियों ने जो हमारी मदद की है, तो इन सारी संस्थाओं के चीफ्स का भी मैं बहुत बहुत धन्यवाद करना चाहूँगा। उन सब अधिकारियों का धन्यवाद करना चाहूँगा जो इस कार्यक्रम के आयोजन से जुड़े और इस कार्यक्रम को सफल बनाने में जिन्होंने योगदान दिया। हमारे दोनों स्पॉन्सर्स का भी मैं पर्टिकुलरली नाम लेना चाहूँगा, केएलजे ग्रुप और एक्यूम्स। जो ये केएलजे ग्रुप की तो बात ही सर ने खुद कर दी। इवन जो एक्यूम्स हैं, ये इंडिया के लीडिंग फार्मास्यूटिकल और ड्रग मैन्युफैक्चरर हैं, बहुत बड़ी कंपनी है इनकी एंड बहुत लीडिंग मैन्युफैक्चरर। तो दोनों ने बिल्कुल जैसा ही हमने उनको मेंशन किया, इमीडिएटली वो एग्री कर गए और उन्होंने इस इवेंट को स्पॉन्सर किया, तो उनका भी बहुत बहुत धन्यवाद। हमारे मीडिया से पधारे हुए साथियों का भी बहुत बहुत धन्यवाद जो इस इवेंट को कवर कर रहे हैं, और ये इवेंट लाइव स्ट्रीम भी हो रही है। अगर मैंने किसी का नाम नहीं लिया हो तो कृपया बुरा ना माने। हमें मालूम है कि बहुत सारे लोग जो हैं इस प्रकार के आयोजनों में कंट्रीब्यूट करते हैं, लेकिन मन से सबका नाम लेना संभव नहीं हो पाता। मैं मंत्री महोदय के अधिकारियों का भी विशेष रूप से धन्यवाद दूंगा। अंशु भारद्वाज जिससे मेरी कई बार बात हुई, मैं लगातार उनके टच में रहा, तो आपने भी हमारी को बियर किया एक तरह से, और मंत्री जी को अल्टीमेटली हमारे कार्यक्रम में लाने में सफल हुए, उसके लिए आपका भी बहुत बहुत धन्यवाद। व अंत में मैं आप सभी का बहुत बहुत धन्यवाद देता हूं जिन्होंने इस कार्यक्रम में यहाँ पधार करके इस कार्यक्रम की शोभा बढ़ाई और हमें लाभान्वित किया, अनुग्रहित किया। बहुत बहुत धन्यवाद। जय हिंद। थैंक यू।
चाय और जलपान के बाद दिन का पहला सत्र आयोजित किया जाएगा जिसमें पर्सपेक्टिव्स ऑन न्यू क्रिमिनल लॉज पर चर्चा की जाएगी। इस विषय पर पैनलिस्ट हैं प्रोफेसर GS वाजपेयी, वाइस चांसलर NLU दिल्ली, श्री K रामानुजम, फॉर्मर DGP तमिलनाडु, श्री KP सिंह, फॉर्मर DGP हरियाणा। ब्रेक हो रहा है। श्रीमती S यानी IPS IGP ट्रेनिंग ओडिशा, डॉक्टर नुजहत प्रवीण खान, प्रोफेसर जामिया मिलिया इस्लामिया, श्री संजय वशिष्ठ, सीनियर लॉयर, जहाँ पे सर DC जैन सर मॉडरेटर के रूप में आपको दिखाई देंगे। अब मैं मंच पर उपस्थित अतिथिगण एवं अन्य वरिष्ठ अधिकारीगण से अनुरोध करता हूँ कि जलपान हेतु प्रस्थान करें। धन्यवाद। जय हिंद।
संदीप हमारे पास में पुराने त्रिपाल के पीस पड़े हैं कुछ त्रिपाल के टुकड़े हैं पुराने त्रिपाल के टुकड़े पड़े हैं कुछ ये खिड़की 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 में शीशे टूटे हुए हैं 2 नंबर बैरिक के वो उनको लगाना है हाँ दे क्या उसको ये योगिता साहब कैटरिंग वाले हटाएंगे इसको कैटरिंग वाले हटाएंगे पीछे नहीं हम बैठा के पीछे रख देते हैं उधर ही में ले जा बैठा के और अब ये माइक की जरूरत पड़ेगी हाँ पड़ेगी माइक तो पड़ेगी साथ तो बैठेंगे ना यहाँ पर कॉफी टेबल पे नहीं लगी उधर पीछे बता रही जो कैसे होगा कैसे फिर मेरे पास 5 मिनट लग जाए हाँ तो वो दे इसलिए मैं पूछ रहा हूँ जो सेशन चलेगी हेडलाइन पे हमें तो ये बोला है कि आज वो लगा दो अब ऐसा ना सिर्फ मैं अपने हटा दूंगा सारे फिर लास्ट में बोल दिया कि लगाने एक मिनट क्लियर कर लो इधर क्या बड़ा टेबल भाने का टेबल भाने का टेबल भाने का टेबल भाने का उसके लिए कॉर्डलेस है ना की है, उसमें फोटो में ऐसा रखा हुआ है, एक इधर रखी हुई है, उसमें फोटो है किसी बुक में ना, लास्ट ईयर वाले फोटो रखे हुए हैं।
ठीक है।
कार्टून रखे हुए पानी के बोतल किसी में नहीं है। इसमें देखिए हाँ संदीप, दो नंबर गाड़ी में देखा, दो नंबर गाड़ी में बेचते हैं विनय साहब है, देखिए दो नंबर गाड़ी में विनय साहब बेचते हैं, उनको लेके आ जाओ। ओके सर, सर इसमें बुक में फोटो दिया हुआ पिछले बार, और दिखाता हूँ कैसा लगा ये।
एक बार दो दो सात हो गया। रामचंद्रन साहब का
थोड़ा दूर हो गया ना, टेबल आगे करें, चेयर आगे करें,
केवल आगे
उठाएंगे उठाएंगे
केवल को आगे करना ले लेंगे सर, बैठ के तो बहुत दूर है।
आगे दे साहब, बैठ कर देखना एक बार बीच में,
बीच वाला टाइट आगे
बहुत बढ़िया सर।
शीशा पूरा उठ जाता है।
हाँ सर, दिल्ली होता है प्रोग्राम तो देखिए ना, थोड़ा सा हम दिल्ली आना
बहुत जल्द हो गया, बस हो गया। उसको ऐसे ही तिरछा करना, उसको भी ऐसे ही तिरछा करना, केवल को बस उसको भी तिरछा करना, उसको बीच में
सर। वो पन्नी पैक कार्टून है, मुझे थोड़ा नीचे पानी आया है, कार्टून के लिए नहीं हुए, कार्टून सारे पन्नी पैक हैं। मैं
बस बस
जो पन्नी लगा है, पानी को साफ करा दिया उसको। वो पीछे में कहाँ से पता नहीं कल आंधी आई थी ना, गांधी तूफान जो आया था, उसमें कहीं से आया है पीछे से, मैच के पीछे से कहीं से उसके वो कार्टून में पन्नी पैक है, और कार्टून है, मुझे बता देगा तो दो इसमें एक सेंटर में इसमें। ये बुक्स किसी किताब की थी बता
ये उनके रेसिडेंस के लिए हैं।
दोबारा फिर आएंगे।
हाँ।
अच्छा ये पैड भी नहीं का है दोबारा आएंगे
प्रकाश सिंह सबका है।
दोबारा आएंगे क्या
ये सर है।
ओके सर
May I request everyone to settle down?
In Tamil, we don't have, we don't say Sri. Instead, we are, it's called Tiru. Tiruvalluvar. Kerala also? Sri. So whenever I used to go for a meeting or something, from my office, they will communicate the name. Tiru Kera. Mr. Kera. So here they about Sri Tiru Kera.
Should I go and see, sir?
I'll go. Chief asking me.
Can we request everyone who is outside to please come inside? We are beginning the first session, our panel discussions on the topic. May I request our officers from IPF to kindly request the audience who are outside the hall to please request them to come inside. We are beginning the session. So, welcome back and a very good afternoon to all of you. Though we are late because this session was to begin at 11:30 and to be concluded at 1:30, but I think we have saved some time by finishing with the lunch. So, but of course, instead of going for 2 hours, which was the original plan, I think we'll try to finish it in shorter time. We'll try to finish it in maybe 1 hour or 1.5 an hour within that. The good part is that because of the delay in the inauguration, K.P. Singh sir and I got the opportunity to introduce the subject. We have already touched upon the salient features of the new criminal laws. So for the purpose of introduction, I need not repeat the same, and we may straight away start. So again, first of all, I'd like to introduce the panel. The first session that we have, I'll just explain the theme. Basically, in the first session, and of course, the wider theme is navigating the new criminal laws and implementation challenges. So, in the first session, we will be focusing on the perspectives on the new criminal laws, and we will try to have a balanced debate. We will highlight the positive aspects, as well as we will also take up the criticisms or points of concern. Then that will be the focus of this. The modality of this session would be, first I'll introduce the panelists just now, and thereafter I will request the panelists to give their opening remarks on a particular theme which is dear to them, relating to the topic. And thereafter then we will have panel discussions, and after that finally the floor will be open for discussions, in the sense that the audience will be requested to ask questions or seek clarifications or make observations on the theme of the discussion. So I start from there. We have Srimati S. Shani. She is an IPS officer of 2001 batch from Odisha cadre, and currently she has been serving as IGP training in Odisha. We are thankful to her that she has come all the way from Odisha to join this panel with us. Next to her is Shri K. Ramanujam sir. He is a 1978 batch IPS officer who retired as DGP Tamil Nadu. So thank you so much, sir, for coming all the way from Tamil Nadu to join this discussion. To my left, we have Shri K.P. Singh, whom you have already seen. Sir is 1985 batch IPS officer from Haryana cadre, and sir retired as DGP Haryana. Then we are fortunate to have Professor Dr. Nuzhat Praveen Khan with us. She is a professor in Jamia Millia Islamia University, we all know. She was also former Dean Faculty of Law. So we have a very distinguished panel with us. And as I said in my introduction, straight away I may request the panelists to be ready with their opening remarks. And I think, shall we begin with you, ma'am, if it is okay with you? Yeah, because let's have the viewpoint of the academia first before I come to the police officers. So I will request you to kindly give your opening remarks on the new criminal laws. Thank you.
Thank you so much for giving me this opportunity. However, I am generally audible to all the students. I don't know.
Yeah, it is on.
Good afternoon, everyone. And thank you for holding here after lunch, which is a very difficult thing. However, today we all are gathered here to ponder upon a very important subject, which is, all of us are very curious to know and to understand. And I'll not say I'm that much an expert, but still, being a teacher, I may be able to put some light and to share some of my thoughts on the subject. So as already Professor Jain said, we already have the introduction of the subject, that this law came into existence, there are 3 steps. First, the bill came in August 2023, then it was enacted or passed by the Parliament in 25 December 2023, and then finally got implemented on 1st of July 2024. And implementation means a lot, actually. Now this requires to be known to with all the stakeholders, whether it is judiciary or police officers, or even for the student. This is for the first time they will have their semester exam coming in December from this particular new law, which is called as Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Sakshi Sanhita. So these 3 laws, they have, have been overhauled. There are very many welcome changes, and it is basically to effectively and in a very big manner to overhaul the subject, keeping in view the time. That was a very old law. I'll not say anything about colonial or something, but everything requires innovation, everything requires to be with time, I'll say. So keeping in view that the requirement of the time, lots of digital technology, electronics, and forensics, which has with the time passed, requires the new type of dealing with the criminal justice system. So how we have this particular law, which is quite taken care of all the things. There may be people who can criticize, but everything have some or the other type of maybe lacunas or maybe certain suggestions which can be taken care in the passage of time. So if you look at if you talk of Bharatiya Nyaya Sanhita, that is somehow the new penal code, you will say. It has, one thing, it has reduced the number of sections. Earlier we were having, in the books you were seeing 511, and then with amendments A, and B, it was around 576. Now it has come to only 356 or 58. So that is a huge relief for the people that the number of such sections reduced. Then it is, it has clubbed certain things. Like, for example, which I think I'll speak in the next round, I'll be speaking on the topic offenses against women and children. So this, otherwise in the IPC, that was now Bharatiya Nyaya Sanhita, in IPC, the offenses were scattered throughout the IPC. They were not placed at one place. In the Bharatiya Nyaya Sanhita, it is a very significant and welcome change that they have clubbed all the offenses relating to women and children confined to one chapter, which is chapter 5 of the Bharatiya Nyaya Sanhita. So in this one chapter, very exhaustively you can see the offenses which are against women and children. Then apart from this thing, this is the first chapter in the sense when offenses begin, because before this the other 4 chapters are, one is definitions, then second is with regard to punishments, then general explanations, and then conspiracy and abatement, etc. But if we look at the exactly offenses, so this is given preference or over even the body offenses, which those who are the law students, especially, I can see many students, you can see the offenses against human body was the most important chapter in the IPC. Now, if you look at the preference order of the chapters, you yourself will feel that how much importance has been given for the safety and security of the women and children. So how this chapter has been made a very important chapter. There are many other changes which are very welcome changes in the criminal laws, especially if I talk of BNS. There are, organized crime concept has been there. New offenses have been added. It is related to in property offenses also, even in body offenses, even in the chapter 5, which is offense against women and children. So I think students and all the police officers, they will also take note of that offenses against women and children have been given quite a prominent place, and it has given a very significant importance, which otherwise I understand was being ignored, was not taken, maybe because we are a patriarchal society, maybe even certain definitions which I'll talk, they have been quite considerably have been changed. And one thing which I'd like to point out, while we are saying number of sections have been reduced, here is a point which students should take note, that earlier the definition clause in the IPC was scattered up to section 53A. And now, just like other Bayer Acts, if you see the Bayer Act, first the section is generally about the extent and commencement of the law, and then the second section generally talks about it's a type of glossary, or you can say that's the interpretation clause, and you see the definitions. So now this is a very welcome change. They have put all the definitions in section 2, just like the other laws. And some of the definitions which have been added, I'll talk later on. Thank you.
Good afternoon, ladies and gentlemen. I'll talk about the provisions which need revisit, where I think the social ethos have been slightly not considered, and the legislature has gone even beyond the directions of the Supreme Court. I'll begin with the loaded statement that this law is very progressive and futuristic. Now let me come to those provisions which need revisit. First of all is section 377 IPC. In Navtesh Johar, the Supreme Court did not struck down the complete section. It saved 2 provisions, bestiality and forced unnatural offense. But while decriminalizing 377, we have left 2 types of victims with no remedy: transgenders and adult male who are forced to undergo unnatural offenses. They have no remedy in law. So I think it is a provision where we need to rethink, and Delhi High Court has already taken cognizance of this matter and issued notices. The second provision is section 497 IPC, adultery. It has been removed from the statute book. After the judgment of the Supreme Court in Joseph Sign, this offense was struck down from the IPC. But the Supreme Court erred on 2 points. One, there was the concept of inequality in the provision. The Supreme Court have well made it gender neutral so that that equality clause should have been protected there. Second is the second part of this section, which provides that a woman can have relationship with a man outside marriage with the consent of her husband. The learned judges failed to understand what was the meaning of that section. The meaning of this provision was niyog. How Pandavas were born, we all know. And that was the custom at that point of time, traditions in 1861 when IPC was written, and the British, they protected it. But our judgment, our Supreme Court failed to understand that and completely struck down. I do not advocate that niyog should be reintroduced, but at least the provision of marriage should have been protected by retaining section 497. Because the chapter under which section 497 is listed, the title of the chapter is of offenses against marriage. The idea was to protect the institution of marriage, because it is the institution of marriage which has been the cornerstone of our civilization, and we boast that we have been the oldest civilization basically because of the institution of marriage and family. So this is the provision which need revisit. Most of you are law student here. There is a presumption in law that a child born within 27 years of even after dissolution of marriage shall be presumed to be a legitimate child. That is the sanctity of marriage. It needs to be protected. The third is decriminalization of section 309 IPC, that is to commit suicide. Welcome step. But the remedy was available under section 1151 of the Mental Health Care Act 2017, whereby it is provided that a person who attempt to commit suicide should not be prosecuted and punished. He should be treated as a psychiatric patient. But how will come to know that such a person exists when we do not even document it in the form of FIR? So the best way would have been to transport those provisions as an explanation in section 309 and rewrite it. The next provision is maximum period of under trial which can remain in jail. Here in the morning session also somebody commented it's a very welcome step. But if you read between the line, you will see that not even a single person will be eligible to avail the benefit of this provision. Why? Because they have said that if a person is charged with more than one of offenses, even in a single FIR, he will be ineligible. And as police officer will know, in 95% of the cases, there are more than one section in FIR. Second, if there is more than one case, he will be ineligible. Secondly, they have expanded the sections where the person will not be able to avail this right. Even life imprisonment has been added in that list. Earlier, it was only death penalty. The provision, another provision which I will mention in brief is community policing. They have introduced, but with no modality. In field, there is confusion who will execute this sentence, whether jail authorities or they will create some other authority. Who will supervise these community policing services? There is no modality involved. So modality should have been spelled out. Plea bargaining in the morning session was also referred. It is a dead horse. I have not seen even a single case in the last 15 years after this provision was introduced in CRPC that a case has been plea bargained. And same is going to happen now because we have not changed anything substantial in it except minor changes, cosmetic changes. Witness protection scheme we have already mentioned. Whereas in Mahendra Chawla, the Supreme Court has given the whole scheme, how you should go about it. But we forgot to give the detail in the CRPC. There are many drafting mistakes, which in discussion when it will come, we will go there. But I conclude with saying that there are many positives, but there are certain lacuna also where we should concentrate and revisit. Thank you.
Thank you, sir.
Good afternoon, everyone. It is less than 100 days since we sang the requiem for the old criminal major acts. The new acts have come into place in the spirit of what Lord Tennyson wrote, the old order changeth, yielding place to new, lest one good custom should corrupt the world. Maybe the old acts were one good custom, but then they had to go. As is to be expected, there have been bouquets and there have been brickbats, and the heaviest brickbatting has come from civil rights groups, human rights groups, and to some extent from the bar also. Now I'm going to present the point of view of these quarters. These are not exactly my views. I'm just presenting what others have expressed. I will outline the objections of these groups. In fact, if you see the number of changes that have been effected or new introductions that have been made are quite few, not too many. But still, some of these groups have made so much noise as if this entire thing will is aimed at arming the state with untrammeled and uncontrolled powers. So their objections I'll outline under 4 heads. As I said, these are not my views, and the individual points can be discussed. And since the time given for opening remarks is only 5 minutes, I will not go into the details on everything. These can be reserved for discussions and interactions. The first point that is made is there is an attempt to
criminalize democratic and peaceful expressions of dissent and protest. This is one of the first major attacks. They refer to three particular sections in this regard. One is section 113 of BNS, the second is section 152 of BNS, and the third is section 226 of BNS. Section 113 of BNS deals with terrorist acts. The main criticism is there's already an Unlawful Activities Prevention Act which defines terrorist act in exactly the same manner as it is given in BNS. So why have this UAPA? Why have this section in BNS? Especially when you don't have the safeguards that are provided in section 45 of the UAPA. There are two important safeguards there which do not find place in BNS. In fact, some people have seen even a conspiracy in the way this section has been placed. This section has been placed in the chapter on offenses against human body. And why should it be an offense against the human body? It should be, in fact, an offense against the state. What these people see is that if it had been placed in the chapter on offenses against human body, then under section 227 of the 217 of the BNSS, previous sanction of the government would have been required for prosecuting these cases. So they see a deliberate attempt to place this section in this particular chapter on offenses against the human body. The second point in this regard about criminalizing democratic and peaceful protests is about the introduction of 152 IPC. Now 124A IPC, 152 BNS. Now 124A IPC was put on hold by the Supreme Court in 2022 with little chance of resuscitation. Now this new section 152, which deals with acts against endangering unity, integrity and sovereignty of India, some people regard that it is a new avatar of 124A. It later. And the third section, which they think is an attack on section 226 BNS, which is about attempt to commit suicide. In this, so suicide as an offense has been removed, but an attempt to commit suicide in order to force the hands of a public servant is considered an offense. Now, there is an apprehension that this can be used for a clamp down on democratic protests in the form of hunger strikes. So these are the three major points on which there is criticism on this particular head. The second criticism is about eroding the rights of those who are in conflict with law. The following are the major criticisms under this head. I will not go into the details. Maybe some of them can be discussed later. One, handcuffing. Number two, extension of the duration of police custody. Number three, digital display of information about arrested persons. Number four, trial through video conferencing. Number five, trial in absentia of proclaimed offenders. Then permission to attach property by ex parte orders. And finally, getting samples of signatures, handwriting and voice recording even from persons who have not been arrested. Now, as police officers, many of us will be surprised that there could be objection to many of these features. In fact, many of us would regard as helping the investigation and trial. But then, these are the views from the other side of the fence. The third criticism is that there is a raw deal given to the complainant. Two aspects can be mentioned. One is the provision for preliminary inquiry when a complaint is given, when the punishment is between 3 years and 7 years. Obviously, there is an apprehension that this will result in delay, either delay in registration of case or even denial of registration of a case. And this particular section, this particular provision for preliminary inquiry is violative of the Supreme Court guideline that preliminary inquiry can be done only to verify whether a cognizable offense is made out or not if the complaint itself is not clear. Whereas here they are talking about a preliminary inquiry to find out if there is a prima facie case. So this is one objection. Second point in which a complainant could face problem is about complaints against public servants. Now, this new law requires that if there is a complaint against a public servant, which is filed as a private complaint before a magistrate, then the accused public servant is to be given an opportunity to explain, and further action cannot be taken without getting a report from a superior officer. So this practically gives, this is the view of the human rights and civil rights groups, that this kind of gives an immunity to public servants to even act with impunity, because it's not likely that any public servant is going to admit that what he has done is wrong, and it is very rarely that a superior officer is going to say what his subordinate has done is wrong. The fourth point is the state and the police are seen as acquiring draconian powers under the new laws to the detriment of the citizens. One instance cited, a petty instance, but still an instance cited, is section 172 of BNSS, which says, all persons shall conform to lawful directions of police officers, and that on refusal they may be removed or detained. This is a new provision in BNSS. And those earlier sections which I mentioned, which are supposed to erode or curtail the rights of the accused, are seen as increasing the authority of the police correspondingly. Finally, I would like to touch upon the point Mr. K.P. Singh made about adultery. Not many will know that when the IPC was drafted by the first law commission headed by Macaulay, they also published notes to go along with the IPC sections. Not many people would have been able to read the notes. We have read only the sections. Now, this particular report has devoted 4 pages to the topic of adultery to discuss what should be done, what should be the approach. And at the end of the 4 pages, they say, we think it best to treat adultery merely as a civil injury, because they didn't want the government to enter into matrimonial matters. For some reason, this was not accepted by the then government. The British were in power. I'm talking about in 1860. So when the new law actually came into effect in 1860, adultery was made an offense. But now adultery has come a full circle when it has been decriminalized by the Supreme Court. This took 160 years. Now, whether we agree with the decriminalization or not, the point is there are certain concerns that have been expressed, and we need not wait for 160 years to take note of the feedback. We should approach these criticisms in the spirit of appreciating the constructive and ignoring the destructive, and make changes as may be in the best that are in the best interest of the state and its citizens. Thank you.
Distinguished panel members, panelists, senior officers, all the people who are patiently listening after a sumptuous lunch. I would like to, because we are running short of time, I would like to specifically point out certain things with the objective of having the scope for improvement in case the government is considering any amendments or any rules in pursuance to the new enactments, which, as has been told, also contains a lot of progressive provisions. I will come straight to things that an ordinary man would encounter when going to a police station. As you all know, a FIR is recorded under section 173 of BNSS. Now, from the point of view of a normal person, they go to the police station to register an FIR. So this was an opportunity that we missed by changing the language in the law, to bridge the gap between the language used in the law and what as it is understood by ordinary people and also the police. We refer to registration of FIR, but there is no registration of FIR in the BNSS. So 173 speaks of recording of cognizable information that a police station receives. Now, when it is received, what the officer in charge is expected to do recording is by process of entering the substance of that information into a book, which has been now settled to be the FIR. It's known to everybody that there is no book as such at present, which is the FIR book, which once upon a time the police stations had a book, which was the FIR book. So we have probably forgotten at the time of this legislative change that it's now a form as prescribed by the state government, but that form is not in the form of a book, but in the form of CCTNS entry in the computer. So this was something that we could have taken care of by bringing in what we ordinarily use, FIR registration. Neither the FIR is in, the word first information report is there in the law, nor is the word registration of FIR. So these are two distinct things. Recording of information, if it is received oral information, written information, or electronic information, has to be reduced in the form of a book. Now coming to the change that has happened in BNSS, there is something called as a zero FIR, which a lot of people have referred to in the morning, which is a very good thing. You have heard of the case which was referred to by the Law Minister regarding the train journey and refusal to register the FIR. It's good that the provision of zero FIR has come. But what about certain offenses where a rape victim is found in another jurisdiction? You have to do the medical examination. You have to take a statement. What if the victim is very severely injured? A dying declaration may have to be recorded. So these preliminary steps in investigation do not at present have the sanctity of law. Whereas a lot of SOPs have come which said that you can assign an investigator. In fact, in the zero FIR form, there is an option where you can assign an IO, but some of the state SOPs say that you cannot entrust an IO. Some of the state SOPs that have come up say that you can entrust an IO in cases, but whose discretion that is, whether to assign an IO or not. You are leaving it to an officer in charge decision and discretion, and there is no legal sanctity to those initial preliminary steps. So by introducing a zero FIR, we could have as well thought of legal backing to the steps that are immediately taken. Maybe an accused is being brought by somebody, so his arrest has to be recorded. Would he be produced if the offense has happened in a place which is far away and you are getting an accused in a case and the FIR is also registered in that police station? What would be the initial steps that is expected to be taken at the police station? Second, there is also a lot of confusion between when a zero FIR is registered at present. This doesn't go into the chronological sequence of FIRs in the police station. It goes into a different chronological sequence. And this decision to transfer the FIR to the actual police station where the territorial jurisdiction of the offense lies, at that end police station, what will you do? Whether to, if it is a PE case, whether you can conduct a PE, or whether you are mandated to re-register it as an FIR. So this also again, the BPRND SOP says that the destination police station has no option but to register the FIR. But there are many state SOPs which say the contrary, that officer in charge at the destination police station, receiving police station, has an option whether to register the FIR or to register a PE. I also would like to point out another very nuance in the law, because I do not want to cover the practical aspects. 173 says that every cognizable information that comes to the police station has to be recorded in a book, which is the FIR. What about PE? 173(3) provision, the legal provision, is without prejudice to the powers of investigation under 175. Now, there is no prejudice to the power of the officer in charge to proceed to investigate a cognizable offense, but it is not without prejudice to the provision in 173(1) which says that any information comes has to be entered in a book. So whether preliminary inquiry is a pre-FIR process or a post-FIR process, there is a legal nuance in it. I hope you are getting the point that 173(3), which says about discretion of the officer in charge to enter into a preliminary inquiry in cases where punishment is 3 to 7 years. In those cases, legally, as far as I have understood the provision, there is nothing that exempts the mandatory provision in 173(1) which says that every cognizable information that comes has to be entered as an FIR. So I think this needs to be resolved. I would also like to say about what I'm trying to say is that strict interpretation of law, there cannot be a preliminary inquiry without registration of an FIR. And if police officers have been authorized to also, under Chapter 13, not only to investigate but also to inquire, then there should have been powers of police officer to investigate and inquire. Powers of both should have been covered in the subsequent provision of legal empowerment. And coming to the inquiry, what is the scope of the inquiry? As was discussed, the inquiry is to ascertain, not like what was in Lalitha Kumari, to see whether there is a cognizable offense made out or not. The inquiry is to ascertain whether a prima facie case exists or not. It's not very easy thing. It evolves whether you can examine. There is no clarity at present as to whether during the process of inquiry, I can visit the spot, whether the investigating officer can seize certain objects, whether the investigating officer can examine witnesses, and how would you record it? These are things that I think, because there is no detailing as to what should be the inquiry and how this inquiry will be conducted. These have been covered in SOPs, but then there is no legal backup for the SOPs that have been issued both by BPRND and the states.
Remaining points in discussion?
Sir. Sir. Thank you.
Thank you, the panelists, for giving the opening remarks. I'll come back to Professor Nuja, because you have already given us the salient changes that have been made in the Bharatiya Nyaya Samhita. And I'd like to ask you one particular question. Rather, I'll request you to elaborate on that. We know this new section 69 has been added, which makes certain offenses relating to sexual intercourse with a woman. And one of the new offense that has been added in this section is that if you have sexual intercourse with a woman on the pretext of marriage, false pretext of marriage, false promise of marriage, then you can be booked in this offense, and the punishment is also very severe, 10 years. So I think there is a concern in the civil society on this, that we know that in many cases, particularly when people are in courtship or people are in living in relationship, and tomorrow they may change their mind, they may not decide not to marry because they may not find themselves compatible with each other. So whether because of this new offense introduced in the BNS, there will be a misuse by people who are kind of, can subject this to misuse or abuse. So what are your thoughts on that, and how, for the investigators also, what would be exactly the kind of evidence demanded by this section to prove the ingredients of this particular offense? So I would particularly request you to touch upon this in your discussion.
Thank you. Thank you for the question, and regarding the topic which actually I'm speaking is about the same actually, which is actually one of the unique feature of this Sanhita to incorporate all the offense against women and child. You asked about 69, but if I begin with section 63, actually this whole chapter, which is chapter 5, is clubbed into section 63 to section 99. Which is all about the offenses against women and children. So if we look at the first section itself, which is section 63 and is a replica of section 375, which was the section for rape. And this section is having its language, which actually is somehow absolutely the same which was existing before. But all of you should know that 2013 Justice Verma Committee report has suggested some wordings, some of which have been incorporated into it. And most important change is with regard to the language and the consent word in the definition of rape. As well as if we look at clause 2, if you have the definition, somebody in front of you, you can see that they have, apart from the, that natural way of committing a rape, they have also included clause 2, which was talking about, it's because it was after Nirbhaya, gang rape case, and they noticed how brutally that lady was assaulted. Sexually assaulted. So they have included any object also into the definition. However, I think it is not taken cognizance by anybody, including judiciary. You see that some word, have you heard about this word, digital rape? Any one of you ever? Don't confuse it with the cyber word. It is nothing to do with the cyber word. It is not, because the moment we see any term which is digital, we just conclude it something happening by way of technology, something happening by way of computers or internet or some fake identity or somebody doing something. But no, it is not actually. It is a type of finger rape. It is a type of sexual assault of a woman through any other object, and that is very specifically have been given. But I'm sure even if somebody comes objecting and giving a complaint about that I have been raped, but it was this method, then the person's, maybe that complaint may not be taken in that form. So it really needs sensitization. This gender, this term which have been specifically given in clause 2, and apart from that, the two exceptions of the definition of rape. If you look, the two exceptions, one is if somebody touches upon a woman with the intention of some medical procedure. Another is a husband into a sexual relationship with his wife will not be called as rape if the wife is above 18 years of age, which is quite objectionable, and most of you must be knowing, because the word consent they have already defined very elaborately. Consent, will, all the words have been, and consent have been so specifically, I will just read this word consent, an unequivocal voluntary agreement when the women by word, gestures, or any form of verbal or non-verbal communication communicates willingness to participate in that specific sexual act. So, and the age of consent, which was earlier 16 years, now has been raised to 18 years. But the question is not that. In fact, a case which is Independent Thoughts versus Union of India. It was in the High Court, and it went to the Supreme Court now, whereby the question is not whether it is raised from 16 to 18 years. The question is, even a woman who is above 18 years of age and does not consent into the sexual relationship, even with her husband, it will amount to marital rape. And this term has been actually suggested many times, even the previous time, and right now, when we were entering into a new era in the form of BNS, which we feel is a very, it will be a very effective and efficient framework for addressing all sort of crimes. And we are also talking about victim-centric justice, but it has not been taken care at all. Marital rape has not been taken care at all. We are just following. However, we know many of the countries across the world, they have come up with this law. They long back. And in our country also, the debate is going for long, but we have not addressed that. Second thing is, we have, on the one hand, we are talking about the gender-neutral offenses, gender-neutral crimes. We have also defined the term gender, transgender, in the definition clause of the BNS, where earlier it was male or female was defined, but today we have transgender. But unfortunately, there is no crime have been specified under the whole BNS, which is against the transgenders. And all of you must be knowing that we have a law also passed in 2019, which is about the rights of the transgenders. But in the criminal law, which is BNS, we have not addressed, there's no gender inclusivity. Though we want to make most of the laws as gender neutral. There are some whereby you will see in place of male, they have said whoever in the morning session, you might have noticed. I'll tell you further. And with regard to the section which the moderator just mentioned, It is about sexual assault by deceitful means, which is a newly added section of Bharatiya Nyaya Sanhita. In fact, it is a type of overlapping. If you read, section 63 itself, you will find the similar type of wordings in that section on false promise of marriage, and especially in this world where youngsters are here, they know there's lots of culture of live-in relationship is going on, and later on the complaints of rape of the same sexual relationship, which was earlier maybe voluntary, but later on if it is without the consent, and then it is coming. So the punishment is severe, but that's a welcome section. It should be actually interpreted positively, then it's a very good section. Also we have some more things which requires consideration apart from, taking, if you was at this point of time, you must have, that Justice Verma Committee report very specifically given good recommendations about the offenses against women, and your concern with regard to women and children offenses by putting them in a separate chapter, by organizing them in a manner. So I think that could have been taken into consideration, because very shortly we will be requiring these changes. The debate is already on. Again, after Verma Committee report, we had this section 354 in the IPC, which was about the outraging the modesty of the women. So in this, and then later on, A, B, C, D were added, which was about, voyeurism and other type of assault. So now they are, some of them, not all of them, they have become gender neutral. That's a good move. Others could have also been made gender neutral, but it is not. If you see section 77 BNS, which creates liability of a person irrespective of who the other side is. So this is the time we are talking about the gender neutrality even in other offenses also, like we have sexual harassment of women at workplace law, which was also passed way back in 2013. It's a very gender-specific law, and some of the questions are already starting arising. Okay, a woman cannot harass a man, but can a woman harass a woman? So these are all changes which require, and which is the need of the time. Then I'm just going on to give few more points which came to my mind. Yeah, you can. Thank you.
With respect to the ma'am's comment regarding sexual intercourse by deceitful means, a new section has been added. I find there are police officers also here. So one reason why 376, the ex-IPC section, and rape as such was trivialized by police station people, because there are substantial number of cases which are technical, because in police language we say that technical case, because there is actually a consent, but the woman reports a forceful intercourse after the marriage doesn't happen, or if there are issues in relationship later. So because of such overload of such, or like whatever number of such cases, there was an attitude of trivializing the actual reports, with a prima facie intention कि ये तो consent किया होगा. So to that extent, it's a welcome step that a new provision has been put where sexual intercourse by using deceitful means, false promise of marriage also comes under it. But I am just worried, ma'am, about the extent of punishment that has been given for it, which is up to 10 years. Right. So it's a welcome in one way that there is a new provision, but then making it almost as severe as a rape would not serve that purpose. Thank you.
Thank you, Chani. Sir, I'll come back to you, because you made a very interesting observation regarding the efficacy of this provision, which is advocated as a reformative provision in the new law, BNSS in particular, where they have reduced the period for which under trial prisoner can be detained in the prison. As we know, as per section this 479 of BNSS, if there is an under trial who is facing trial in the court, and if this person is a first time offender without any previous history of conviction, and if this person has undergone 1/3 of the maximum punishment under that particular section, then this person is entitled to be released on default bail, or I mean released on bail by the court, and the onus of making the application is on the jail superintendent. So earlier this period was 1/2, it has been reduced to 1/3 for first time offenders without previous conviction. Now you say that this is going to remain on paper, and it is not going to be of any help, because you say that those who are charged for more than one offense, then they will not be getting any benefit. But if we read the explanation 2 given in this 479, I'll read it for the benefit of audience what it says. Notwithstanding anything contained in subsection 1 and subject to the third proviso thereof, where an investigation, inquiry, or trial in more than one offense or in multiple cases are pending against a person, he shall not be released on bail by the court. In any case, what it means, someone who, in addition to this case under trial, if against the same person there is an under investigation matter or some other under trial matter, then in that case this person shall not be entitled to be released on bail. But in case there is no pending matter against this person, and this was the only pending trial against this, and he is a first time offender without previous conviction history, in that case I don't see there is any problem why this person shall not be released.
Please read subsection 2. It starts with non-abstante clause. Notwithstanding anything in subsection 1. Forget about what is said in subsection 1 and read this hereafter. The subject to the third proviso, where an investigation, inquiry, or trial is more than one offense, means in the same FIR there are more than one offense, or in multiple cases where more than one FIR is there pending against the person, he shall not be released on bail by the court. So what is the important thing? This non-abstante clause, notwithstanding, meaning thereby everything is washed off. Read this provision, it will prevail. Second objection is, yes, second objection is, earlier in 436A, only those who were facing penalty for an offense which was punishable with death, only they were denied this right. Now, they've also included life imprisonment in that. And in IPC, there are more than 100 sections where life imprisonment is the punishment. And all heinous offenses, 100, more than 100, read sir. Right? More than 100. सर रेप में ही देख लीजिएगा 8-10 तो वहीं मिल जाएंगी. Yes, बहुत ज़्यादा है. So they are also not covered, meaning thereby all heinous offenders, they will not get this benefit. So they have expanded the scope of not giving the benefit further by increasing the number of sections. Secondly, by giving this caveat, notwithstanding section 1, nobody will be released. So this was my observation, that somebody has very cleverly crafted it, drafted it or crafted it, that nobody will be eligible. So when I was taking classes for jail superintendent on these topics, I told them, don't worry, nobody would be eligible by that time. So here we need some thought.
Sir, you have made a very valid point. I'll go to Ramanujam sir. In your opening remarks, you mentioned about, I think there is a concern from the human rights groups about the extension in the period of police custody. That is, you are talking about the new section 187 of PNSS. So if those of us who listened to the speech of the Honorable Home Minister on this particular section, he clarified, and I think in a subsequent press conference also, that as far as the total period of police custody is concerned, it has not been increased. Earlier also it was 15 days, and here also in the new provision it can't go more than 15 days. It can't exceed 15 days if we read carefully section 187 subsection 2. Then further it was clarified what we have changed is only the period up to which you can seek police custody remand, because those of us who will know, it was in this Supreme Court judgment in Anupam Kulkarni versus CBI in the year 1992 that the apex court held that once you arrest a person, then from the day of arrest, it is only up to the first 15 days that you can seek police custody remand. From the 16th day onwards, the custody could only be judicial custody. So keeping in view the practical difficulties the police were facing because of this ruling, what they've changed is that now this police custody remand of 15 days, you would be able to seek up to 40 days or 60 days depending upon the period of punishment of that offense in which that person is being investigated. So, I mean, after this clarifications of what are the concerns of the human rights groups, on what grounds they are thinking that this period of police custody can go beyond 15 days.
What is the clarification? I don't know the clarification.
No, clarification, they say, I'm talking of the law.
Now, what does it mean?
It says it can't exceed 15 days.
No, it doesn't.
So, we can read. We have the book.
I'll just read, I'll explain that. See, the basic problem here, what is being pointed out is that if you take section 167 of the CRPC, it says the magistrate may authorize detention beyond the period of 15 days, otherwise than in custody of the police. That particular portion has been taken away. So if you see this 187.3, it simply says, the magistrate may authorize the detention of the accused person beyond the period of 15 days if he is satisfied, etc., etc. Now, it doesn't say what custody. So this could be interpreted to mean.
So there are issues of
that will be the issue. The second point is, one more point is, there is a lot of, there are different people have interpreted it in different ways. Some people say this allows maximum 15 days of custody anytime within the first 40 days or 60 days. Some people say it will allow police custody for the entire 40 to 60 days. Some people even go to the extent.
Part they have taken here because they say, sorry sir for this interpretation, they say like when we read this, not exceeding 15 days. For a term not exceeding 15 days. In subsection 2, it is made very clear whatever custody they are mentioning in subsection 2 will not go more than 15 days. That is for sure.
Subsection 2 does not talk about police custody. It only talks about, yeah.
Whatever custody, because it is this custody for which they have allowed you a period of 40 days or 60 days. But the period of the custody, we have to distinguish between two things here. Because the period of custody can't go more than 15 days is very clear. Though, of course, they don't mention police custody over here. That point is well taken. But whatever we interpret it to be, whether the judicial custody or police custody, it can't go for more than 15 days is very clear. What they say, they have increased the room, the number of days within which you can seek this police custody from the magistrate, One more observation, sir, I'd like to make for your consideration. In subsection 3, they say, not the custody in subsection 2. So the two custodies mentioned in subsection 2 and 3 have to be different. They can't be the same. Though it is a valid observation that they should have very clearly mentioned in subsection 2 the police custody word, and in subsection 3 otherwise than in police custody, as was the case before, then perhaps this confusion would have not arisen. But one thing we need to very clearly understand, the custody mentioned in subsection 2 and custody mentioned in subsection 3 can't be the same. It has to be different. So if we say in subsection 2 it is police custody, then in subsection 3 it has to be a custody other than police custody. By implication, that interpretation will hold good. It looks to me.
Yeah. That is the point. There is room for interpretation in different ways.
Room for improvement
See,
of language.
Precisely. In fact, I would say this section may be redrafted. Another point I don't understand, why are they bringing in 40 days and 60 days? What is the logic? There is no logic at all. In fact,
There are concerns, sir. Actually, if I
yeah, I'll finish this. So my point of view is, when the police have 60 days or 90 days for investigation, they need the leeway to question the accused anytime during this period. Why restrict it to 40 days? Let them give 15 days custody anytime during the 60 days or 90 days. This can be, actually, as you said, it is bad drafting. In fact, I will...
Simple reading creates a contradiction.
Precisely. That is precisely the
Simple
point.
reading creates a contradiction.
Actually, there is a lot of problem in the way the drafting has taken place. Plenty of reason for confusion. For instance, if you take matching.
I think they should add our notes now.
Pardon?
Yeah.
They should add some notes to clarify this.
To know the legislative intent.
Simply have to change language, that's all. Language.
I would request everyone to speak
Yeah,
with the mic.
yeah, because we are broadcasting. Sorry, sir, you made the right observation. But I think this is a very interesting section 187, and there are a lot of observations, questions which may come. Let us, I think, reserve it for future. I'll move on to Shani for a question. I think I'd like you to address the concerns relating to sections 105 and 185 of the BNSS. We know in section 185, because I think the audience also need to know, if you ask anyone which is one section in the BNSS which enforces police accountability, means makes police more accountable than before, it is section 105 of the BNSS. What it says, that whenever police would conduct any search, like under this chapter, means after obtaining warrant, or under section 185 BNSS, that is without warrant, it will have to mandatorily, compulsorily do the video recording of the entire process of the search, including seizures, signing of the list by the witnesses, what articles police is taking away, etc., etc. So again, this has raised implementation concerns, particularly in the police, because at times these searches go on for many hours, done at multiple locations. Issues of storage are there, and the further provision in the same law says that the recording will have to be provided either to the district magistrate or SDM or the judicial magistrate of the first class, as the case may be. So how the police intends to handle these concerns, will you like to address?
So thank you, sir. This is one particular section and mandate which has made the lives of police officers very, very difficult, because 105 BNSS and 185 mandates, mandatory, it's a shall provision where you are bound to video record, audio video electronic means, it says. The problem, one is with respect to the practical implementation, for which we have a session, but by using language in the law, by audio video electronic means, and preferably by mobile phones, I think this should have been avoided, because we have been talking of lot of nuances. I was just wondering if there is a scope for coming out with rules covering all the aspects that we are referring to, like in many countries, instead of going for, because there are a lot of nuances in PE, Zero FR, lot of new things which have come. Some of it are progressive, but like sitting on the dais, all of us have understood even the custody matter differently. So to leave out this, to avoid the scope of interpretation, is there any scope we can explore to come out with rules covering all the aspects? With respect to audio video electronic means, I would like to say, point out a confusion in law that is prevailing across. I think BPRND has also issued an SOP on audio video recording, which has been mostly copied as such by the states with minor modifications. The SOP says when audio video recording of the search and seizure is being made by the police officer, who has to, at the scene of crime, do so many things: collect the evidence, take a statement, keep the accused under detention, and he is also now expected to record the thing. You are not giving an extra person to the police station, because this requires a lot of institutional capacity building, lot of SOPs have come saying that it's not clear as to whether the investigating officer should do it himself or whether somebody else, or he can get it recorded. Let us presume that somebody else can get it recorded. At the scene of crime, imagine a road accident. He would be like managing the crowd. There might be a rastarogo at the scene of crime. The existing 3 or 4 people with whom he is going to the scene of crime itself is too less. Second, let me come back to the law, where in most of the SOP says after the audio video recording, it should be a certificate under 63 BSA should be given. I think when I read, we have to distinguish between procedural compliances, which I find in 105 and 185, it is a procedural compliance to bring accountability of police actions. We are not treating those audio video recording as electronic evidence. So 63 BSA is about admissibility of electronic evidence. So I think there is a misunderstanding, interpretation mistake where we think that in audio video recording there should be a certificate under 63A and B. How many audio part A and part B certificates you would require? Because there will be so many. In a single case there will be.
No, this is wrong. This is a wrong
interpretation. This is a wrong interpretation.
People are interpreting that way.
What I'm trying to say is, it's not required is what I'm trying to say, but already SOPs are issued which says, including the BPRND SOP, which says that that certificate is mandatory. And in the BPRND SOP, Part B certificate, there is a small box given, and it very specifically says Part B has to be signed by the forensic expert. Jain sir has already raised the issue of the expert. I'll not get into it. But what about Part A certificate? Part A. Now we'll go on to the certificate portion. Part A says about hash value and the algorithm used for hashing, for coming out with the hash value. Now we are thinking of a person sitting, giving us a CDR or big things when we are reading that. What about a jewelry shop fellow or a small Dukani fellows from whose computer you actually have to seize an electronic evidence? Will he understand what hash value is? Will he understand the kind of algorithm used? Now there is a legal mandate for that person who is handing over the electronic evidence to you to indicate the hash value and to indicate the algorithm used. I think we need to, there is a requirement to revisit that provision. Thank you, sir.
Thank you, Shani. I think keeping in view the paucity of time, we need to now throw open the floor for discussion. We can take a couple of questions. I'll request people who are helping us to provide mics to the audience. Can we have some mics, please? Yeah. So otherwise we can take from here in case it is not there. So I think Ashish sir raised his hand, so I'll request him to make his observation. Yeah.
Yeah. Yes. Thank you, Mr. Jain, for the opportunity here, and thank you for the panelists for wonderful observations that you made on the BNSS, BSA, and the BNS. Shani, just to tell you, in UP we did realize that the SOPs don't have the weight of law, so therefore we have come about with the Uttar Pradesh BNSS rules 2024, which covers all these aspects that you have mentioned. So it brings a bit of a legality to the whole thing. And you are right, I think we need to actually now come out with the rules also with the BNSS, all that. A question I want to throw up to the panelists, because I am a bit confused about this. There was this section 164 in the CRPC earlier, where a metropolitan or a judicial magistrate could record the confession. Now the equivalent section in the BNSS is 183. And interestingly, it says any magistrate of the district. So I'm confused. Does this give the right to record confession to even an executive magistrate of the district? And if that be so, it is pretty draconian. It's pretty draconian.
No. I think, is there anyone in the audience who says that no, here when they say magistrate, it can't be executive magistrate. It has to be a judicial magistrate only. Yes, please. Yes, yeah, from that side. Can we pass on the mic to the lady, please? Because that That has been clarified in certain parts of the BNSS. Someone needs to refer to that. Yeah. An executive magistrate won't be able to record, as far as I understand. No, 183. Yeah.
सर जहाँ पे जुडिशल मजिस्ट्रेट की बात मतलब मजिस्ट्रेट की बात की गई वहाँ पे जुडिशल मजिस्ट्रेट ही है, और जहाँ पे एग्जीक्यूटिव होगा वहाँ पे स्पेसिफिकली लिखा हुआ है.
हाँ, ये कहाँ पे लिखा हुआ है? ये चीज़ भी कहीं लिखी हुई है?
यस मैं
सेक्शन 3 में लिखी हुई है.
यस सर.
सेक्शन 3 अगर आप पढ़ेंगे BNSS का,
Yes,
वहाँ पे इस चीज़ को क्लैरिफाई किया गया है कि जहाँ मजिस्ट्रेट, अगर जुडिशियल मजिस्ट्रेट नहीं लिखा है तो भी वो जुडिशियल मजिस्ट्रेट ही माना जाएगा. अगर उस काम को एग्जीक्यूटिव मजिस्ट्रेट से कराना है तो हम स्पेसिफिकली लिखेंगे, तभी एग्जीक्यूटिव मजिस्ट्रेट उस काम को कर पाएगा. ये क्लैरिफिकेशन सेक्शन 3 में मिलेगा. दूसरा, फर्स्ट शेड्यूल में भी मिलेगा आपको. वहाँ पे भी उन्होंने थोड़ा सा लिखा है, अगर हम शेड्यूल पढ़ेंगे, कि जहाँ हम केवल मजिस्ट्रेट की बात कर रहे हैं, वहाँ जब तक हम स्पेसिफिकली नहीं बोलेंगे, हम उसको जुडिशियल मजिस्ट्रेट ही पढ़ेंगे. ये 2 क्लैरिफिकेशंस आपको BNSS में मिलेंगे. कन्फेशन नहीं, वो केवल एक ही पावर है सर, एग्जीक्यूटिव मजिस्ट्रेट को जो लिखा हुआ भी है. अगर आपको पुलिस कस्टडी रिमांड चाहिए किसी का, तो 7 डेज तक का एग्जीक्यूटिव मजिस्ट्रेट दे सकता है. वो है क्लियर. यस सर.
Actually, this, I think you referred to section 3 only. It's very clear, unless the context otherwise requires any reference in any law to a magistrate without any qualifying words, magistrate of the first class or a magistrate of the second class shall, in relation to that area, be construed as a reference to a judicial magistrate of the first class or judicial magistrate of the second class, as the case may be, exercising jurisdiction in that area. In fact, there's somebody else had raised this point during our discussion in this internal reforms also, because original CRPC amendment said when there is a death in police custody, the inquiry shall be conducted by a judicial magistrate. Whereas the BNSS omits that word judicial, so they said executive magistrate can also conduct the inquiry. But I pointed out that if you read it along with section 3, it has to be a judicial magistrate.
सर एक क्वेश्चन पूछना था मुझे.
हाँ जी, कौन? पूछिए पूछिए प्लीज. आप जरा.
सब इंस्पेक्टर मनीषा,
दिल्ली पुलिस.
यस सर.
हाँ जी, बताइए.
सर जो सेक्शन 185 है, सर्च बाय पुलिस ऑफिसर, सर उसमें जो सेक्शन सबसेक्शन 5 है उसमें दे रखा है कॉपी ऑफ एनी रिकॉर्ड्स मेड अंडर सबसेक्शन 1 एंड सबसेक्शन 3 सेल फोर्थ विद बट लेटर नोट देन 48 आवर्स. सर इसका मतलब ये है कि रिकॉर्ड जो हमें भेजना होगा मजिस्ट्रेट के पास, जो उसमें क्या केस डायरी भी जाएगी, जैसे रिकॉर्डिंग है, या जैसे हमने डोज नाम में DD एंट्री करी है कि हमें क्या सर्च करना है, तो क्या केस डायरी भी देनी होगी वहाँ पे?
ओके, गुड क्वेश्चन. ये सेक्शन क्या है 185?
सर्च बाय
ये
पुलिस
सर्च
ऑफिसर.
बाय ए पुलिस ऑफिसर विदाउट वारंट.
यस सर.
ठीक है. तो ये क्या कह रहा है, जो आपने चीज़ें सीज की है सर्च में, जो रिकॉर्ड आप लेके आए हैं, उसकी कॉपी या ओरिजिनल जो भी है वो आपको मजिस्ट्रेट को देना है. हम लोग अभी भी ऐसे ही करते हैं 165 में. देयर इज नॉट मच ऑफ डिफरेंस बिटवीन 165 एंड 185.
जो केस डायरी वाला सेक्शन, ये जो नया
उसको देखिए, केस डायरी से कंफ्यूज मत करिए. वो क्या लिख रहे हैं, पहले क्या था, इफ़ यू कंपेयर 165 एंड 185, पहले भी ये लिखा हुआ था कि ओनली व्हेन देयर आर एक्सेप्शनल सर्कमस्टांसेस, मीनिंग देयर बाय कि अगर आप कोर्ट से वारंट नहीं ले सकते, आपको लगता है कि जितना समय हम वारंट लेने में लगाएंगे तब तक तो ये जो हम जिस चीज़ को सीज करना चाहते हैं वो खुर्द-बुर्द हो जाएगी, तो इसलिए हमें पावर दिया हुआ है टू कलेक्ट एविडेंस एंड कंडक्ट सर्च इवन विदाउट वारंट. तो पहले ये था कि ये जो रीज़न है कि वाई डू यू वांट टू कंडक्ट सर्च विदाउट टेकिंग ए वारंट, ये कहाँ लिखना है, किस डॉक्यूमेंट में यू हैव टू रिकॉर्ड दिस रीज़न वाज नॉट स्पेसिफाइड इन सेक्शन 165. अब 185 में उसको क्लियर कर दिया कि आप केस डायरी में ये रीज़न रिकॉर्ड करेंगे. मजिस्ट्रेट को अगर देखना होगा कि वेदर दे वर जस्टिफाइबल ग्राउंड्स और नॉट फॉर डूइंग द सर्च विदाउट वारंट, तो आपको केस डायरी मजिस्ट्रेट को दिखानी होगी, कोर्ट को दिखानी होगी. वो जो नीचे वाला जो सबसेक्शन है 5 जिसकी आप बात कर रहे हैं, वो केस डायरी को कवर नहीं करता है ना. उसमें तो जो आप चीज़ लेके आए हो सर्च के दौरान, जो भी रिकॉर्ड लेके आए हो, डॉक्यूमेंट लेके आए हो, कोई मटेरियल थिंग लेके आए हो, उसकी कॉपी जो भी आपने सीजर मीमो बनाया है और जो भी कोई आर्टिकल सीज किए, दैट थिंग, दैट रिकॉर्ड यू विल हैव टू प्रोड्यूस टू द मजिस्ट्रेट. फिर क्या होता है, मजिस्ट्रेट से ऑथराइजेशन लेते हैं कि आई वांट टू कीप दिस थिंग्स फॉर द पर्पज ऑफ investigation. Otherwise, whatever you have seized from during search becomes the case property, the court property. तो उस चीज़ को क्लैरिफाई किया है.
Sir.
No, Dr. Nuzhat started off just explaining very briefly about the crimes against women and children, which have been combined. That's a welcome step. And the age of 18 years also is a very big step from our angle, who work for the children. Now, but then there are contradictions. I mean, the challenges are endless so far as children are concerned, more than women. See, the Juvenile Justice Act is a separate system of law and justice, all of us know. There are bodies like Juvenile Justice Board, Child Welfare Committee, District Child Protection Unit, Children's Court. They are all bodies which operate under JJ system, and there is no reference to them. There is a big problem. There is no reference to all these competent authorities, all these statutory bodies which are there, functional, and they deal with the children, whether the children happen to be victim, or they happen to be children in need of care and protection, or they happen to be juveniles. You understand? Just one small point.
Yeah, you are right.
Now, the point I am trying to make that Child and Adolescent Labor Prohibition Regulation Act, the definition of adolescent has been brought equal to child, 18 years, isn't it? It's good that marital rape goes up to 18 years because, again, according to child. The issue I am trying to raise that POCSO, the child labor laws, child adolescent labor laws, all these Juvenile Justice Act, all of them create series of crimes. Many crimes are there. And you know, surprisingly, we have been asking for it, no amendment is made. There are offenses under JJ Act which have been declared non-cognizable, although the punishment is more than 3 years. Right. And then non-cognizable and police not registering cases. The offenses against Child Labor Act, which are the police is not investigating those cases. Those things had to be rationalized and kind of brought together, at least interpretation, which is not there.
Absolutely agree with you. There are different sections here where they have created some minor changes, such as earlier the term minor was there, now they are saying child, and child means anybody who is less than 18 years or up to 18 years of age. So first of all, the definition of the word child have been taken care. Yeah, yeah. But with regard to, as you are saying, with regard to Juvenile Justice Act and all the, the authorities, all the, organizations which are taking care of the children's issues, there's no mention of it anywhere. There's no coordination, you will say. Even the POCSO Act, which already talked about the term sexual assault and grievous and heinous sexual assault, it has not been taken care here. So that's a...
Gender neutrality was brought in POCSO.
Yeah.
And the Justice Verma committee, we appeared. I also appeared.
There is gender neutrality, but here
it could be extended to adults also. And the problem of 377 could have been sorted out.
Right.
But it was not done. Even now it is not done.
No, and even regarding what you are saying, up to 18 years of age and marital rape and above 18, and a question which was put by the moderator with regard to deceitful means. In fact, even the judicial, if you look at the way the society and the way the system deals with it, despite having a constitution which talks about equality before the laws and equal protection and having ratifying many of the international conventions, including CEDAW. But when we see some of the judgments, which I have not named at that time, there are few judgments where the judges themselves say the person who has done some sexual assault or rape, marry, and then the offense will be over. So that's the attitude which is there in the system. We need to actually address these issues very seriously.
Community service was there in JJ Act.
Yeah, yeah.
It has been tested already.
Community service, actually, some of the judges are already using, and when we talk of restorative justice, and if you recall, if I'll given an opportunity by the moderator, if you watch one very old movie, Dushman, you will see the judge how beautifully put the hero on the community service, serving the family whose bread earner's death is caused, maybe, Rajesh Khanna. So community service is something, obviously to put the person on the correct side. The community service now, other issues, because they put in the law book in the form of one of the punishment, now how it will be checked, how it will be taken care, who will, how it will be given, and who will be monitoring, and all those issues are going on.
One small point, just one sentence, that generally it's believed that the changes, the actual changes, minus the changes brought because of court rulings, is just about 7 to 8%. The changes are very little in the overall scheme of things. because the architecture of the criminal justice system, which includes police and jail, was left untouched, rightly mentioned by Mr. Prakash Singh in the morning. So unless you change the architecture, the change in law is very, very difficult. That's the feeling. Okay, thank you.
I think I'm very positive and optimistic. Maybe slowly, gradually, when the things will be addressed, will be taken care, and the things will be all right. Suddenly,
yeah.
Thank you.
Just a minute, I think can we give a preference to the student?
I just have a question in continuation with this. So firstly, of course, this is very kind of connected with what Mr. Kant said, and also what you had mentioned earlier about transgender, because the whole status and definition of transgender, especially children, has changed over the years. Because earlier they were kept in isolation, or they were socially segregated, or they were not talked about. But now this is an open book, and their participation in society, in schools, in colleges, in general kind of habitat is fairly open. Now, I feel that according to the times, the kind of crime, even psychological trauma, which is sometimes caused because of, let's say, people not being sensitized or not being sensitive, that part is still neglected. And also, I'm talking of, say, even up to 18 years, even sexual crime against them is often goes unreported. So
Yes.
that's one area where I
Yeah,
would
ma'am.
like to draw your
So
attention.
I also wonder that transgenders, I think, are in the society from time immemorial, since we are there. But fortunately or unfortunately, for the past 2 decades, the subject matter has been under consideration. They are being taken care. The law has come. Some of the public spaces are being created. So the subject is there. And despite that, we have not addressed that issue at all in the criminal law, at all in this Bharatiya Nyaya Sanhita. In fact, to the extent of definition, in the definition the term transgender have been defined, but later on none of the offense have been specifically. Yeah, so I feel many cases are pending in the court. Some of them have been decided where we are talking about their rights. So this should be taken care. We are pointing it out. Maybe, hopefully, it will be taken up. Thank you.
I think we can have the next question from the student.
Good afternoon, everyone present here. Good afternoon, honorable panelists. I am Aditya Gupta from third year. I am a third year law student from Lloyd Law College. So my first 2 questions was, as mentioned by sir, why the offenses like adultery and bestiality and the crime against homosexuals is ignored by the new criminal laws. And other than that, I have 2 more questions. The first question is, why the punishments like murder and the aggravated form of murder like mob lynching and organized crimes have the same punishment as the murder? As even at the time of drafting of bills, the standing committee was of the view that the aggravated form of the murder, like mob lynching, should have more harsher punishment. And secondly, my question is, why the offenses like cheating and paper leaks, which are very serious in nature, are considered and mentioned in the petty organized crimes in this new criminal laws? That's all.
What is the punishment for murder? What is the punishment for murder?
Sir, death and
What
life
can be the punishment for aggravated murder? It is already there. And the discretion has been given to the judge that depending upon the gravity of the offense, he can award life imprisonment, or he can award life imprisonment till remainder of the life, or he can award death penalty. It is the option for the judge. So we should not put everything in black and white. Let us leave something to the discretion of the judge also. What was your second question?
But sir, these both offenses will create a same kind of deterrence. Like
that, leave it to the judge.
Okay.
If it is mob lynching, he can give death penalty. If it is simple murder in anger, he can give life imprisonment. And then let me tell you, you must not be knowing, there is again premature release of these convicts. And there is a standing committee of the government whereby after serving sentence of 14 years, case of every convict is to be considered by the government for premature release. And then they have graded this punishment, that if it is this murder, it will be after this much year. If this is that murder, it will be after this year. So government has already taken care of that in that scheme. Your second question I could not follow.
So my second question was, like offenses like paper leaks and cheating, which are very serious in nature, like the whole career of the students got affected by the paper leaks. Why these offenses are mentioned in the petty organized crimes?
Yes, that is a drafting mistake, and serious objection have been there, because they have said selling examination question paper. They have not qualified it whether it is question paper of last year, we all purchase and prepare in our examination, or it is for the future examination. They should have qualified it. So that is the mistake. It should have been clarified there.
Thank you, sir.
On the point you raised, there's a very valid point. In fact, if you see the original draft in the bill for mob lynching, although they didn't call it mob lynching, there was a provision for punishment of 7 years. Now the IPF memorandum pointed out that you are making mob lynching a lesser offense than murder. Yeah. Then they have modified it, put it both on the same thing. Now similarly, apart from this, there are other instances also. For instance, snatching. If you take snatching, the punishment is 3 years. For theft also, punishment is 3 years. Yeah. In fact, for the second conviction, an enhanced punishment can be given for theft, whereas that is not available for snatching. One more thing, interesting thing is, right of private defense is available to defend your property against theft and robbery. But right of private defense is not snatching is not included in that category. So essentially, this snatching has been defined in such a manner that I would say snatching in BNS is like the appendix in the human body. It serves no purpose, whereas it can cause a lot of problem.
In this context, I would also like to say that a new provision, organized crime, has been added with the rider, that for all these illegal acts, human trafficking, sale of weapons and all these things, if it comes under organized crime, if you are part of a organized crime syndicate, now there is no procedure as to who will declare who is a syndicate. How can you, what will be the evidence? How do you decide that somebody is a member? Are you leaving it to the officer in charge dreams that he will say कि हाँ ये उसका gang का है, ये इसका gang का है? So this organized crime syndicate is a very open term used without any qualifying riders as to how will it decide which is an organized, what is the procedure? Like there are laws which details the procedure, but this is lacking here. But I would also, the same thing that he raised, I was also, while reading the text, found that if a single person commits a murder, he can go up to death. But then if you're doing it as a contract killing, and by the way, the contract killing is outside the purview of organized, there are a lot of, so human trafficking is also included. But contract killing, you're killing somebody for ransom, they are not covered in organized crime at all, whereas we all are aware that there are such rackets functioning. Thank you.
Just a minute, because I think we are running short of time, we need to conclude. We'll have last two questions, one from sir and one from ma'am. So first, ma'am, if you permit, first I can take him, but then we'll have, and that will be the last question, I think, because of the paucity of time. Yeah, please.
Fair, sir. So after hanging my boots, I am now with Reliance Jio as a national nodal officer. And my team provides more than 5,000, 10,000 CDRs every day to the police. Now, till now, when 65B was there, we were giving one certificate. Now we have to give 2 certificates and along with the hash value and all. Of course, Shini made a bit reference to this CDR, but I want it to be elaborated. Who's the expert in this case, and who would sign this Part B of the certificate?
Sir had, in his remarks in the beginning of the day, referred to it, because the expert in 63 do not fit into any of the expert definitions that we understand, neither in 39 BSA nor the forensic expert as in 65 IT. I don't remember the section rightly, 79. So the expert, it requires clarification as to who that expert is. If you are referring, it cannot be a forensic expert for sure anyway, because as sir had already told in the morning, like I am from Odisha, there is not our facility, the State Forensic Science Laboratory, the cyber wing has not passed through this accreditation process, which is in the IT department, to be qualified a forensic expert. So if you look at there are references to in 329 BNSS also, where examiner of electronic evidence. So that will be the expert as per IT Act. But this definitely, because there are hundreds of not just CVRs, electronic evidence, for you it will be still limited. Imagine the kind of Part B certificates that have to come in all the electronic evidences seized by OCAN. Are there enough experts in each state to actually sign the Part B of the form? So this is something where there is an oversight in what that expert would be, and we would require that maybe in future this clarification will come or an amendment.
As I said, every day I'm providing more than 10,000 CDRs and IPDRs. More than 10,000 every day.
This is an area where nobody has really understood who that expert is.
Okay.
मैंने इसीलिए उसको रिजर्व रखा हुआ था, बिकॉज आई न्यू दैट वुड बी. इस पे और चर्चा करेंगे अगले सेशन में, और थोड़ा चर्चा करेंगे. नाउ आई विल रिक्वेस्ट मैम टू आस्क अ क्वेश्चन.
So that's, I think, the final question. There's not a question really. First of all, for the student, benefit of the student who's sitting at the back and who had put in the question regarding cheating, UP, I think, has made amendments, and we are now having 10 years punishment for cheating, 10 years of imprisonment for cheating. So that is a recent amendment. But I am here to again reinforce and reiterate, sir, which I would say an ambiguity as far as the concern goes of anybody who's married 18 years and above. And if it does not have a provision of a rape in it, then I'd like to question as to what happens to the women every day who is, if not physically, if she's physically abused, you have a section for it. She's beaten up, you have a section for it. She's murdered, you have a section for it. But if she is through intercourse punished day in and day out, then what is the section for it? Let me give you an example of the French lady who was abused by her husband, drugged 50 years into marriage, drugged and raped. I'm not talking about the rapes by other men, but the rape by her husband. What section did you have in this country to protect her? And if that be so, I also question the forum. I think all those who sat and made this law were probably all men sitting there. हम लोगों को अगर जोड़ दिया होता तो ऐसा section नहीं आता. Thank you.
Very valid, pertinent observation made by ma'am. I think though paucity of time doesn't permit, but in case there is any student, only the student, and particularly from this side, so who is that? Those who qualify the definition of a student, huh? Yeah, please. Sorry, ma'am. No, that we know, ma'am. That we know. Yes, please. हाँ,
मेरा क्वेश्चन ये है कि जब स्पेशल प्रोविज़न बनाया जाता है, जैसे कि वुमेन्स के लिए बनाया जा रहा है या चिल्ड्रन के लिए बनाया जा रहा है, उसके लिए स्पेसिफिकली इसलिए बनाया जा रहा है ताकि वो वनरेबल है, उनके खिलाफ इजीली क्राइम हो सकता है, इसलिए उसको भारतीय न्याय संहिता में स्पेशली मेंशन भी कर रखा है. क्या पर्सन विद डिसेबिलिटी को मेंशन किया गया है? प्रोविज़न तो बना रखे हैं, RPWD एक्ट 2016 बना हुआ है प्रॉपर्ली, पर उसको कोई जानता भी है? UPSC के थ्रू क्लियर, मतलब पढ़ने के लिए तो पढ़ लेते होंगे, पर किसी को RPWD एक्ट 2016 पता भी है? मतलब राइट्स ऑफ पर्सन विद डिसेबिलिटीज़ के, मतलब अगर उनके खिलाफ कोई क्राइम हो रहा है तो उसका क्या होगा, उसके लिए क्या प्रोविज़न है? इस पहला क्वेश्चन ये है. दूसरा ये है कि जो क्या कहते हैं, मैंने सुना है कि कहते हैं जो अपना FIR है, FIR के अंदर अगर पर्सन विद डिसेबिलिटी क्रिमिनल है तो उसके लिए तो सेक्शन है कि वो पर्सन विद डिसेबिलिटी क्रिमिनल है, पर अगर वो है क्या कहते हैं विक्टिम है तो उसके लिए कोई ऑप्शन नहीं है कि पर्सन विद डिसेबिलिटी की एक विक्टिम है, उसका कोई वो नहीं है कि उससे ये होता है नुकसान कि पर्सन विद डिसेबिलिटी के खिलाफ कितने क्राइम हो रहे हैं, वो डेटा ही नहीं आ पाता.
बहुत बढ़िया सवाल है आपका. क्या शुभ नाम आपका?
आशुतोष सिंघल.
आशुतोष, आपने मेंशन किया राइट्स ऑफ पर्सन विद डिसेबिलिटी एक्ट 2016 और 6. It was
16.
उसमें बहुत सारी डिटेल्ड में राइट्स हैं आप लोगों के, एजुकेशनल राइट्स हैं और दूसरे प्रोटेक्शन के राइट्स हैं, उसके बारे में अवेयरनेस नहीं है अभी सोसाइटी में, और जुडिशरी अवेयर है। अभी जुडिशल एकेडमी चंडीगढ़ में इस पे एक सेमिनार हुआ था, बहुत ज़बरदस्त तरीके से डिटेल में भी हुई थी, बहस भी हुई थी, और नेशनल लेवल पे मैंडेट था कि आप इसको बताइएगा कि किस तरीके से इनको कवर किया जा सकता है। मैं आपको बता दूं जे एक्ट में ये प्रोविजन है कि अगर विक्टिम जो है वो विद डिसेबिलिटी है तो पनिशमेंट 1.5 है, तो वहाँ पे विक्टिम का राइट क्रिएट किया गया। लेकिन जो जनरल लॉ है, BNS है या दूसरा लॉ है, उसमें डिस्टिंग्विश नहीं किया गया है राइट टू पर्सन विद डिसेबिलिटी, लेकिन जुवेनाइल के केस में वो है, पनिशमेंट इनहांस्ड है इफ द विक्टिम इज पर्सन विद डिसेबिलिटी।
Unsound mind, a type of person who is having some type of disability, but regarding any physical disability or the disability as defined in Right of Persons with Disability Act 2016, you are right, it is nowhere. The ambit can be increased with regard to offenses committed against the persons with disabilities. Agree with you, this require attention.
Can you hear? I think this consultation on disability, especially vis-a-vis children, is going on. And I remember when there was a session in the High Court in my state, I tried to find out from the data that we have as to how many, I just wanted to know what are the difficulties the people with disabilities as victim face when they go to a police station. And the data was absolutely missing. We had, as part of the consultation, suggested that in the IIF form, there has to be a drop-down menu where you will have an option to click mark, like you are capturing the data of the child now, which was not there earlier. So it's time that we actually capture the data with respect to people with disability. And it's a very valid point raised. And we have already put that as a recommendation from the Odisha High Court Juvenile Justice Committee. Thank you.
Thank you. I'll end this session by thanking my co-panelists, the panelists of this panel. They were very lucid, I think, in their responses, their observations, and making the opening remarks. And I think we had a very wonderful session, though because of the paucity of time, we had to cut it short. Thank you so much. And
I'll take leave. I'll go to Gautam Ghosh.
Just quickly change that.
See you then.
See you, sir. We'll be here in case you are able to come back.
I'll just go there.
Yes. Excellent. Excellent.
Thank you, sir.
Please have.
Yes, thank you, sir.
The next session.
yes, sir.
Yeah. Hello, I am Ramchandran. Harmeet. If you like to stay, you have to come. I had to go, then please carry on. Thank you so much. Thank you so much. I'll come and see you. Let me make an announcement and then I'll come and see you.
Sir.
No, sir, I'll come.
Sir ji.
May I request, excuse me, may I request the next session, excuse me, may I request members of the next panel, the panelists, to come up to the stage. The other panelists are missing. You also leaving? Huh? You not? Okay. So why don't you stay and ask the question again? That is something we are also worried about, whether the case itself will fall down. And we don't have the, the capacity.
Exactly. My colleague will be happy to speak about capacity.
Why don't you stay on the organ to finish it off? Thank you. I think we will need 6 or 7. You will be here also.
I'll be here, but
When we left.
4 plus 2, 6.
We have
5 plus 2.
Amit,
I think 5 plus 2.
Amit, Viplav, Chaya is there.
So we need 6.
Yeah. 6. May I request other members of the panel to come up? Please be seated. Huh? Where is Hadi? What is your posting now? Please be seated. You have brought some very impressive books. Please be seated. Yeah. You have the name, please. Yeah. You are the moderator, so we have to keep you tight. Amit, you can start straight away.
Right, sir. Good afternoon, ladies and gentlemen. We've had a very interesting session, and if you go through your invitation cards and schedules, you will not see my name there. So I'm actually a filler. My friend and colleague couldn't come. I was in town from Assam. So मैं stopgap arrangement हूँ.
Introduce yourself first.
तो मेरा काम भी थोड़ा स्टॉप गैप रहे तो बुरा मत मानिएगा. My name is Harmeet Singh. I'm an IPS officer of the 1992 batch. And I'm posted in Assam. बाकी क्या बताऊं sir? इतना ही काफी.
Your designation.
Sir, there are too many of them. So don't laugh. I'm Director General Civil Defense and Commandant General Home Guard. I'm Director Fire Services. I'm Special DGP Police Headquarters with all the police branches reporting to me, including Law and Order. And I'm also Special Director General of Police Border. तो मतलब कोलू का बैल हूँ जिसके ऊपर सब कुछ लादा गया है. But you know, before I start, I want to put something in perspective, that the world is changing and these new laws are actually a very progressive step which accepts that change and prepares us for the future. जब भी कोई नई चीज, you don't mind if I shift between English and Hindi. तो जब भी कोई नई चीज होती है तो 90% of the world is status quoist, वो उसको थोड़ा सा resist करते हैं. And as a result, we first look for the loopholes or the problems that face us and start talking about them rather than seeing the positives of what is in the new. Having said that, I would suggest that we look at the new laws vis-a-vis, as our topic says for today, implementation challenges, where we look for solutions. And I may share with you that just last week, there was a nationwide conference hosted by the MHA, the IB, where the highest formations were present. And the result on the session on new laws was as simple as this, that the highest formations involved with this were very clear कि आप लोग जहाँ जहाँ समस्या या बाधा आ रही है उसको काइंडली कोलेट करके और सरकार को पेश करें so that those can be solved. So I would thank the Indian Police Foundation and all of you here today, especially my co-panelists, some of whom are very old friends, we work together, to look at this entire session that the Indian Police Foundation has put together so that recommendations can go as to what those who are knowledgeable and those who are on the ground feel needs to be done. Having said that, I will only act as a moderator. I have very erudite and knowledgeable colleagues here. So I will just list out certain points where we feel that attention is needed, and then maybe start with the lady and we'll come down this way on what. So let me first look at the futuristic aspect of the new law is the amount of importance given to forensics. So where is the challenge here? The challenge here is the manpower and infrastructure required. All states have started working on this, but I think there is possibly a need to speed it up and possibly infuse more funds in it. It's a great thing that we already have a National Forensic Science University. We have other forensic institutes, so the manpower is already out there, they are already graduating. As I said, learning and unlearning of old and new laws is an issue which needs to be done. While we were talking in the last session, there was a young boy who raised the issue of the rights of Divyangs. Even as far as this law is concerned, I think a lot of public awareness needs to be brought about. Another thing which came up in the last session is another challenge, which I told the gentleman from Geo, कि ये इस session में जैन साहब इसको address करेंगे. Yes, the question of electronic evidence and the amount of digitization that has come out with the new act, particularly the certificate required by experts under section 63B of BSA,
The definition and availability of such experts is the challenge that needs to be met. मैं बिल्कुल समझ सकता हूँ कि CDR, SDR, CAF में second form भी कौन भरेगा, ये एक सवाल है, but I am sure once this is put up to government, इसका जवाब आएगा. So information from TSPs, ISPs and intermediaries is a question. Now the question is the facilities for audio, video and electronic means at the district, subdivisional and police station level. That is another part of infrastructure. So I am looking at, my colleagues will deal with the entire gamut of the laws and the sections, but I am looking at the systemic requirements because we must look at the systemic requirements. So the facilities for audio, video and electronic means at district, subdivision and police station level is a must, both for witnesses and for recording of evidence. The compulsory recording of search and seizure. पिछली कॉन्फ्रेंस में डायरेक्टर CBI ने और दूसरों ने ये सवाल उठाया कि where you have multiple seizures across the country or across a state running into hours, a raid, आपने वो पिक्चर देखी होगी, raid 3 दिन चली. Now how do you record something that is going on for such a long time? So that is a clarification and a challenge which I'm sure once it is sought will be available. We already, I think in the last session, Shiny spoke about it, is the practical implementation of the zero FIR. Who actually takes the final call and whether it's a PE or what, that is something that we need to look at. Even electronic summons in a digital form, which is there in the new law. Now, how and where will that get implemented? What will be the SOP? Or as the gentleman and lady, my seniors from UP said, that UP has come out with rules for the new laws. So maybe at the central government level, maybe some forum will suggest to the government that there possibly need to be rules to interpret. Question of receiving information through electronic communication. आपको एक email आया, आपने उस पे EFIR तो ले लिया, but वो असली है या नहीं है is something, because in Assam we had already set up Assam Police Seva Setu, which has the maximum services available anywhere in the country, police services. This question did come up many times. Who will finally sign that thing and how do we verify? So this is a minor point, but as we will be inundated with EFIRs and e-complaints, we will have to handle this. Now, there are all our young legal eagles at the back who are going to join either the bar or the judiciary later. The creation of a prosecution vertical, that is very much a part of the law, but how many states have moved forward, we have to look at that. We have, us din Delhi Police Commissioner साहब ने बताया conference में, they are moving forward on it. We are creating a service, many states are doing it, but that entire process, कौन होगा डायरेक्टर ऑफ प्रोसिक्यूशन, डेप्टीज कौन होंगे, क्या होगा, उनका स्ट्रक्चर क्या होगा, सिस्टम क्या होगा, that is coming up and that is something which again is not an insurmountable challenge. Everything I'm mentioning here are not insurmountable challenges. So we have to look at the whole thing progressively and look for how do we find the solution, how do we go to government and say on the ground or as per our knowledge, हमको ये addition या subtraction होने से ये फायदा होता है. Registration of PE की बात पिछले session में हुई, I don't want to repeat it. The question, there is another question, ये special executive magistrate का सवाल है. Yesterday we amongst ourselves had a very interesting session thanks to WhatsApp where we exchanged ideas. So this also came up. For other departments there's no bar, but police में SP के नीचे नहीं हो सकता. Now, जिले में तो एक ही SP होता है. So how do we handle that? The courts interpreting what to do pre and post 1st of July. So BNSS पहली जुलाई के बाद हुए केसेस पे लगेगा या कुछ कोर्ट्स ने कहा है कि नहीं साहब पहले के भी जो प्रोसीडिंग्स है उनको BNSS में ले आइए. So this is a question that will need to be answered. There is also, like the Western countries, developed countries, witness protection is a part of the law. Assam, I know because we are part of it, has already moved. It's under government approval, a witness protection scheme. But witness protection schemes with the concurrent logistics and finances will be needed for witness protection. 377 IPC ki baat ho chuki. I know my colleagues are going to do it again. There's also one more question vis-a-vis sexual offenses. The possible misuse of the new section 69, which I think one of my colleagues is going to talk about. The timeline given for postmortems in rape cases is another issue because it's 7 days. So if every doctor starts taking it at 7 days is my minimum, then major cases will have issues, and these days such sensitive cases also have a public reaction. I think there is one more thing that I'd like to point out before I wrap up and ask my colleagues to take over, is the discretion of the SP under 113 to decide whether an offense is under BNS or UAPA. So I think Ashish is going to be dealing with UAPA. In this, of course, I also have to say that central organizations like CBI and NIA have a different investigation system and setup than state polices. So how they will also adapt, I think Mr. Jain and Ashish can talk about it. So I think we should start with Chayaji, who will be handling challenges relating to capacity building, her experience of training Delhi police personnel, and issues relating to admissibility of digital evidence as per provision in section 63 of the Indian Evidence Act. So that's all I had to say. So stopgap का काम थोड़ा stopgap ही होता है. Thank you so much.
So at the outset, I'd like to thank the Indian Police Forum for having given me this opportunity to speak to you. So respected my co-panelists and DC Jain sir and seniors sitting in the audience and my dear friends from the police and the legal fraternity. I was looking after training, and just the day I joined as special CP training, I was asked to create material for 90,000 police officials of Delhi police, and so that they understand the new laws. So at that point in time, when 25th December, just the bill had come, I had copies of the bills only, and not even the actual act had come. Printing, it had been enacted, but the print had not happened. So we had just one copy of the taxman, and that was all that we had. And CP sir told me that I have to go and create books or maybe some material so that the lowest common denominator in our department understands what the new law is. So first of all, it was a big challenge. Thanks to sir, he allowed me to create a small team. We included a lot of officers who knew law, some seniors, some juniors, some retired personnel, and 2-3 advocates also, so that they become our devil's advocate. And we told them that आपके पूरी freedom है, हम जो करें आप हमें question कीजिए, and please make us uncomfortable, because we don't want that our books should go out and people should laugh at us that what have you created. And we also realized that अभी तक जो पढ़ाई हो रही थी उसमें बेयर एक्ट लेके जो हमारे टीचर्स थे, लॉ के ट्यूटर्स थे, वो पढ़ा रहे थे, बट दे वर यूजिंग द बेयर एक्ट. सो टेक्निकली हैंडबुक कोई नहीं थी जिसमें हम पुलिस को पुलिस के बारे में पुलिस के तरीके से पढ़ाएं. सो दैट गैप वी हैड टू कवर. सो हम लोग बैठे करीब 28 दिसंबर से हमने बैठना शुरू किया, और बिफोर 26 जनवरी हमने 3 हैंडबुक्स क्रिएट करी, जिसमें एक हैंडबुक BNS पे थी, एक BNSS पे थी और एक BSA पे थी. तीनों हैंडबुक्स का जो अल्टीमेट मीनिंग था, द फील वाज दैट इफ़ some ASI or a head constable, even if he's about to retire in 2 years, should not feel uncomfortable. He should be able to hold the book and understand what is my job and how do I have to go about it. What are the sections? What has it change come? Because now if you take the bare act, you wouldn't know what the change is because it's not highlighted, it's not given separately. It is the act. Now it's the new act. So what we did was we abridged sections from the act where we felt that change is there. We put it in color and we highlighted those portions so that it is easy to make out. And then we gave comments. So we made those booklets pretty early. And then by now, we also created a compendium of 20 scenarios, like what happens if it is a snatching case. So our CP sir had given us the guideline that we have to create a guide, something like an idiot's guide, where anybody who doesn't know anything about how he would have to register a FIR, and like Shiny was mentioning, right from the time a call or an information comes to the police station, up to the fact that the final chart sheet is made, what he has to do, all step-wise guide. So that we identified 20 scenarios initially, and we made that stepwise guide, largely based on Tamil Nadu's writer's card. And after having said that, we made sure that what we started doing was that we made a compendium, like whatever forms they would be needing for the new, we made those forms also. And then we started a phase-wise process. How do we start teaching our guys, like which segment to start first? Because in January we thought it was March that they will start implementing it, but then later on, as it luck would have it, it happened in July, 1st of July. So we did phase-wise. First, the cutting edge. Second, the people who may be in traffic or armed police, well, again, we will be meeting. And we made sessions for them, 5-day sessions, and we taught all the 3 laws. The first most important challenge that we needed to take out the fear was that it's not like a unsurmountable thing. It's something which is easy and it is possible for them to do. So having said that, I think we've been very lucky, a lot of support, and we were able to do this because we did trainers. We identified good officers from districts, and we created 45 master trainers. They trained the first lot of our cutting edge people from all over the thanas. So by the time it was March end, they were ready. Suppose any new FIR needed to be registered, they would be able to do that. And also, the biggest challenge was that in the training academies, we were now had to teach not only the new law, but the old law also. Because for another 5, 6 years or 10 years, you will still have to deal with the old laws also. So this was a big challenge. Having said that, we were able to incorporate stakeholders also, and that was very important. First the prisons, then the NAIB courts, then the newly recruited magistrates. We tied up with the Judicial Academy. So a lot of things we did, and we made sure that whoever and who was ready to learn from us, we were able to give them training. And lastly, we trained about 80 executive magistrates also from the Delhi government. So having said that, I'm supposed to speak on admissibility of the digital evidence. So a lot of portion I think Shiny had covered, but as and when we speak on that, when we will speak independently, I will speak. But the most important part that we have to understand is that digital evidence has created a lot of procedural issues for us, challenges for us, how we will pick it up, how we will record, and how we will make it admissible in the court. This bit about hashtag value, the integrity of chain of command, how we're going to store it, where we're going to store it, is it going to be primary evidence, secondary evidence? So all that we will discuss, and as and when we progress through our this thing. Thank you, sir.
Before I pass the floor on to Anil Kishore Yadav, who will speak on proclaimed offenders, trial in absentia and related issues. On the training part, Chaya, I just have a query for you, and it involves everybody in the house, that while on the judicial side there is an equal amount of training going on, and while on our side, the police, there's an equal amount of training going on, there are other stakeholders like the civil administration and the health authorities, because the health authorities play a very major role. So did you move towards that and do something there, or are other states doing, so later my other friends can also handle this question, because if everybody is not on board, all stakeholders are not on board, then we will continue facing roadblocks.
I agree, we have this medley pass activated, which is not in place right now, where the reports, the medical reports have to come in a time-bound manner. So once that gets enforced, only then we can force these people to come and have, because it's only a very short part of the new law which we will have to cover. But we are in consultation with the senior officials of the main hospitals in Delhi. But I think once they are ready with the medley power issue and they are able to provide that, I think only then they will come for training. So as of now, not the medical fraternity.
सर थैंक यू सर. इसमें छाया वाली इसी बातों में थोड़ा एक जोड़ना चाहूँगा. हम लोग CAPT सेंट्रल एकेडमी फॉर पुलिस ट्रेनिंग इन भोपाल under BPR&D, we have been conducting these capacity building programs for 5 major pillars, and also sir we are going to plan a national level this conference, 2 days conference on 7th and 8th October. There we will call medico-legal experts also, those doctors who are handling those autopsies, postmortem reports and all those. Sir, thank you. Jai Hind, madam, sirs, or dear students. I would like to talk about related issues, proclaimed offenders. Proclaimed offenders is one of those most enabling reforms. Earlier, पहले हमारे IPC की मात्र 19 sections defined थे under section 82 subsection 4 CRPC. उसमें proclaimed offenders deal करता है 82 section CRPC का. अभी section 84 है BNSS का. उसमें 4 subsections हैं. Subsection 1 to subsection 3 there is no change at all. CRPC and BNSS there is no difference. But there is huge difference in subsection 4 of these respective corresponding provisions. So what has happened with this new reform? This scope of proclaimed offenders, it has been expanded limitlessly. Under section 82 subsection 4 of CRPC, there were only 19 specific sections of Indian Penal Code were mentioned, जिसमें रॉबरी, डकैती और मर्डर इस तरह के सेक्शन और मिसचीफ थ्रू फायर और एक्सप्लोसिव्स इस तरह के सर्टेन मोस्ट सीरियस सेक्शन जो उन्होंने कंसीडर किए, उन्हीं के लिए प्रोक्लेम्ड ऑफेंडर्स वाले प्रोविज़न उसमें थे. लेकिन अभी 82(4) सबसेक्शन 4 BNSS में बाय रिप्लेसिंग दीज specifically mentioned provisions, they have provided making it applicable to all offences punishable for imprisonment for the term of 10 years or more than 10 years, life imprisonment and death penalty. So by a single stroke, this is going to expand this scope limitlessly. 19 की जगह पर हमारे not only these हमने उसको enumerate किया, तो there are 85 sections in the BNS itself जहाँ punishment 10 years or more than 10 years LI and death penalty तक जाता है. तो 85 19 की जगह 5 गुने तो यहाँ हो गए. And this will be applicable to every law for time being enforced. सभी special acts पे भी लागू होगा जहाँ भी 10 साल से ज़्यादा जिन offences में सज़ा है 10 या उससे ज़्यादा. तो ये इसका विस्तार बहुत हो गया है. इसका फ़ायदा जो प्रोक्लेम्ड ऑफेंडर से रिलेटेड प्रोविजंस हैं, लाइक सेक्शन 34 BNSS, जहाँ विलेज ऑफिसर जो भी रिलेटेड हैं उनको सबकी रेस्पॉन्सिबिलिटी रहेगी. प्रोक्लेम्ड ऑफेंडर कहीं उनके इलाके में कहीं आने जाने की सूचना है तो वो रिपोर्ट करेंगे. इस तरह की जो चीज़ें हैं, इससे भी बड़ा इसका बहुत ही क्रांतिकारी जो एक और हमारा इनोवेशन है हमारे इसमें, हालांकि इंडियन सब कॉन्टिनेंट में दैट इज़ 1982 में बांग्लादेश वाज द फर्स्ट टू इनोवेट ऑन दैट अकाउंट, ट्रायल इन एब्सेंसिया. उन्होंने 1982 में सेक्शन 339B कैपिटल एंड कैपिटल C 339 उसके माध्यम से उन्होंने उनका वहाँ वही अंग्रेज़ वाला ही चला आ रहा है CRPC 1898 वाला, उसके माध्यम से उन्होंने किया था. और अपने यहाँ झारखंड में कोड ऑफ क्रिमिनल प्रोसीजर अमेंडमेंट एक्ट 2020 जो कि 22 में झारखंड का एक्ट नंबर 6 है, उसके माध्यम से उन्होंने सेक्शन 299 सीआरपीसी में अमेंडमेंट करके उसको लेके आए। और हमारे यहाँ जो 356 है ट्रायल इन एब्सेंसिया, उसमें प्रोक्लेम्ड ऑफेंडर के लिए है बाय डिफ़ॉल्ट, लेकिन लॉ मेकर्स ने इसको रखा है सेक्शन, जिसका लास्ट सेक्शन सबसेक्शन 8वां है, उसके माध्यम से स्टेट गवर्नमेंट्स को एम्पावर्ड कर दिया है मात्र नोटिफिकेशन के माध्यम से ही इसका विस्तार बढ़ाने का, जो नॉट ओनली प्रोक्लेम्ड ऑफेंडर्स के जो ये जो प्रोविजन है 10 साल वाले, बल्कि सबसेक्शन 1 के अधीन हैं जो प्रोक्लेम्ड पर्सन वाली कैटेगरी में आते हैं, उन पर भी सर्टेन ऑफेंसेज या उनकी कैटेगरी ऑफ ऑफेंसेज में वे विस्तारित कर सकेंगे स्टेट गवर्नमेंट्स। तो ये ट्रायल इन एब्सेंसिया के माध्यम से, जैसा सुबह के सेशन में भी उनमें भी बात हुई, बाहर हैं हमारे देश से या फिर हमारे देश के अंदर हैं और वो थकाते हैं सिस्टम को, फटीग, विक्टिम और विटनेसेस को, और उसके बाद अपना बाद में फेवरेबल जब टाइम आता है तब सरेंडर करेंगे या पकड़ में आएंगे, तो ऐसे में हम कर सकते हैं। लेकिन यहाँ एक मैंने जो अनुभव किया उसके हिसाब से एक वर्ड ऑफ कॉशन है हमारे सभी जो स्टेक होल्डर्स हैं इसमें हैं क्रिमिनल जस्टिस डिलीवरी सिस्टम में, कि जैसे कन्विक्शन इन एब्सेंसिया किया जा सकता है, वैसे ही सर्टेन इन्फ्लुएंशियल और शातिर जो प्रोक्लेम्ड ऑफेंडर्स हैं वो एक्विटल इन एब्सेंसिया भी पा सकेंगे अगर हमारा सिस्टम बहुत अलर्ट नहीं रहा। इसलिए ये इशू मैं फ्लैग करना चाहूँगा इस फोरम के माध्यम से। और इसमें मैं याद दिलाना चाहूँगा कि कुछ बहुत ही अच्छे इनेबलिंग प्रोविज़न हमारे एक्ट 25 ऑफ ईयर 2005 के माध्यम से, जो 23 जून 2006 से लागू हुए थे, वो लागू होने के बावजूद हम उसका फ़ायदा नहीं उठा पाए, जो फरार रहने की प्रवृत्ति को कर्व करने के लिए लाए गए थे। 23 जून 2006 से लागू थे और वो यहाँ भी आए हैं। सेक्शन 174A इंडियन पिनल कोड, जो यहाँ थोड़े से संशोधन के बाद 209 BNS के रूप में आ गया है, उसका तो कुछ राज्यों में प्रयोग हुआ भी, हाई कोर्ट्स, इलाहाबाद हाई कोर्ट्स, दिल्ली हाई कोर्ट और चंडीगढ़ हाई कोर्ट के जुरिडिक्शन में प्रयोग भी हुआ। और बहुत ही मेजर केस लॉज आए, संजय सरीन वर्सेस यूटी ऑफ चंडीगढ़, इकबाल वर्सेस यूपी, मोती सिंह सिकरवार वर्सेस यूपी, कृष्णा रेड्डी वर्सेस CBI, दिल्ली हाई कोर्ट, इस तरह के। लेकिन इनके अलावा हमारा बाकी पूरे देश में इनका यूज़ नहीं हुआ है। और एक और उतना ही अच्छा आया था बेल जंप वाला 229A, जो कोर्ट को करना था। इतने लगभग 2000 जुडिशल ऑफिसर्स को हम लोग इस बीच में इसमें कर चुके हैं ट्रेन, उनमें से एक भी ऑफिसर नहीं मिले जिन्होंने बताया हो कि उन्होंने खुद या उनके किसी परिचित ने उन्होंने सुना है कि उसका कभी इस्तेमाल हुआ। ये टू कर्ब द टेंडेंसी टू इवेड अरेस्ट एंड ट्रायल, ये चीज़ थी। तो 229A 269 BNS के रूप में आ गया है और 174A यहाँ 209 के रूप में आ गया है। और 174A के साथ एक कंट्रोवर्सी क्रिएट कर दी गई थी, जो सेक्शन 195 सबसेक्शन 1 CRPC के माध्यम से, कि भाई कि इसके अंदर आएगा इसलिए ये कॉग्निजेबल ऑफेंस के रूप में ऐसे ट्रीट नहीं होगा। लेकिन वो कंट्रोवर्सी इस नए कानून ने पूरी हमेशा के लिए सेटल कर दी है। उन्होंने न सिर्फ 209 को यहाँ टच किया, उसमें कम्युनिटी सर्विस वाला एक एडिशनल डाला है फर्स्ट पार्ट के लिए। उन्होंने सेक्शन 215 BNSS, which is corresponding section to 195 of CRPC, they have clearly mentioned that excluding section 209 of भारतीय न्याय संहिता। तो अब हमें किसी तरह कन्फ्यूजन की गुंजाइश नहीं रही है। अब हम लोगों को ये कॉग्निजेबल ऑफेंस है। तो 209 और 269 जो सेक्शंस हैं बेल जंप के, 269 कोर्ट के वहाँ से शुरू होंगे और ये नॉन अपीयरेंस प्रोक्लेमेशन का डिफाइंस है। तो इन पे हमें कार्रवाई करनी होगी, FIRs दर्ज करने होंगे और उसमें कई केस लॉज हैं। समय कम है तो उसके बारे में डिटेल बात नहीं करना है। उन केस लॉज में ऑप्शन सारे हैं। फ्रेश FIR आपको करनी है 209 में, या उसी चालान में ही उसमें ही सप्लीमेंट्री चार्ज जोड़ के आगे बढ़ा देना है। वो सारी तरह के केस लॉज हैं, ऑनरेबल दिल्ली हाई कोर्ट से लेके ऑनरेबल चंडीगढ़ हाई कोर्ट और ऑनरेबल इलाहाबाद हाई कोर्ट की। तो मुझे बस यही हाईलाइट करना था कि कहीं ट्रायल इन एब्सेंसिया का फ़ायदा हमसे पहले कि ट्रायल कन्विक्शन इन एब्सेंसिया के बजाय वो एक्विटल इन एब्सेंसिया लेके न चले जाएं और हम जब तक जागें। और हम 12 साल में हमने बहुत अच्छा इस्तेमाल नहीं किया उन कानूनों का, 23 जून 2006 से लागू हैं। ये मैं फ्लैग करना चाहता था। थैंक यू सर। जय हिंद सर।
I think you might as well pass that one. Thank you, Anil. Now hand over to Viplab Kumar Chaudhary, Joint Director CBI. I'm very happy to note that he has, as part of his mandate, provisions helpful to the IOs in investigation. As I said, we have to look at the entire gamut of the new laws positively. The other issues he will be handling is decriminalization of 377 and the audio-video recordings of such provisions, which we've already mentioned. The floor is all yours, Vikram.
Thank you, sir. Sir, it has been less than 3 months since the new criminal laws have come into effect, and I am little positive. Positive in the sense that, based on our experiences so far, we can safely say that the challenges in implementation of the new laws, so far as investigation is concerned, have been far too less than what had been anticipated. Transition has been quite smooth, at least in the organization I come from.
Even as far as we are concerned.
Sure. Some of the provisions of the new laws have in fact been quite helpful in police investigations. For instance, provision contained in section 187 of BNSS, which provides that after arrest, police custody of an accused can be taken for a maximum period of 15 days in the whole or in parts at any time during the initial 40 days or 60 days out of the detention period of 60 days or 90 days, as the case may be. In case of central agencies or even in state CBCIDs, case will come to, let's say, CBI or to NIA or to, let's say, state CID also, after about 2 months, 3 months, 4 months, maybe after a long gap. So the initial 15 days already lost, and when the case will come to us after 15 days, then the advantage of custodial interrogation is lost. So by providing this provision, probably we have got some advantage. Secondly, provisions contained in section 193 of BNSS, which provides that on completion of investigation, police report along with other documents can be given to the accused by electronic communication also. Again, this is in cases that we handle in CBI particularly, a lot of documents are there. Sometimes the number of accused is also very large. So it becomes a problem to provide them all the documents, the police report in physical form, in hard copy. Now it is very easy for us to give it to them in a simple pen drive.
Only if he agrees to take it in electronic form. You can't force it on him. Kindly check this.
No, you can.
You can't force it on him. Only
No, he can't demand that it is to be given in the document form only. Because the law is very clear that if you provide it in the electronic form, it will be considered as duly served. But he can't say no,
It
sir.
doesn't necessarily mean that you have the authority to give it, because the person can be quite poor on the other side and he says, मैं print out कहाँ से निकालता रहूँगा? I require so this is an interpretation.
फिर वो कोर्ट का भी तो रहेगा ना सर रोल. I think the court will have court का रोल रहेगा.
नहीं, court का रोल नहीं था, because अब इसमें clear हो गया कि the IU has to provide all the copies.
नहीं, but through the court only, not directly.
Through the court.
Through the court only.
मतलब it's not necessary कि हो जाएगा, it's a matter of.
जो लैंग्वेज है सर, उसके हिसाब से तो can even be provided. So it is of course not necessary that you provide everything in physical. But then generally they have been accepting it.
कभी कोई objection आएगा तो case बन जाएगा.
वो भी है सर. अब नई चीज़ें आई हैं, जुडिशियल इंटरवेंशंस होंगे एंड देन एक अगला प्रोविजन है सर, विच इज़ कंटेंड इन 187 ऑफ BNSS, विच प्रोवाइड दैट एन एक्यूज्ड कैन बी प्रोड्यूस्ड बिफोर a magistrate for extension of judicial custody even by audio video electronic means. Again, पहले हम लोग जब ले जाते थे इन्वेस्टिगेशन के दौरान तो इतने सारे लोग लगाने पड़ते थे, so that problem will be sorted out then. So having said that, I must also point out that there are some gaps, some issues, though not very serious but significant enough, warranting our attention and needs to be addressed. A case in point is absence of provisions in BNS corresponding to section 377 of IPC which criminalized and provided punishment for unnatural sex with any man, woman, or animal. This section has been discussed in the previous session also, but just to briefly touch upon. Honorable Supreme Court in the 2018 case Navtesh Singh Johar versus Union of India read down section 377 of IPC and decriminalized consensual sexual relationship between consenting adults, whether between same-sex individuals or otherwise. After the said judgment, section 377 of IPC continued to apply to non-consensual unnatural sexual acts for acts like sodomy and bestiality. The recently enacted BNS prescribes punishment for non-consensual unnatural sexual acts by a man with a woman. Also, there are penal provisions in POCSO Act, which is gender neutral, for non-consensual unnatural sexual acts with a child. But in the absence of any provisions corresponding to section 377 of IPC in the BNS, at present, there is no remedy under law for non-consensual unnatural sexual acts by a man or by a transgender person with a man or a transgender person above 18 years of age. So that's an area of concern. I am, however, sure that with time, by judicial interventions as well as by legislative enactments and executive orders, such gaps would be quickly filled. One major issue related to investigation, which is being faced at this early stage of implementation of the new criminal laws, is related to the provisions contained in section 185 of BNSS. We talked about this provision earlier also, in the previous session also. This section makes it compulsory to record search proceedings during investigation through audio, video, electronic means. This section further stipulates that recording of search be conducted preferably by mobile phone. My take is that instead of use of the word including, that is to say that probably we could have used word including instead of preferably. So that is to say that recording of search be conducted through audio, video, electronic means including mobile phones. Instead of saying recording of search be conducted through audio, video, electronic means preferably by mobile phone. So probably that would have been better. Nevertheless, recording of such proceedings by mobile phone or by any audio, video, electronic means such as by a video camera in searches, which sometimes continue for long hours. In case of CBI cases, sometimes we conduct searches for 10 hours, 15 hours, 20 hours, days together. So that becomes sometimes very quite challenging, because you have issues such as discharge of camera, discharge of mobile phone, battery discharge. Even video camera will also not function for such a long time. There are issues related to storage capacity of the mobile phone or the video camera also. But I am sure again that with time we will develop adequate infrastructure for videography of such proceedings, and we will overcome this issue also. Thank you.
Now may I request my friend Ashish Chaudhary from the NIA, who's an IG in the NIA, to talk to us about UAPA and BNS, because as you all know that anti-national elements raise their head every few days, and Ashish is one of the people handling that part of protecting national security. All yours, Ashish.
Thank you so much, sir. First of all, I think the benefits that are going to arise out of these new laws and the related changes in the criminal jurisprudence is being well appreciated everywhere. Being one of the key stakeholders, the police, there was definitely initial hiccups, there was certain hesitation, but as we all know, no major change can be had without any hesitation. So the larger and the bigger the change, there's more resistance to it. But what is heartening is that the way these laws have been drafted and enacted, there is very less which needs to be modified and addressed to. When we were having these closed group discussions on this topic with regard to the changes and the difficulties which are being faced by the law enforcement agencies, I would say that there were not many difficulties and issues which require a larger intervention. So So these are small little interventions which may be, from executive orders, maybe some certain SOPs, these can be addressed. Yes, there were certain issues which we cannot, as on date, say that they have been resolved. Our issues with regard to, number one, the searches, as has been mentioned. Not only the searches in large number of locations when the searches are being conducted, and especially when they are protected in time, these issues will come up. Another thing which probably 105 may have missed is the chance recovery. So if I'm a policeman on the ground and I see something happening in which I have to seize certain material, let's say I see somebody carrying drugs or illegal arms, what do I do there? Do I start recording it? Do I secure the person? Do I first secure the contraband or the illegal stuff? And if at all I have to do, how can I do it? I don't have too many hands. So, and will this act of mine, become a reason for the person to get away? But I'm sure all these will be taken care of in the suggestions. And as has already been mentioned by Sir, the highest formations of the government and the stakeholders that we are already seized of these matters, and a very high level committee is going to look into all these, and certainly all these problems are going to be addressed to. One thing which I wanted to highlight over here is, as you all know, and probably the students of law which I can see over here would have been exposed to, the terror law of this country, the UAPA, is a special law which was enacted because the IPC, which was the major criminal law, did not have specific sections and offences with regard to terrorism. Now, under section 113 of BNS, this terrorism has also been made an offence in the criminal law, which is a very, very welcome sign. But what is required to be seen is that UAP is not only a penal law, it is also a procedural law. It lays down a lot of procedures with regard to how the UAPA has to be, implemented. What are the rights and, overarching liabilities, I would say, with regard to the accused. There are certain provisions which empower the law enforcement agencies in terms of more number of days for police custody, the larger detention period. The provisions of bail are a little stringent as compared to the normal law. So all these have to be also, somehow linked to the section of 113, the offence which has now been incorporated into the main criminal law. Because if there are same offence, two different laws, two different statutes, it may invite unnecessary litigation and maybe even challenge on the constitutionality. But I'm sure this has also been highlighted, and this shall also be taken care of in the due course. And obviously we have the issue with regard to the admissibility and the certificates of 63A and B. The definition of expert, as has already been dwelled in detail in the earlier session, this needs to be also taken care of, sir. That is all from my part. Thank you so much.
May I now request our esteemed senior, Shri DC Jain Saab. He's touching upon three very important aspects. One is the question of how the courts are handling the post and pre-1st July 2024 situation. Then the prosecution vertical, which will be the backbone of the entire investigation, and then later taking it to the courts. And of course, the question of exempted categories, which may lead to further confusion. So I hand it over to you, sir.
Thank you, Harmit. Before I begin, We must acknowledge the presence of Director Prosecution CBI Dr. Padmini Singh. On our request, is here. So thank you, ma'am, for accepting our request. To respond to the question, there are a couple of, I think again, no law is perfect. We all know Dr. Ambedkar, like after making the constitution, the remarks, I think he said no law is perfect. Only the people who administer the law makes it perfect or imperfect. So a lot will depend upon the people who are going to implement the new criminal laws. So obviously in any bare act, you can't find answers to all questions because they are subjected to multiple interpretations. And I think these new criminal laws are no different. We need to appreciate 1860 IPC. Even today, the high courts and the Supreme Courts, they are giving different interpretations. Even today, in fact, we have to go to the court and seek clarification. It means there was some clarity lacking in even in those laws. So these laws have just like, they are not even old by 3 months. Coming to the issues that I need to point out, again, interpretations in section 20 of the BNSS, like it was introduced in the opening remarks also, like in order to strengthen the prosecution, they want the state government to set up directorate of prosecution at each district level, district headquarters. Now they have also defined the powers and functions of the 3 officers of the prosecution, that is the Director of Prosecution, Deputy Director of Prosecution and the Assistant Director of Prosecution. Interestingly, in case of the Deputy Director of Prosecution, they say one of his functions would be to examine and scrutinize the police report. Now this can also be subjected to different interpretations. We already have a notification issued by the Union Territory of Jammu and Kashmir on this. What do we mean by police report? Whether the investigation report before it is filed in the court under section 193 or after that. So the Jammu and Kashmir notification, those who have looked at it, it says after the police report has been filed in the court, then the Deputy Director of Prosecution will examine and scrutiny. But I wonder, once you have already submitted your report in the court, thereafter what kind of examination or scrutiny the Deputy Director can do? Because it becomes now a court matter. So I think these things need to be, but fortunately the same section gives the powers to the state to kind of, issue clarifications and notify any more powers and functions of these 3 functionaries. So I think this gap needs to be filled and this clarification need to be issued. Now this next thing, the changes made in section 179 BNSS, when we compare it to the corresponding section 160 of CRPC, are very, very important for the police officers in the field. What it is, as we know, section 160 of CRPC empowers us to summon a person for examination at the police station. There are certain exempted categories you can't call to the police station. We all know, women of any age, an elderly person 65 years and above, a male child below 15 years, and the 4th category is people who are mentally and physically challenged or disabled. What changes have been made in corresponding section 179? The age of the male person has been reduced from 65 to 60 years, and they've added one more category, persons with acute illness. Now this thing has again not been defined in 179 whom you will treat as the person suffering from acute illness, but what is important is the new proviso that has been added in section 179. What it is, that if any one of these exempted categories of people make a request to the police officer that you don't come to us, we want to attend the examination at the police station, then the police officer will be able to do so. Now I see here certain practical issues in the sense that may put them into trouble in the future. How do you implement it? Whether the person makes an oral request, you also permit orally, and if it happens to be particularly a child or a female who is made to visit to the police station for the purpose of examination, tomorrow if they make a complaint that no, we were forced to attend at the police station, that what defense you have? Why I am saying so? Because we must all know, if the police examines any person at the police station in violation of the direction of law, it is a cognizable offense. Not many people know that. Section 166A of IPC and the corresponding section in the BNS is 199. Incidentally, no protection under section 197 for this offense.
because it is exempted from 197. Again, the corresponding new section is 218 BNSS. So we have to be careful. We must insist, if any one of these exempted categories of persons makes a request to the police officer that I want to attend the examination at the police station, my advice would be, please seek in writing. You must have the evidence on record that the request came to me in writing, and you must also permit in writing. So that tomorrow if anyone tries to drag you into any kind of controversy or problem, because you have the defense with you, because of this problem, that violation is a cognizable offense. That is one. Then, there is a provision 193 of BNSS. The corresponding section is 173 of CRPC pertaining to filing of police report in the court. Further investigation. Power of police to continue further investigation even after filing charge sheet. There is a change. No, again, a proviso has been added where they say, if you want to continue further investigation during trial, then you require permission of the court. This was not there in the CRPC. So what do you mean by during trial? Moreover, there are a couple of questions that need to be clarified by the police leadership, in the sense that when I file a charge sheet under section 193(9), and while filing the charge sheet, I keep further investigation continued. And if I am not able to complete this further investigation and the trial begins, whether I require permission of the court in this case, or after having filed a complete charge sheet, if I think because of whatever reasons that I need to now do further investigation but the trial has begun, is it in this case that I need to obtain permission of the court? I think these are the issues that need to be clarified. Last, applicability of BNSS versus CRPC. We all know when you read this section 531 subsection 2, one thing is, it says those proceedings which are pending, whether it is investigation, whether it is trial, whether it is appeal, and it also includes any application, they will be continued to be governed by CRPC as if this BNSS did not come into existence. But if we read, there are already different verdicts of different high courts on this. Say for example, Delhi High Court in one case says this particular FIR was registered much before 1st of July 2024. Now, during the pendency of investigation, the accused person moves an application for anticipatory bail in the High Court. Now, High Court judge say this should have been moved under BNSS because it is a new application. It is not a pending application. So, but the investigation began before 1st of July 2024. This application has arisen out of that investigation which is pending much before 1st of July 2024. Similarly, in another judgment of the Punjab under Haryana High Court, where a person had filed a revision petition in a matter much before 1st of July 2024, but along with an application for condonation of delay. So what the judge does, first he decides the application for condonation of delay, that is allowed. Now the judge says, since I have allowed this application today, therefore, the revisional application or the petition has to be filed under the BNSS. I will not consider what was filed earlier under the CRPC. But in the same High Court, very recently, few days back, another judge doesn't agree with this interpretation of the earlier judge, and now this matter has now been referred to the Chief Justice for constitution of a larger bench. Look at the Rajasthan High Court, what they say, Rajasthan High Court, that no, as far as the previous matters are concerned, whatever may be the stage, whether it is investigation, then it moves on to the trial, then moves on to the appeal, all the subsequent stages will also continue to be governed by CRPC. So there is continuity, there is not confusion, otherwise the judges as well as the advocates in the same matter, somewhere they'll have to refer to the CRPC, somewhere they'll have to refer to the BNSS. So why to create so much confusion? Let us deal with old matters under the CRPC and the new matters which will arise after 1st of July 2024 under the BNSS. So as you can see, different high courts have already been interpreting these things, I think, differently. So either the central government may consider issuing clarification or make rules, or it is the state leadership who looks at these pending issues. So I think, as I said in the morning also, A lot will depend upon how the state and the police leadership handles these issues or concerns arising out of the interpretations of the new criminal laws. Thank you.
Thank you, sir. I think we can now open the floor for questions. Please.
May I, sir?
बिल्कुल.
ये पूरा सुनने से लगता है कि this whole thing, new law, is in a stage of draft, and there will be amendments. Am I correct? Number one. And if there is any amendment, it will go to the parliament again. So is that going to happen?
No, it depends. You see, पहली बात तो these are laws, these are not drafts. है ना? They have been enacted by the parliament. They have become codes. Gazette notifications issued. They have acquired the status of a law of the land. As far as amendments are concerned, amendments can always, like in a criminal law, because it is a subject matter of concurrent list. So both the states as well as the union have powers to amend these laws, depending upon their requirement, their powers, etc. Okay. So even the state governments can make state-specific amendments. In the earlier laws also, there were many amendments done by the respective states. So here also, there is no legal bar by the state to amend it. As far as the union government is concerned, they are also, I think, within their powers either to amend or issue clarifications to the rules, as has been discussed. So I think, as Harmeet was saying, only on 13th and 14th of this month, there was a high-level conference in the Intelligence Bureau, which was attended to by the highest formations. So they are now, I think, gathering. They have requested all the stakeholders to kind of consolidate and get back to them, and then perhaps they will take a call.
So it will not go back to the parliament?
No, for amendment, they have to go back to the
अभी जैसे इन्होंने कहा that courts are still interpreting the old laws. So law is always a ruling, a rule, an interpretation, a clarification, and then if need be an amendment. So it's a process. आप डायरेक्टर प्रोसिक्यूशन से इसके बारे में चाय पे चर्चा कर सकते हैं.
My question is, what happened to that section 304A of IPC, which was there in the BNS, which has been shelved? Generally, an act should be shelved by the Act of Parliament only, but it has been done by an executive order of Secretary or I think MHA. I would like to know about that. And as of now, I think 304A IPC cases are registered under 304A IPC only now, because the new act things have been shelved. It came in papers and what is the situation? I don't know.
Confusion is there, sir. Let us be very clear about it. 304A IPC makes the act of death due to rash and negligent act an offence. What has been changed? There is a corresponding section in the BNS, that is 106 BNS. There are two subsections, 1 and 2. 1 is very clear. It is the one which is corresponding to 304A, जो कहता है कि अगर आपने accidental death किसी की कर दी तो change क्या हुआ है? Definition stays the same. Punishment has been increased from 2 years to 5 years. पहले यह था कि maximum punishment 2 साल हो सकता था, अब वो 5 साल तक उन्होंने कर दिया है. उसमें एक exempted category रखी है जो death due to medical negligence, डॉक्टरों के केस में, that will still attract the maximum 2 years punishment. ये हो गया 1061. 1062 में now they have added a kind of new offence we can say, जो hit and run accident cases की आप बात कर रहे हैं, कि अगर वो व्यक्ति डेथ करके रिपोर्ट नहीं करता, इन्फॉर्म नहीं करता और भाग जाता है, hit and run, तो in that case the maximum punishment can go up to 10 years. तो इसको लेकर के हल्ला हुआ था कि ये बहुत ज़्यादा ड्रैकोनियन हो गया है, बहुत ज़्यादा हो गया है. कुछ स्ट्राइक वाली बात भी हुई थी, कुछ हुई भी थी ट्रांसपोर्टर्स की स्ट्राइक. सर, लॉ के प्रोसेस में क्या होता है, एक बार जब लॉ पास हो जाता है, प्रेसिडेंशियल असेंट मिल जाती है, तो ये सेंट्रल गवर्नमेंट का प्रेरोगेटिव है कि वो उसमें से किसी भी पार्ट को रोक सकता है. जब तक वो गजट नोटिफिकेशन नहीं करेगा तब तक वो लो इट विल नॉट कम इनटू इफेक्ट, बिकॉज क्या लिखा रहता है, इट विल कम इनटू इफेक्ट फ्रॉम द डेट विच द गवर्नमेंट ऑफ इंडिया शैल नोटिफाई. तो दैट डेट इज डिसाइडेड बाय द गवर्नमेंट ऑफ इंडिया थ्रू अ गजट नोटिफिकेशन. इस केस में इन्होंने क्या किया, 1061 को तो नोटिफाई कर दिया, 1062 का नोटिफिकेशन विदहोल्ड कर लिया. तो दैट हैज़ नॉट कम इन टू इफेक्ट. तो आज की तारीख में इवन अगर हिट एंड रन के डेथ केसेस रिपोर्ट होंगे तो 1061 में ही किए जाएंगे, 1062 अभी अप्लाई नहीं होगा.
We'll take another couple of questions. Then we need to wrap up.
May I, sir?
I think the gentleman at the back was first. Can we allow him?
Yeah, thank you. My name is Valay Singh. I work with the India Justice Report. So I would first like to thank IPF for giving us this opportunity, and also the two panelists, the two panels. My question is very simple, and it's also a long-standing question which all government officers are aware of. Is this also not critically linked to the capacity, the implementation? So that's one question. Do you think that we are with just 19 lakh actual policemen in service, do we have the capacity to do justice to the expectations that are there in the new acts? That's one. The second is that what happens if the judge actually adjourns and does 3 hearings? Or if the police officer, as Mr. Chaudhary was saying, is not able to record, make a video recording. So what is the accountability for that? These are my 2 questions.
On your first question, I have a simple reply: yes. We are absolutely capable. Capacities have been brought up. On your first question, it's an unequivocal yes. Capacities have been brought up, capacities are being brought up, and 19 lakh is a very large number. So yes, we are absolutely capable of handling it. The technical part Anil will handle.
Thank you, sir.
Police to population ratio in the world. That's we chai pe charcha mere bhai.
This, if any public servant disobeys direction under law, that as sir mentioned already, that is a cognizable offence under section 199 BNS. निर्भया केस के बाद में जोड़ा गया था, 3 फरवरी 2013 से लागू था, 166A IPC था, वो पूरा का पूरा रिप्रोड्यूस्ड हो गया है 199 BNS के रूप में. तो कोई भी पब्लिक सर्वेंट है जो क्लियर कट डायरेक्शन है अंडर लॉ, डिसोबेइंग डायरेक्शन अंडर लॉ नोइंगली, तो उसके हिसाब से उसमें उनके खिलाफ मुकदमा भी दर्ज किया जा सकता है. और इसमें टर्म यूज हुआ है पब्लिक सर्वेंट. इसमें यहाँ ये नहीं लिखा है कि सिर्फ पुलिस ही रेस्पॉन्सिबल हो सकती है. तो वो जो इस तरह की चीज़ें कहीं आएंगी तो इसमें इस तरह के कानून ये प्रोविजंस में कवर हो जाएंगे. थैंक यू.
I think we can wrap the session. Yeah, sure.
About capacity building, I'd also like to add that it was not just teaching the law, but it was also about teaching about our police personnel, the technical gap that they had to teach them how to do photography, picking up digital evidence, to make hashtag values. So they were all also made to learn how to create hashtags. So I think there is a lot of learning which we have given to our staff. Of course, the people who will be actually going onto the field and doing the videography, photography, they will take some time to learn. They will learn from their mistakes, like the law evolves over time. Even our judges and our lawyers will also then guide us as to where we are making a mistake. But I think that's part of the ongoing learning. But as far as the critical input about telling them what, where and all, and the supporting infrastructure coming up, we will, I think, come up to their expectation.
So we've really overshot the time, so I'm sorry. We'll have to close the questions here and go on for the tea and then the last session. So further questions? Sorry, sir. Sir would like to finish it now?
Yes.
And then have tea, absolutely, sir. So for the closing remarks, we maybe request Shri Sudhir Pratap Singh. Sir. Achha, there are no free lunches, so we are going to get mementos.
May I request the may I request Mr. Ramanujam to come up to the stage? And who were the other panelists? They have all
I think all others
run away.
seem to have left because of my panel. Other
In
than
fact, in
Ramanujam
the
sir.
last session, we forgot to give the mementos. So we will give you 2.
Anyway, we'll send it to those who are not here. We'll send it, sir, to those who are not
Yeah,
here.
yeah. So please, so you can.
I'll give it.
Yeah, please do. You need not leave right now.
Sir, we'd like you to also join the photo, please.
Yes. Come, sir. For the photo.
Former boss.
So let us have a photo.
सर अपने सीईओ को छोड़ दिया आपने I said, you remember that day I was driving and you were sitting there? Sir, मेरा नहीं आप
Thank you so much. Thank you. So I was wondering how come you are bringing such very impressive books.
So he's written it.
Excellent. Thanks a lot. Thank you.
The stage is all yours.
Sorry, sir, for the delay.
So now I request Mr. Sudhir Pratap Singh. Mr. Sudhir Pratap Singh is a member of the Indian Police Foundation's Executive Board and is also the treasurer of the Police Foundation. I would request him to sum up discussions and also say the word of thanks. Thank you.
Thank you, sir. And thank you to the distinguished audience and members who have come for this function today. I wanted to thank all of you for bearing with us for this delay also. And this last vote of thanks thing is not very interesting for people because everybody would be wanting to leave. And I would like to sum it up in a few words. The good things which were said about the new laws which have been enacted was far much more than its minuses. So I feel it is the new laws, there was a lot of apprehension about the new laws, and even within the Indian Police Foundation there was a lot of apprehension that these new laws will be creating more problems than probably would be a way ahead. But I think after what I have been hearing for the whole day, the new laws is definitely a distinct welcome. It's a law which reflects the priorities of a democratic society. And there are a large number of points which have been flagged by the chief guest and the panelists and the members, and I don't think so it is worth really repeating all those points again. I would definitely like to say that the enactment of the new laws depends upon the police leadership. How well is the police leadership open to implementing these laws? Because all these new laws depend more on how the laws are implemented. So implementation is the key to the success of the new laws. And a lot of discretion is there in implementing these new laws. So we have to be very careful while implementing and while instructions are being issued at the state level. But nevertheless, I would like to thank the Ministry of Home Affairs, which has implemented, it's a welcome change. The new laws are a welcome change to the country because we have been decolonized, as people say. And I would like to thank all the stakeholders in this regard. I would also like to thank the Indian Police Foundation, which took the initiative of, as soon as within 3 months we have come up with something like this, which set the ball rolling about, set the process. People have started thinking about these new laws and the problems, the plus, the minuses, the good and the bad. So on behalf of the Indian Police Foundation, I would like to thank each one of you, each one of the participants, each one of the speakers, the chief guests, and all the people who are associated, the India International Center. And thank you very much, and Jai Hind. Thank you.
Yeah. So thank you very much for your patient listening of the entire proceedings of today. It was a very useful and productive session. Thank you very much, and everyone is invited to a cup of tea outside. Thank you. Thank you. All the best. Bye.
Thank you, sir.
Yeah.
Thank you very much for us.